Then provided for the
Sir, your attention, please. First, adjournment request to BC memos or
ಕೇಳಿಲ್ರಪ್ಪ ಆಡಿಬಲ್ ಏನಿಲ್ಲ.
Court officer,
Sir, ಹೇಳಿ sir.
any adjournment on VC is permitted, court officer?
Yes, sir. First submissions with regard to adjournments will be through VC only,
All
then
right.
followed by memos here personally. Then any request with regard to adjournments here in person.
Thank you, court officer.
ಆರ್ಡರ್ಸು ಮೂವ್ ಮಾಡ್ಬೋದಾ ಕೋರ್ಟ್ ಆಫೀಸರ್?
ಮಾಡಿ ಆರ್ಡರ್ಸ್ ಮಾಡಂಗಿಲ್ಲ ಸರ್, ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಬೇಡಿ.
ಬಂದಾಗ ಮಾಡ್ಬೇಕು.
So this is a commercial complex. The purchaser of one of the units from the developer share has filed the case. We are the landlords. Nothing affects it. That's why I'm not bothered.
It is sir,
Just write up here. That's all.
Mentionings through video.
Serial
Memo.
number, my lord, serial
Yes.
number 131, my lords, in the day's list for final hearing.
Yes.
My lord, some inconvenience for the day I appear for the appellant, my lords. I am not keeping very good health. Any day next week to the convenience of the court, my lords, may I request?
The request of the learned counsel for the appellant who submits he is not keeping well. As finally a week's time as paid is granted. Yes.
I'm grateful.
Serial number 69 million for non-compliance ಅಂತಿದೆ ಆಗ್ಬೋದು ಕೇಳ್ಬೋದು.
Non-compliance ಎಲ್ಲದು mentioning ನಲ್ಲಿ ಬರೋಲ್ಲ. Matter reach ಆದಾಗ ಹೇಳಿ.
Please.
Yes.
Matter for admission,
Yes.
for partition,
Ah.
defendant appeal.
Ah.
Suit has been decreed. I am the purchaser of the property. Oh, an FDP has been filed.
Monday. Yes. Yes. Is any mentioning? Yes. 136. Yes. 130? Yes.
523 is no more. Is dead. I file a memo. Yes, I file a memo, my lord. Legal absolute, I will take it, my lord.
Yes, you can move the memo and the matter is called.
ಅದು ಡೆತ್ ಆಗಿದೆ.
ಹೌದು ರೀ, ಅದನ್ನ ಔಟ್ ಆಫ್ ಟರ್ನ್ ತಗೊಳ್ಳಿಕ್ಕೆ ಅರ್ಜೆನ್ಸಿ ಏನಿದೆ?
ಎಲ್ಲ
ಹೌದು, ರೀಚ್ ಆಗ್ತದೆ. ಇರಿ, ಲೇಟ್ ಆಗ್ತದೆ, ಸ್ವಲ್ಪ ಬೇರೆ ಕೋರ್ಟ್ಗಳು ಅಟೆಂಡ್ ಮಾಡಿ ಬನ್ನಿ, ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್ 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 we will see when the matter reaches. Yes, call the cases.
Non-compliance of its objections. Second time, Silver one, Narayan.
ಅಲ್ಲಿಗೆ ಮೇಲೆ ನಿಲ್ತಾರೆ. ಕೆಳಗಡೆ ಕೂತಿದೆ, ನಾನು ಚೇರ್ಗೆ ಕರ್ಕಿಸ್ತೀನಿ.
Serial number one, Narayana YVS.
This is time for the appellant. I pray for weeks time.
Rejected. Rejected.
I'm not able to get it.
2 years, 19 days. After the direction to file affidavit. 3 years, 9 months, 7 days after institution of the suit. Yes. No attempt was made to comply the office objection. Appeal to be paginated and indexed, provision of law for RFA to be correctly stated, PIN code to be stated, value of appeal to be stated. 4 years. Are we justified in rendering justice to the parties with this space for this kind of needfuls? Sorry won't cure remedy which injustice we are causing to the society. When a judicial direction was there more than 2 years back to file an affidavit, ಅದರಲ್ಲೂ ಎಲ್ಲ ಬರ್ಲಿ ನೋಡೋಣಂತೆ ಆಟಿಟ್ಯೂಡ್ ಇದ್ರೆ, ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಒಬ್ಬ ಲಾಯರ್ಗೆ ಟುವರ್ಡ್ಸ್ ದ ಕೋರ್ಟ್ ಆಟಿಟ್ಯೂಡ್ ಇದ್ರೆ ಏನಾಗ್ತದೆ? ವೇರ್ ವಿ ಆರ್ ಟೇಕಿಂಗ್ ಅವರ್ ಜುಡಿಷಿಯರಿ. A specific direction was given to you by the court. You have not compared the direction of the court. ವಕೀಲರೇ, ಮುಖ್ಯ ನಾನು ಪದೇ ಪದೇ ಹೇಳ್ತೇನೆ, ನಮ್ಮ ಆಟಿಟ್ಯೂಡ್ ಚೇಂಜ್ ಆಗ್ಬೇಕು. ನಾನ್ ಜಡ್ಜ್ ಏನ್ ಮಾಡಿದ್ರು ನಡೀತದೆ, ನಾನ್ ಲಾಯರ್ ಏನ್ ಮಾಡಿದ್ರು ನಡೀತದೆ, ಅದು ನಮ್ ಇಬ್ಬರಲ್ಲಿಯೂ ಹೋಗ್ಬೇಕು. Both of us are answerable to the society because of the paymasters who are the general public. We are surviving. ಅದು ಬಂದ್ರೆ ಎಲ್ಲದೂ ಆಗ್ತದೆ. 3 ನಿಮಿಷ, 4 ನಿಮಿಷ, 5 ನಿಮಿಷ, 10 ನಿಮಿಷದಲ್ಲಿ ಕಂಪ್ಲೇ ಆಗ್ತಕ್ಕಂಥ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಗೆ ಹಲವಾರು ವರ್ಷಗಳು ನಾವು ಎಳ್ಕೊಂಡು ಹೋಗ್ತೇವೆ. ನಮ್ಮ ಮಕ್ಕಳನ್ನ ಇಂಡಿಯನ್ ಲೀಗಲ್ ಎಜುಕೇಶನ್ ಬೇಡಪ್ಪ, ನೀನ್ ಅಬ್ರಾಡ್ ಹೋಗು, ಆಸ್ಟ್ರೇಲಿಯಾ ಹೋಗು, ಯುನೈಟೆಡ್ ಕಿಂಗ್ಡಮ್ ಹೋಗು, ಅಮೆರಿಕ ಹೋಗು, ಏನು ಸಿಗದವಾದ್ರೆ ನಮಿಬಿಯಾ, ನೈಜೀರಿಯಾ, ಸೊಮಾಲಿಯಾನಾದ್ರೂ ಹೋಗು, ಫಾರಿನ್ ನನ್ನ ಬೇಕು, ಇಂಡಿಯಾ ಬೇಡ. ನಾವೇ ಅಲ್ವೇ ಮಾಡ್ತಿರೋದು? ಪ್ರತಿ ದಿವಸ ಹೇಳ್ತಿದ್ದೇನೆ ನಾನು ಇದನ್ನ, ನಿಮಗೆ ಮಾತ್ರ ಅಲ್ಲ, ಯಾಕಂದ್ರೆ ನನಗಷ್ಟು ವ್ಯಥೆ ಆಗ್ತದೆ. ವೇರ್ ಅವರ್ ಕಂಟ್ರಿ ಇಸ್ ಹೆಡಿಂಗ್ ಅಂತ. ಒಂದು ವಾರ ಕೊಡ್ತೇನೆ ಮಾಡಿ. At the request of the learned counsel for the appellant as a final last opportunity, a week's time is granted to do needful and complete office objection, failing which the court may proceed to pass appropriate order. In case if the office objections and directions are not complied in full, registry to list the matter on 1/6. Yes.
Third time non-compliance number 2, let's S. Katan.
ಕೊಟ್ಟಿದ್ದಾರೆ. ಏನಾಗಿದೆ, ಅಪಲೆಂಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಗಿದೆ, ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪಲೆಂಟ್ ಆಗಿದೆ. ಅದರಿಂದ ಎನ್ಒಸಿ ವಕಾಲತ್ ನಾಟ್ ರಿಸೀವ್ಡ್ ಬೈ ದಿ ಕೌಂಟರ್. ಸೂಪರ್ ಪಾರ್ಟಿಷನ್ ಡಿಕ್ಲೇರ್ಸ್ ಡಿಸ್ಮಿಸ್ಡ್. ಸದಸ್ವತಿ ಅನ್ನೋದು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡ್ಬೇಕಾಯ್ತು, ಅದು ರೆಸ್ಪಾಂಡೆಂಟ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅವರು ರೆಸ್ಪಾಂಡೆಂಟ್ ಆಗ್ಬೇಕಾಯ್ತು, ಅದು ಅಪಲೆಂಟ್ ಆಗಿದೆ. ಅದರಿಂದ
ಮಾಡಿದ್ದು ಆಫೀಸ್ನವರ, ರಿಜಿಸ್ಟ್ರಿ ಅವರ
ಇಲ್ಲ, ಅದು ಅರ್ಲಿಯರ್ ಅಡ್ವೊಕೇಟ್
ಆಗ್ಲಿ. ನೀವು NOC ತಗೊಳ್ಬೇಕಾದ್ರೆ ನಿಮ್ಗೆಲ್ಲ ಏನೇನಾಗಿದೆ ಅನ್ನೋದು ನಿಮಗೆ ಗೊತ್ತಿದೆ.
ಇನ್ನ ಅಲ್ಲಿ ವಕಾಲತ್ ಎನ್ಒಸಿ ವಕಾಲತ್ ತಗೊಂತಾ ಇಲ್ಲ, ಅಲ್ಲಿ ನೇಮ್ ಟ್ಯಾಲಿ ಆಗಲ್ಲ ಅಂತೇಳಿ ಈಗ ನಮ್ಗೆ NOC ಕೊಟ್ಟಿದ್ದಾರೆ.
You have not yet filed NOC, then you have no standing to make any submission in the matter. Until you file a wakalat, you cannot make any submission, that too without the leave of the court. Undertaking to file wakalat does not entitle you to make any submission without the leave of the court.
Name was not tallied to the, so they are not taking any wakalat to the counter.
ಇದ್ರಲ್ಲಿ ಆಗ್ಬೇಕಾಗಿರೋದು ಹೇಗಿದೆ ಹಾಗೆ ಇನ್ನೊಂದು ಸೆಟ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಮುಗಿತಿತ್ತು ಕತೆ. ಇದ್ರದ್ದನ್ನೇ ಗ್ರೀನ್ ಶೀಟ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಜೆರಾಕ್ಸ್ ತೆಗೆದ್ನೋ ಅಥವಾ ಕಂಪ್ಯೂಟರ್ ಅಲ್ಲಿ ಇನ್ನೊಂದು ಪ್ರಿಂಟ್ ಔಟ್ ತೆಗೆದ ಸ್ಟಿಚ್ ಮಾಡಿ ಹಾಕಿ ಬಿಟ್ಟಿದ್ರೆ ಎಲ್ಲದೂ ಮುಗಿತಿತ್ತು. 4 ವರ್ಷ ಆಯ್ತು. ಇಲ್ಲದ ಹೆಚ್ಚಿನ ಕಾರಣ ಈಗ ಹೇಳ್ತಾ ಬರ್ತಾ ಇದ್ದೀನಿ.
ಈಗ NOC
learned counsel Sri Shailesh Katare is not absent. Learned counsel Sri so and so who says that he is filing a wakalat, no objection wakalat for the appellant, submits that because of predecessor's mistake he couldn't comply with this objection. Next line. Prima facie, the learned counsel who is appearing today has not filed wakalat for either of the parties in the matter. As such, he is not the counsel representing the appellant in the matter. Secondly, as could be seen from the cause list, the main objection that was required to be complied was filing of the second set of the copy in the matter, for which for more than 4 years the appellant has not evinced any interest. Sufficient time of not less than 3 times were also given to the appellant in the matter to do needful, despite which the appellant has not evinced any interest. Hence, I do not find any reason in granting further time. Accordingly, the appeal stands dismissed for non-prosecution.
Serial number 3, Divakara PS.
We have complied office objections. name of defendant number 8D by oversight has been crossed out in the last title of the judgment. But in the degree copy, it has been stated at page number 126. I also furnished this.
What submission you are making has got no relevance with the alleged outstanding office objection, which is yet to be complied with.
They have raised a fresh objection. We have complied on 27th. We time to comply any fresh.
At the request of the learned counsel for the appellant, as finally a week's time is granted to comply office objection, making it clear that in case its office objection is not complied within a week, the court may proceed to pass appropriate order in the matter. In case if the office objection is not complied, it can time list the matter on 2/6.
Serial number 4, Ram Mohan A.
Appellant, excuse me, Lord. 8/11/22. Had an application in the order 122, seeking deletion of several responses. It's a very old suit. So many people are there at the trial stage itself. The suits seem to have abated. So when we go in for all these, we come to know that when we to our sought the deletion of all those people. But the interesting point in this case, my lord, is the suit scheduled property belongs to BBMP. It's still BBMP officer has come and declared before the court, it is BBMP's property. The partition is being done. How a partition suit can be allowed? That is the only subject matter in this case. My lord. So I have sought for.
Probably I am mistaken. I am not here in this matter to hear on the merit of
I
the
know,
case,
I know.
but regarding the complaints of office objection.
Office objection, my lord, I have already complied with that. This application, whatever that I have heard on 8/11/22, should solve all the problems.
Yes, whether your application dated so and so gives the present age of the petitioner.
I'm sorry, my lord,
Office objections are like that.
but in the cost, I did not see any of those things, my lord. That is why I was.
ಸುಲಭವಾಗಿ ಪ್ರಾಮಾಣಿಕವಾಗಿ ಮಾಡ್ಲಿಲ್ಲ, ಕೆಲವೊಂದು ಮಾಡದಿದೆ ಮಾಡ್ತೇನೆ ಅನ್ನೋದಕ್ಕಿಂತಲೂ
I'm sorry, my lord, I will attend to the other aspect.
ಹೆಚ್ಚಿನ ಚತುರತೆ ತೋರಿ ಇನ್ನೊಂದು ವಿಷಯನ ಹೇಳಿ ಅದರಿಂದ ಇದಕ್ಕೆ ಉತ್ತರ ಸಿಗ್ತದೆ ಅಂತ ಹೇಳಿದ್ರೆ ಹೇಗೆ ವಕೀಲ?
I am sorry, my lord, ಆಗಿಲ್ಲ. This was the situation. I was under the impression my colleague has complied with all the objections.
ನಿಮ್ ಕಲಿಗೆ ಹೇಳಿ ಒಂದು ವಾರ ಕೊಟ್ಟಿರ್ತೇನೆ, ಮಾಡ್ಲಿ ಇಲ್ಲದವ್ರೆ ಡಿಸ್ಮಿಸ್.
Martin, sir, Martin.
Learned counsel, yes please.
Number 1, paid on 18/21, paid on number 2/2.
That will not be shown unless the matter would be ripened for first hearing. ಅಲ್ವೇ? ಹೌದ್ರಿ, ಸಿವಿಲ್ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್ ಒಮ್ಮೆ ನೋಡ್ರಿ. The counsel for the appellant and caveator are physically present. Considering the reasons shown by the learned counsel for the appellant as a final last opportunity, a week's time is granted to comply all office objection, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-prosecution of office objection. In case if the office objections are not complied with in photo registry, to list the matter on 2/6. Yes.
And overrule all these objections on the reason that the suit property belongs to BBMP, my lord. How the partition could be maintained, my lord. Only from that point of view, your lordship may so photo can take an.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಈ ಸ್ಟೇಜ್ ನಲ್ಲಿ ಓವರ್ ರೂಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಮೇಂಟೈನಬಿಲಿಟಿ ಗ್ರೌಂಡ್ ಮೇಲೆ ನಾವು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅನ್ನು ಓವರ್ ರೂಲ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನಿದೆ ಬಹಳ ಟ್ರಿವಿಯಲ್ ಇದೆ, ಬಹಳ ಸಣ್ಣದಿದೆ. ಈಗ ಓದಿ ಹೇಳಿದೆ ಅಲ್ವೇ, ಅವ್ರು ಏಜ್ ಕೊಟ್ಟಿಲ್ಲ, ಇವ್ರು ಡಿಸ್ಕ್ರಿಪ್ಷನ್ ಕರೆಕ್ಟ್ ಆಗಿ ಹೇಳಲಿಲ್ಲ, ಪ್ಲೇಂಟಿಫ್ ನಂಬರ್ 3 ಯಾವಾಗ ಸತ್ತೋದ ಅಂತ ಹೇಳಲಿಲ್ಲ, ಇಷ್ಟೇ ಇದೆ. ಅದಷ್ಟು ನೀವು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ರ ಮೇಲೆ ಆಮೇಲೆ ಫಸ್ಟ್ ಹಿಯರಿಂಗ್ ಮೆಚೂರ್ ಆಗ್ತದೆ, ಅವಾಗ ಮೇಂಟೈನಬಿಲಿಟಿ ನೋಡ್ಬೋದು. ಮೇಂಟೈನಬಿಲಿಟಿ ಈ ಸ್ಟೇಜ್ ನಲ್ಲಿ ನೋಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ.
Serial number 5, Balkrishna.
Counsel for the appellant neither present physically nor through video conference. The result of the opportunity would go to show that in spite of granting several and sufficient opportunities of not less than 3 times over in a span of 4 years, the appellant has not completed the office subsection. On 33/2021, this court had directed the learned counsel for the appellant to file an affidavit explaining the reasons for non-compliance with specific reference to the office subjection from the date of raising of office subjections till the expiry of the further time granted by the order passed on the said date. In spite of such a direction also, the appellant neither bothered to file, neither filed the affidavit as directed, nor even completed the office subjection. Till this court had granted some more time to him on 23/9/2022 to comply office subjection, despite which the appellant did not make use of the opportunities given to him to comply the office subjection and also to file affidavit as directed. A perusal of the office subjection yet to be completed also would go to show that there are 2 trivial office subjection, like filing separately the synopsis, correctly stating the valuation para in detail, and mentioning the specific share value of the plaintiff. To comply those small office subjection also, the appellant has not evinced interest despite he having a time of more than 4 years. Added to the above, the counsel also has remained absent and has not even shown the reason for non-compliance of office subjection. Hence, the appeal stands dismissed for non-prosecution as well as for non-compliance of office subjection.
Serial number 6, Joseph Anil Kumar A, connected.
Subjection suggestion board. Interim office subjection.
Monday.
1,000 rupees per day. If you are complying within a day, 500 rupees cost. If beyond 1 day, 1,000 rupees per day. I grant you time. Office subjection are very simple. 2 office subjection. Marking of annexure to be removed in appeal memorandum. Challenging impugned order number only to be stated in entire appeal memorandum.
I'll do it by the end of the
4 ವರ್ಷ.
It was.
ಅಂದ್ರೆ ನಿಮಗೆ ಏನ್ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ ಅಂತಲೇ ನೋಡಲ್ಲ. ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ ಬಂದಿದೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ, ಪ್ರೇ ಫಾರ್ ಎ ವೀಕ್ಸ್ ಟೈಮ್.
I'll do it by the end of the day.
The counsel for the appellant submits that office subjects should be complied in toto during the course of the day. If the office objections are not complied during the course of the day, registry to list the matter on 29/5, on which day the court may proceed to pass the order dismissing the appeal for non-compliance.
Till number 7, Devendra Gowda.
ಏನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮಾಡಿದಿರಿ? ಗೊತ್ತಿಲ್ಲ, ಸೀನಿಯರ್ ಹೇಳಿದ್ರು ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಗಿದೆ ಅಂತ ಬಂದ್ರು ಅಲ್ವೇ? ಇನ್ನೊಮ್ಮೆ ಬಂದು ಸೀನಿಯರ್ ಹಂಗೇನಾದ್ರು ಹೇಳಿದ್ರೆ ಸಾಹೇಬರು ಮುಂದಿನ ಕ್ವಶನ್ಗಳು ಕೇಳ್ತಾರೆ ಸರ್, ನನಗೆ ಗೊತ್ತಾಗ್ಬೇಕು ಅಂತ ಹೇಳಿ ಫೈಲ್ ನೋಡ್ಕೊಂಡು ಬನ್ನಿ. Counsel for the appellant is physically present and submits that in view of the evaluation made by the appellant, the matter lies before the division bench. Next line, simultaneously, the registry also has made a similar submission in the proceeding sheet. In the light of the above, the registry is permitted to place the matter, post the matter before the appropriate bench. However, after securing the necessary orders by the Honorable Chief Justice of this court, if required, the matter be listed before the appropriate bench on 1/6.
Till number 8, Synchronization Bhatt.
In the meantime, the appellant to comply the remaining of the subjection.
Till number 8, Synchronization Bhatt.
That counsel for the appellant neither present physically nor through video conference. No reasons are forthcoming for his non-appearance. The perusal of the order sheet would go to show that in this appeal of the year 2019, in spite of granting sufficient opportunities of not less than 3 times, including as final opportunity, the appellant has not complied the office objections. As long back as on 1/4/2021, this court had directed the appellant to file an affidavit explain the reasons for non-compliance of office objections. In spite of such a direction, no such affidavit appears to have been filed by the appellant. Further, even thereafter also on 12/8/2021, once again, 2 weeks time was granted to do needful as final opportunity. Thereafter also, the appellant did not evince any interest to comply the office objection for nearly 2 more years. A perusal of the office objections which are yet to be complied also go to show that they are too minor in their nature, like paginating and indexing the memorandum of appeal, dating the index and the synopsis, and stating the executant name in capital letters. For these small office objection also, the matter is languishing on the file from September 2019 to till date. Hence, I do not find any reason to further grant time. Accordingly, the appeal stands dismissed for non-prosecution as well as for non-compliance of office objection.
Till number 9, V. Anand.
The 2 objections are there.
Defendants appeal lordship. So suit for plaintiff filed the suit for declaration and rejection. Declaration reject ಮಾಡಿದ್ದಾರೆ. Rejection allow ಮಾಡಿದ್ದಾರೆ. I have to challenge the allow rejection. So sufficient court be pay ಮಾಡಿದ್ದೀವಿ.
ಅದನ್ನ ಇಷ್ಟು ವರ್ಷ ಹೇಳದೆ ಈಗ ಯಾಕೆ ಫಸ್ಟ್ ಟೈಮ್ ಹೇಳ್ತಾ ಇದ್ದೀರಿ?
ಅಷ್ಟೇ ಪೊಲೀಸ್ ಬಂದಿದ್ದೀವಿ.
I will find a detailed memo for valuation mentioning these aspects. You have not done that. Then I dismiss it. That is one of the objections.
Injunction ಮಾತ್ರ ನಾನು challenge
ಹೌದ್ರಿ, ಅದು ಅವರಿಗೆ ಕನಸು ಬೀಳಲ್ವೇ ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ? ನೀವು ನಿಮ್ಮ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಅಲ್ಲಿ ಹೇಳ್ಬೇಕಲ್ವೇ ಅದನ್ನ?
ಹೇಳಿದ್ದೀನಿ, ಫೈಲ್ ಮಾಡಿದ್ದೀನಿ, ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಫೈಲ್ ಮಾಡಿ.
ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ಫೈಲ್ ಮಾಡೋದಲ್ರಿ. ಈಗ ತಾವು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದೀರಿ? ವಾಟ್ ದ ಸೂಟ್ ವಾಸ್ ಫಾರ್. But what is challenged in this appeal? You are not challenging everything what was there in the plaint in this appeal. You are challenging only a portion of the prayer there. As such, proportionately, the court fee also stands altered. ಅದನ್ನ ನೀವು ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಸ್ಲಿಪ್ ನಲ್ಲಿ ಹೇಳಿದ್ದೀರಾ? ಹೇಳಿಲ್ಲ. ಅದಕ್ಕೋಸ್ಕರವೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಏನ್ ಹೇಳಿದೆ? ಡೀಟೇಲ್ ಮೆಮೊ ಫಾರ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಟು ಬಿ ಸ್ಟೇಟೆಡ್ ಇನ್ ಅಪೀಲ್ ಮೆಮೊರಾಂಡಮ್. ನೀವು ಅದನ್ನ ಮಾಡ್ಲಿ. ಹಾಗಾಗಿ 500 ರೂಪಾಯಿ ಒಂದು ದಿವಸ ಎಷ್ಟು ದಿವಸ ಬೇಕು ಕೇಳಿ.
Course of the day. Course of the day.
ಕೋರ್ಸ್ ಆಫ್ ದ ಡೇ ಮಾಡಿದ್ರು ಇನ್ನೊಂದು ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಎರಡನೇ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ವಿಚ್ ಈಸ್ ರಿಲೇಟೆಡ್ ಟು ದಿ ಫಸ್ಟ್ ಅಬ್ಜೆಕ್ಷನ್ ವಾಟ್ ಐ read now. If your submission is accepted, then the another objection doesn't sustain. ನೋಡಿ ನನ್ನ ಪರಿಸ್ಥಿತಿ ನೋಡಿ, ಪ್ರತಿಯೊಬ್ಬರು ವಕೀಲರಾದ್ರು ಹತ್ತು ಕರೆದು ನಾನು ಮಾಡಿಯಪ್ಪ ಹೀಗೆ ಮಾಡಿ ಹಾಗೆ ಮಾಡಿ ಹೆದರಿಸಿ ಕಾಸ್ಟ್ ಅನ್ನೋದನ್ನು ತೋರಿಸಿ ಎಲ್ಲದನ್ನು ಮಾಡಿ ನಾನು ಮಾಡಿಸ್ಬೇಕು, ಒಪ್ಪಿಸ್ಬೇಕು. ಎಂತಹ ದಯನೀಯ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ನಾನು ಕೂತಿದ್ದೇನೆ ನೋಡಿ. ಸಾವಿರಾರು ಕೇಸ್ಗಳು ಕೇವಲ ಕಾಂಪ್ಲೈನ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆ. ಕಳೆದ 4 ರೋಸ್ಟರ್ ನಲ್ಲಿ ಒಬ್ರು ನೋಡ್ಲಿಲ್ಲ. ಡೋಂಟ್ ಪೋಸ್ಟ್ ಅಂದ್ರು. ಅದೆಲ್ಲದು ಕೂತಿದೆ, ಈಗ ನಾನು ತಗೊಳ್ತಿದ್ದೇನೆ. ಸುಮಾರು 800 ಮ್ಯಾಟರ್ಗಳು ಇನ್ನೂ ಸ್ಕ್ರೂಟಿನಿನೇ ತಗೊಳ್ಳಿಲ್ಲ. ಅದನ್ನ ಯಾಕೆ ಮಾಡ್ತಿಲ್ಲ ಅಂತ ಅಲ್ಲಿ ನಾನು ಕೇಳ್ತಿದ್ದೇನೆ. ದೋ ಇಟ್ ಇಸ್ ನಾಟ್ ಮೈ ಡ್ಯೂಟಿ ಟು ಡೂ. ವೈ? Only in the interest that at least the litigants may have some further hope upon the judiciary. ನಾವು ತಿಳಿದಾಗಿಲ್ಲ, ನಾನು ನೀವು ಹುಡುಗರಿದ್ದಾಗೆಲ್ಲ ಜನ ಕೋರ್ಟ್ ಅಂತ ಹೇಳ್ಕೊಳ್ಳಿ ಏನ್ ಖುಷಿಯಿಂದ ಬರ್ತಿದ್ರು. ಪರಿಸ್ಥಿತಿ ಹಾಗಿಲ್ಲ. ಅನಿವಾರ್ಯ ಇದ್ರೆ ಮಾತ್ರ ಬರ್ತಾರೆ. ಈಗ ವಕೀಲರು ಇದ್ದಾರೆ, ಪಕ್ಕದಲ್ಲಿ ಒಬ್ಬ ಕಾರ್ಪೊರೇಟರ್ ಅಥವಾ ಇನ್ನೊಬ್ಬ ಯಾರೋ ಇನ್ಫ್ಲೂಯೆನ್ಷಿಯಲ್ ಪರ್ಸನ್ ಇದಾನೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಒಂದು ಸಮಸ್ಯೆ ಬಂದ್ರೆ ಈಗ ಜನ ವಕೀಲರ ಹತ್ರ ಬರ್ತಾ ಇಲ್ಲ. ಆ ಕಡೆ ಪಕ್ಕದ ಮನೆಗೆ ಹೋಗ್ತಿದ್ದಾರೆ. ಅಣ್ಣ ಏನಾದ್ರು ಸ್ವಲ್ಪ ಹೇಳೋಣ, ಕಾರ್ಪೊರೇಷನ್ ಆಫೀಸ್ಗೆ ಹಣ ಅವ್ರನ್ನ ಕರೆಸಿ ಒಂದು ಮಾತು ಹೇಳೋಣ, ಮಾಡಿಸಿಕೊಡೋಣ ಅಂತಾರೆ. ಅವನು ಆಗಲ್ಲ, ನನ್ ಕೈನಲ್ಲೂ ಆಗಲ್ಲ, ಇನ್ನೇನು ಆಗಲ್ಲ ಅಂತ ಹೇಳಿದಾಗ ಇನ್ನೇನ್ ಮಾಡೋದಣ್ಣ ಅಂದ್ರೆ ಹೋಗಪ್ಪ ಕೋರ್ಟಿಗೆ ಹೋಗು ಅಂತಾರೆ. ಅವಾಗ ನಿಮ್ ಎಡಗಡೆ ಮನೆಗೆ ಬರ್ತಾರೆ, ನಿಮ್ಮ ಹತ್ರ ಬರ್ತಾರೆ. ಪರಿಸ್ಥಿತಿ ಇವತ್ತು ಹಾಗಿದೆ. ನಾವು ಅರ್ಥಕೊಳ್ತಿಲ್ಲ ಹೆಚ್ಚು ಜನ. ಬಿಡು, LLB ಆಗಿದೆ, ಮೈ ಮೇಲೆ ಕೋರ್ಟ್ ಇದೆ, ಏನಾದ್ರೂ ನಡೀತದೆ. ಜನ ಮುಂಚಿನ ವಿಶ್ವಾಸ ನನ್ನ ಬಗ್ಗೆ ನಿಮ್ಮ ಬಗ್ಗೆ ಇಟ್ಕೊಳ್ತಾ ಇಲ್ಲ. ನಾನು ಇಲ್ಲಿದ್ದಾಗ ಮೈಲಾರ್ಡ್ ಹೈಕೋರ್ಟ್ ಕಾಂಪೌಂಡ್ ಹೋಗಿ ಒಬ್ಬ ಆಟೋದವನಿಗೆ ಬರ್ತೀಯನಯ್ಯ ಅಂದ್ರೆ ಇಲ್ಲ ಅಂತಾನೆ. ನಾನು ಯಾರು ಗೊತ್ತಾ, ಹೈಕೋರ್ಟ್ ಜಡ್ಜು, ನೀನ್ ಬಾ ಅಂತ ಹೇಳಿದ್ರೆ ನೀವು ದೇವರೇ ಆಗಿರ್ಲಿ ಹತ್ಬೇಡ್ರಿ, ಹೋಗ್ರಿ, ನನ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡ್ಬೇಡ್ರಿ ಅಂತ ಮೊಬೈಲ್ ನೋಡ್ತಾನೆ. ಒಬ್ಬ ಲಾರ್ಡ್ಶಿಪ್ನ ಮರ್ಯಾದೆ ಅಷ್ಟೇ ಇವತ್ತು. ಈ ರಿಯಾಲಿಟಿ ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಬೇಕು. ಮಾಡಿ ಡ್ಯೂರಿಂಗ್ ದ ಕೋರ್ಸ್ ಆಫ್ ದ ಡೇ. At the request of the learned counsel for the appellant, he is permitted to comply office objection during the course of the day, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance. In case if the office objections are not complied, registry to list the matter or move to the. Yes. ಬಹಳ ಸಿಂಪಲ್ ಇದೆ, ಮಾಡಿ 2 ಸೆಂಟೆನ್ಸ್ ಮೆಮೊ ಹಾಕಿ.
Serial number 10, Mahesh S.
₹1,000 per day. So 7,000 rupees you may have to pay. I grant you 7 days stay.
In 2 days.
ಅದೇ ಯಾಕ್ರಿ ಕಾಸ್ಟ್ ಕೇಳಿದ ಕೂಡಲೇ 7 ದಿವಸದಿಂದ 2 ದಿವಸಕ್ಕೆ ಇಳಿಸ್ತೀರಿ. ನಿಮ್ಗೆ ನಿಜವಾಗಿಯೂ 7 days ಬೇಕು ಅಂದ್ರೆ ನಿಮ್ಗೆ 7 days ಕೊಡ್ತೇನೆ ನಾನು. ಬೇಡ 10 days ಕೊಡ್ತೇನೆ. 10,000 rupees ಆಗ್ತದೆ. ಡೋಂಟ್ ಹೆಸಿಟೇಟ್. ಅಲ್ವೇ? ಅದು ನಿಮಗೆ ಗೊತ್ತಿದೆ. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ 7 ದಿವಸದ ಸಮಯ ಬೇಡ, 9 ಸಾಕು. ಆದ್ರೆ ವೀಕ್ ಟೈಮ್ ಕೇಳಿ ಬಿಡೋದು. ಫಸ್ಟ್ ದಾಳ ಒಗೆಯುವುದು ಅಂತಾರೆ ಕನ್ನಡದಲ್ಲಿ. ದಾಳ ಒಗೆಯುವುದು ಅಲ್ವೇ? ಏನಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್? ಮೊಬೈಲ್ ನಂಬರ್ ಆಫ್ ಕೌನ್ಸಿಲ್ ಟು ಬಿ ಸ್ಟೇಟೆಡ್ ಇನ್ ವಕಾಲತ್, ಡೀಟೇಲ್ ಮೆಮೋ ಫಾರ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಟು ಬಿ ಸ್ಟೇಟೆಡ್ ಇನ್ ಅಪೀಲ್ ಮೆಮೊರಾಂಡಮ್, ಅಪೀಲ್ ಟು ಬಿ ಪೇಜಿನೇಟೆಡ್ ಅಂಡ್ ಇಂಡೆಕ್ಸ್. 1 ವಾರ ಬೇಕಲ್ವೇ? ಇದು ಎಲ್ಲದರಲ್ಲಿಯೂ ನಿಮ್ಮ ಕಕ್ಷಿದಾರಗಳು ಬರ್ಬೇಕಿಲ್ಲಿ. ಇವತ್ತು ಲೈವ್ ಟೆಲಿಕಾಸ್ಟ್ ಆಗ್ತಿದೆ. ಕೇಳ್ಬೇಕು ನಿಮ್ ಕಕ್ಷಿದಾರ. ನಮ್ಮ ವಕೀಲರು ಏನ್ ಕೇಳಿದ್ರು? ನಮ್ಮ ಹತ್ರ ಇನ್ನು ಕೋರ್ಟಿಗೆ ಬಂದಿಲ್ಲ ಅಂತಿದ್ದಾರೆ. ಕೇಸ್ ಹಾಕಿ 4 ವರ್ಷ ಆಯ್ತು, ಕೋರ್ಟ್ ಯಾಕೆ ತಗೊಳ್ತಿಲ್ಲ? ಇಲ್ಲಿ ಓದಿ ಹೇಳ್ತೇವೆ ನೋಡಿ. 10 ಸೆಕೆಂಡ್ ಅಲ್ಲಿ ಮಾಡೋದಕ್ಕೂ ಕೂಡ 1 ವಾರ ಟೈಮ್ ಅಂತಾರೆ, 2 ವಾರ ಟೈಮ್ ಅಂತಾರೆ. ಅವಾಗ ಏನಿರ್ತದೆ ನಮ್ಮ ಗೌರವ? At the request of the learned counsel for the appellant, a day's accommodation is granted to comply all of his objection, including filing of the affidavit as directed earlier. In case if the office objections and direction are not complied in toto within a day from today, the appeal stands dismissed on its own without any further order by this court with effect from 26/5/2020.
Bill number S of R.
Jaya is Rao, independent. She is respondent to here in RFM. She was not a party in OS. The first objection test. The submission is that she was plaintiff number 2 before the OS, where due to typographical errors, it was part of it.
The registry has observed that the matter request to be posted before the appropriate division bench since the plaintiff share value exceeds ₹15 lakhs. In view of the above submission and in view of the above note by the registry and the supporting submission made, the registry is permitted to post the matter before the appropriate division bench, however, after obtaining necessary permission under the Chief Justice of his court if required. Let the matter be listed before the appropriate bench on 1/6. In the meantime, the appellant to complain the office objection which are yet to be complained.
Bill number 12, H.N. Basuraju.
Appearing for appellant in this case.
Yes.
Will not praise 1 week time to complete the office objection.
Learned counsel for the appellant appearing through video conference prays for a week's time to comply of his objection. A perusal of the order sheet would go to show that in this appeal of the year 2019, sufficient opportunity have already been granted to comply of his objection. On 17/4/2021, this court had directed the appellant to file an affidavit showing the reason for non-compliance of office objection. Despite such a direction also, the appellant has neither complied of his objection nor even filed the affidavit explaining the reason for non-compliance. On the contrary, a perusal of the office objection which are yet to be complied would go to show that they are too simple and trivial in their nature, like mentioning of the details in the presentation forum, furnishing the typed copy of the OS valuation slip, stating the value. to attend these office objection, which hardly requires couple of few minutes, the appellant has taken nearly 4 years and still praying for time. Hence, though the appeal could have been dismissed for non-compliance, however, in the best interest of justice, a week's time as prayed is granted, but imposing a cost of rupees 3,000 payable by the appellant to the Legal Services Committee of this court within 2 days from today, and filing a compliance memo along with original receipt in the registry to that effect within the said time. The failure of paying the cost and compliance of office objection in their entirety within the time granted as above would automatically result in dismissal of the appeal for non-compliance of office objection without any further orders by this court,
Much obliged.
with effect from 1/6. Yes.
Bill number 13, Harish HV.
Questions raised on IAM. But apart from that, there are some more objections, 12 objections.
NOC ವಕಾಲತ್ ರೀಸೆಂಟ್ಲಿ ಹಾಕಿದ್ದೇನೆ ಯಾರು ಸಬ್ಮಿಷನ್ ಶುರು ಮಾಡ್ತಾರೆ ಅಂತದ್ರಲ್ಲಿ ನಾನು ಜಾಸ್ತಿ ನಿಷ್ಠುರ ಆಗ್ತೇನೆ. ಯಾಕೆ ಅಂತ ಹೇಳಿದ್ರೆ ವಕೀಲರು ಯಾವ ಹಣೆ ಬರದಲ್ಲಿ ಕೇಸ್ ನಿಂತಿದೆ ಅನ್ನೋದನ್ನ ಪರಿಗಣನೆಗೆ ತಗೊಳ್ಳದಿದ್ದಂಗೆ NOC ಹಾಕಷ್ಟು ಕೂಡ ಜವಾಬ್ದಾರಿ ತೋರಿಸುವಲ್ಲಿ ಹಿಂಜರಿತ ತೋರಿಸಿದ್ದಾರೆ ಅನ್ನೋದು ಮನದಟ್ಟಾಗ್ತದೆ. ಯಾವುದೇ ವಕೀಲ NOC ಹಾಕುವ ಮುಂಚೆ ನಾನು NOC ಹಾಕಬೇಕಾಗಿರ್ತಕ್ಕಂಥ ಕೇಸಿನ ಹಣೆ ಬರ ಏನಾಗಿದೆ, ಯಾವ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ನಿಂತಿದೆ ಅಂತ ತಿಳಿದುಕೊಳ್ಳಬೇಕಾಗಿರೋದು ಅವಶ್ಯಕ ಮತ್ತು ಅನಿವಾರ್ಯ. ಆಗಿದ್ದ ಪಕ್ಷದಲ್ಲಿ NOC ಹಾಕ್ತಾ ಇದ್ದೇನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಇದರಲ್ಲಿ ಏನೇನಾಗಿದೆ, ಎಷ್ಟು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ, ಏನ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಗಳು, ಅಥವಾ ಯಾವ ರೀತಿ ಕೇಸ್ ಕೆಟ್ಟ ಹೋಗಿದೆ, ಅಥವಾ ಏನ್ ಲೂಪ್ ಹೋಲ್ ಇದೆ, ಏನ್ ಸ್ಟ್ರಾಂಗ್ ಪಾಯಿಂಟ್ ಇದೆ ನೋಡ್ಕೊಂಡೇ NOC ಹಾಕ್ತೇನೆ. ಆಗ NOC ನಿನ್ನೆ ಹಾಕಿದೆ, ಮೊನ್ನೆ ಹಾಕಿದೆ, ಈಗ ಹಾಕ್ತಿದ್ದೇನೆ, ಅಲ್ಲಿ ಆಫೀಸಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ ಜಸ್ಟ್ ಬರ್ತಿದ್ದೇನೆ ಅನ್ನೋದು ಒಂದು ಗ್ರೌಂಡ್ ಆಗಲ್ಲ. NOC ಹಾಕ್ತಕ್ಕಂಥ ವಕೀಲರು ಹೆಚ್ಚಿನ ಹುಷಾರುತನ, ಜಾಗರೂಕತನ ತೋರಿಸಲೇಬೇಕಾಗಿದ್ದು ಕಕ್ಷಿದಾರರ ದೃಷ್ಟಿಯಿಂದ ಅನಿವಾರ್ಯ ಮತ್ತು ಅವಶ್ಯಕ. ಹಾಗಾಗಿ ಯಾವ ವಕೀಲರು ನಾನು NOC ನಿನ್ನೆ ಹಾಕಿದೆ, ಮೊನ್ನೆ ಹಾಕಿದೆ, ಇತ್ತೀಚೆಗೆ ಹಾಕಿದೆ, ಈಗ ಹಾಕಿ ಬಂದೆ ಅಂತಾರೆ, ಅಂಥದ್ರಲ್ಲಿ ನಾನು ಜಾಸ್ತಿ ಸ್ಟ್ರಾಂಗ್ ಆಗ್ತೇನೆ, ಜಾಸ್ತಿ ಸ್ಟಬರ್ನ್ ಆಗ್ತೇನೆ. 500 ರೂಪಾಯಿ ಒಂದ್ ದಿವಸ, ಎಷ್ಟು ದಿವಸ ಬೇಕು ಕೇಳಿ ಕೊಡ್ಬೋದು. Yes. At the request of the learned counsel for the appellant, the matter to be continuously paginated and index to be filed, actual delay days to be stated. ಇಂಥ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಗಳು ಬಂದು NOC ನಿನ್ನೆ ಹಾಕಿದೆ, ಮೊನ್ನೆ ಹಾಕಿದೆ, 1 ವಾರ ಅಂತೆಲ್ಲ ಅಂತೀರಿ. ಈಗ ದುಡ್ಡು ಕೊಡ್ಲಿಕ್ಕೆ ತಯಾರಿದ್ದೀರಿ, ಇಂಥದ್ದನ್ನ ಅಟೆಂಡ್ ಮಾಡ್ಲಿಕ್ಕೆ ತಯಾರಿಲ್ಲ. ನೋಡಿ ನಮ್ಮ ಆಟಿಟ್ಯೂಡ್, ವಾಟ್ ಐ ಆಮ್ ಸ್ಪೀಕಿಂಗ್ ಈಸ್ ಅವರ್ ಇನ್ಕ್ಲೂಡಿಂಗ್ ಮೈ ಆಟಿಟ್ಯೂಡ್. ಏನ್ ತಗೊಂಡ್ರಿ ನೋಡಿ, ನಾನೆಷ್ಟು ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಬೇಕು, ಬೇಡ್ಕೊಳ್ಬೇಕು, ಅಂಗಲಾಚಬೇಕು. ಕನ್ನಡದಲ್ಲಿ ಪದ ಅಂಗಲಾಚು ಕೇಳಿದ್ದೀರಿ, ಜಾಸ್ತಿ ಹೇಳ್ಬೇಡ್ರಿ. ಫೈಲು ನೋಡಿದಂಗೆ NOC ತಗೊಂಡು ಅದನ್ನು ಹಾಕಿಲ್ಲ ಮಾಡಿದ್ದಾರೆ, ಬೇರೆ ವಕೀಲರು ನಗ್ತಾರೆ. Learned counsel for the appellant undertakes to comply all of his objection during the course of the day as a final last chance. 3 days time is granted to comply of his objection in their toto, both on the main appeal and on IA, failing which the court may proceed to pass appropriate or peremptory ಮಾಡಬಹುದಿತ್ತು. ನಾನು ಮಾಡ್ತಾ ಇಲ್ಲ. ಯಾಕೆ ಅಂದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡುವ ಮುಂಚೆ ಸ್ವಲ್ಪ ಇನ್ನೂ ಜಾಸ್ತಿ ಬರ್ಸಿ ಮಾಡುವ ಅಂತಿದ್ದೇನೆ. ನಾಡಿದ್ದು ನನ್ನೆದ್ರೆ ಬರ್ತದೆ, ನೀವು ಬರ್ತೀರಿ, ಇನ್ನೊಂದು ಕಾರಣ ತಗೊಂಡು ಬಂದು ಟೈಮ್ ಕೇಳ್ತೀರಿ. ಗೊತ್ತಿದೆ, ಬರ್ಕೊಳ್ಳಿ ಬೇಕಾದ್ರೆ. ಏನಂದ್ರಿ? Court will proceed to pass appropriate order including dismissal of the appeal for non-prosecution. ಯಾಕಂದ್ರೆ ನೀವು ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ಇದ್ರಲ್ಲಿ ಹಾಕದಿರಿ, ಅದ್ ನನ್ಗೆ ಗೊತ್ತಿಲ್ಲ, ನೋಡಿ ನೀವು ಇಮ್ಯಾಜಿನ್ ಮಾಡ್ಬೇಡ್ರಿ. ಅದಲ್ಲ, ನಾವು ಮಕ್ಕಳ ಬಾಯಿಂದ ಹೊರಡಿಸ್ತೇವೆ ನೋಡಿ, 1, 2, 3 ನಾವೇ ಸಜೆಷನ್ ಕೊಟ್ಟದಲ್ಲ ಹೀಗೆ ಅಂತ ಉತ್ತರ. ದಟ್ ಅಟೆಂಪ್ಟ್ ಯು ಆರ್ ಮೇಕಿಂಗ್. ಏನ್ ತಗೊಂಡ್ರಿ? ಅಕಾರ್ಡಿಂಗ್ಲಿ As a last chance, 3 days time as prayed is granted. In case if the office subjections are not complied in their toto, registry to list the matter on 2/6.
Bill number 14, Rashid Khan.
No LRC is interested, no interest is showing with it.
No LRs are interested.
Nobody has come forward.
ಅಷ್ಟೇ ಬಿಡಿ ಇನ್ನೇನ್ ಮಾಡ್ತೀರಿ ನೀವು? What best you can do, you have done. It is for them. The learned counsel for the appellant who is physically present submits that according to the information given to him, the sole appellant is dead. However, his legal representative, despite communication or not evincing interest in prosecuting the matter. With this submission, he pleads his helplessness to comply with his objection. Next time, in the light of the above, since the appellant oblique alleged LRs of appellant himself oblique themselves are not evincing are said to be not evincing interest in prosecuting the matter by complying the office objection. There's no point in further granting any time. Accordingly, the appeal stands dismissed for non-compliance of office objection.
Bill number 15, Mohan S.
The counsel for the appellant neither present physically nor through video conference. The perusal of the order sheet will go to show that in this appeal of the year 2019, till date, the appellant has not complied with office objection in spite of he being given with sufficient opportunities of not less than 3 times to comply office objection. Next one. On the date 24/2021, this court had directed the appellant, learned counsel for the appellant to file an affidavit explaining the reasons for non-compliance with specific reference to the office objections from the date of raising of office objections till the expiry of further time granted by the court on the said date. In spite of such a direction also, the appellant has neither filed the affidavit, though was directed, nor complied with the office objection. A perusal of the next line, office objection yet to be complied, would go to show that they are too trivial in their nature, like clarifying the difference in the address in the wakalat to that of the memorandum of appeal, correctly mentioning the OS number and the date of disposal, signing the synopsis, the stating the name of the executant of wakalat in the wakalat. For these simple office objections, which could have been attended within few minutes, the appellant has not complied despite the appeal of the year 2019. Further, the learned counsel for the appellant also has remained absent, showing no reasons. Hence, I don't find any reason in further adjourning the matter by granting time. Accordingly, the appeal stands dismissed for non-compliance of office objections as well as for non-prosecution.
Bill number 16, Vishwanath Shetty.
₹500 per day. I grant you Friday. ಕೋರ್ಟ್ ಫೀ ಇದೆ. ಕೋರ್ಟ್ ಫೀ ಈಗ ನಿನ್ನೆ ಹೇಳಿಲ್ಲ ನಿಮಗೆ ರಿಜಿಸ್ಟ್ರಿ 2019 ಮ್ಯಾಟರ್ 2021 ನಲ್ಲೇ ನಿಮಗೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿತ್ತು ಅಫಿಡವಿಟ್ ಫೈಲ್ ಮಾಡಿ ಅಂತ. ಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಅನ್ನು ಇಗ್ನೋರ್ ಮಾಡಿದ್ರಿ. ಎಷ್ಟು ಹಗುರವಾಗಿ ತಗೊಳ್ತೀರಿ ನೋಡಿ ಕೋರ್ಟಿನದು. ದಿ ಲರ್ನೆಡ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ ಶಾಲ್ ಫೈಲ್ ಆನ್ ಅಫಿಡವಿಟ್. ಸಮಯ ಕೊಡ್ತೇನೆ, ₹500 per day. ಎಷ್ಟು ದಿವಸ ಬೇಕು ಕೇಳಿ, ಕೊಡಬಲ್ಲೆ. 5 days. Learned counsel for the appellant prays for 5 days accommodation. After bringing to his notice the nature of the office objection to be complied with and non-compliance of the direction of this court in filing an affidavit by the council, which was ordered on 19/4/2021, when the court suggested that granting such time would be on a cost at ₹500 per day. Still, the learned counsel for the appellant insists for the same length of period to comply with his objection. Accordingly, imposing a cost of ₹2,500 payable by the appellant. As a final last opportunity, 5 days time as period is granted to comply with his objection. The cost ordered today is payable by the appellant to the Legal Services Committee of this court within 2 days from today, and to file a complaints memo along with original receipt to that effect in the registry. Is subject to payment of the said cost within time the registry to permit the compliance of office objection. In case if the office objections are not complied in toto and cost is not paid within time, the registry to list this matter on 2/6, on which day the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance and order regarding the recovery of the cost, provided if the same is not paid.
Number 17, Bhakta Vachala.
None appear possible.
Number 18, Ramana MVV.
Appearing for the appellant in this matter, my lords, I am in a situation wherein I have been not getting any instructions from the client. I am sending a retirement memo notice to him. Lordship will give me 3 days time, along with it, I file a memo for retirement. Because if I don't get instructions, I have been seeing my lords today. I don't want to be in such a
In the
situation.
early retirement memo, better if you inform your party also to file an application.
That's
for
what, sir, my
requesting
lord.
order of dismissal.
Today I will issue a notice to
court
the
need
party.
not-
After
the
that,
court
along with the
need
record.
not grant any adjournment to enable a council to send a retirement memo. That is nothing but another reason of seeking an adjournment.
I am not seeking, I am making it very clear that
Yes,
it
you
will
are
be
not
done.
seeking
Otherwise,
adjournment.
I will file.
Yes, please. Otherwise,
Otherwise, I will file a memo of retirement tomorrow itself. In the registry, I will file it.
you need
I am
not
not going to
take
appeal the
that
matter because
trouble
without
also.
I don't want.
I am passing a final
And
order
because, no, why?
of this appeal right now.
No,
for
no, my
law-
lord. So why I am saying is that one, that objection 9, 10, 11 parties is required. Otherwise, I would have done it everything 1, 2, 3, 4, 5, 6. I can do it. But 9, 10, 11 party only has to become. That's the reason why. Because valuation slip, I am not the advocate, the trial court, all those things. That's the reason why.
Mr.
I'm asking.
Ramana, mentioning the same,
Yes,
you
my
could
lords.
have filed an affidavit. Despite a direction that was given to you 2 years back, you slept. You did not do anything even to file an affidavit to that effect.
No, affidavit, I cannot file the affidavit because our party has to accept all those things, my lords. Because the
Yes.
party, unless the party says something, that's why
Yes.
Lordship will give me 2 days time, Lord, I will file the memo for retirement.
Take down. The learned counsel for the appellant appearing through video conference. Place for 3 days time, stating that since the party is not cooperating, he is sending a retirement memo. He is sending a notice of retirement to the party. Next one. The perusal of the case papers would go to show that the appeal is of the year 2019 and till date the office objections are not complied with. Without the assistance or cooperation of the party also, the several of the office objections could have been complied with, since those office objections are like paginating the appeal, filling up of the index, mentioning the page numbers, mentioning the page number, properly stitching page number 5 and 6 of the judgment copy, correctly mentioning the designation of the trial court, etc. These office objection never requires any instruction or assistance from any litigant, since they are required to be attended by the learned counsel himself. In spite of the same, next line, this court on 24/2021 had directed the learned counsel for the appellant to file an affidavit explaining the reasons for non-compliance with specific reference to the office subjections from the date of raising of office objection till the expiry of further time granted by the order possible on that day. Next line, when this court brought the said direction given on 24/2021 to the notice of the learned counsel for the appellant, the learned counsel contended that even to file the affidavit also the party was required. The party of the appellant was required. Next line, needless to say that the direction was to the learned counsel to file affidavit by him, not by the party. Since the learned counsel for the appellant is not even accepting the said contention and has not complied the office objection which he could have complied with without assistance or instructions of the party, I am of the view that there is no point in further granting the time just to enable the learned counsel for the appellant to serve a retirement notice to his party. Hence, the appeal stands dismissed for non-prosecution.
Non-compliance, fourth time, film 19, Lokesh SG.
My lord, I have compared the other substitution. After complaint, my lord, again raise this I will verify today itself. Regarding objection 2 is concerned, my lord, I am mentioned in the appeal memo. Clear, the trial court, my lord, they have mentioned wrong name, my lord. Instead of mentioning Rudra Policy.
If the office objections which are yet to be complied with or raised subsequent to you complying office objections, and if they are for the first time being coming up now, I will grant you a time. If any of the office objections which are due were already there and you were granted a time, I am dismissing the appeal.
Last date, my lord, I have compared.
Nimmadu opening remark, I have already completed all office objections. Subsequently, the registry has raised the present objection.
I am.
Aduna nodtene.
Please note this also. Regarding appellant number 4, name of the appellant number 4 and 6, my lord.
ನಾನು ಒಂದ್ರ ಬಗ್ಗೆ ಹೇಳ್ತಾ ಇಲ್ಲ ರೀ, ಎಷ್ಟು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇದೆ ಗೊತ್ತಿಲ್ಲ, ಒಂದಿರಬಹುದು 15 ಇರಬಹುದು. ಈಗ ಯಾವುದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಔಟ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಇದೆಯೋ ಅದು ಎರಡು ಹೊಸ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇವತ್ತು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆ ಅಂದ್ರೆ ಡೆಫಿನೆಟ್ಲಿ ನಿಮ್ಗೆ ಸಫಿಶಿಯಂಟ್ ಟೈಮ್ ಕೊಡ್ತೇನೆ. ಅದು ಹಳೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಆದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೇನೆ.
ಇವತ್ತೇ ಮಾಡ್ತಾರೆ, ಅದೇ ಹಳೆ ಅಬ್ಜೆಕ್ಷನ್ ಆಗಿತ್ತು, ಇವತ್ತೇ ಮಾಡಿದ್ದೀನಿ ನಾನು ನೋಡ್ತೀನಿ.
ಅಲ್ಲ, ನೀವು ಬದಲಾಯಿಸ್ತಾ ಇದ್ದೀರಿ ನಿಮ್ಮ ಸಬ್ಮಿಷನ್ ವರ್ಷನ್. Submission is varying, drastically varying. It is not honest submission, it is tactful submission now. Always, honesty, tactfulness, there are greater variation. I always appreciate honesty. ಸ್ವಾಮಿ, ನನಗೆ ನಿನ್ನೆ IPL ನಲ್ಲಿ ಯಾವುದೋ ಒಂದು ಟೀಮ್ ಸೋತಿದ್ ಬೇಜಾರಾಯ್ತು ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ಬಹಳ ಬೇಜಾರಾಗಿ ಏನು ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ, ಟೈಮ್ ಕೊಡಿ, ಖುಷಿಯಿಂದ ಕೊಡಬಲ್ಲೆ. ಚತುರತೆ ತೋರಿಸಿದ್ರೆ ನಾನು ಅವ್ರಿಗಿಂತಲೂ ಚತುರನಾಗ್ತೇನೆ. ಈಗ ಯಾವ್ದನ್ನ ಆಯ್ಕೆ ಮಾಡ್ಕೊಳ್ತೀರಿ ತಾವು? Since the learned counsel for the appellant undertakes to comply all of his objections during the course of the day, at final last opportunity, a day's accommodation is granted. In case if the office objections are not complied in the toto within a day from today, the appeal stands dismissed for non-compliance of office objection on its own without any further order by this court with effect from 29/5/2020.
Serial number 20, Chittapati Gowda.
None appear for appellant. As an ultimate chance, 2 days time is granted to comply office objection, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-prosecution as well for non-compliance of office objection. If the office objections are not complied within the time granted above, List the matter on 31/5.
Seal number 21, Pink Fred Richardson.
One week time.
₹500 cost per day. I can grant you 1 week time if you want. ಕೊಡ್ತೇನೆ 1 week time ಕೊಡ್ತೇನೆ 500 into 7 ₹3,500 ಆಗ್ತದೆ. Provision of RFA to be completely stated. Detailed valuation memo in RFA to be filed. Typed copy of decree of OS to be filed. Photocopies of OS to be attested. ನನಗೆ ತಬ್ಬಿಬ್ಬಾಗ್ತದೆ, ಸಂಕೋಚ ಅನಿಸ್ತದೆ. ಇಂಥ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಗಳು ಹಲವಾರು ವರ್ಷಗಳಿಂದ ಬಾಕಿ ಇರ್ತಾವೆ. ಅದನ್ನ ನಾನು ಗಟ್ಟಿ ಓದ್ಬೇಕಲ್ಲ ಅಂತ ನೀವು ಯಾವುದೇ ಸಂಕೋಚವಿಲ್ಲದೆ 1 ವಾರ ಅಂತ ಕೇಳಿ ಬಿಡ್ತೀರಿ. ಕೊಡ್ತೇನೆ 1 ವಾರ, ನಾನು ಇಲ್ಲ ಅಂತೀನಿ. ವೈ ಶುಡ್ ಐ ಡಿನಿ? ಬಟ್ ಆನ್ ಕಾಸ್ಟ್ ಬಿಕಾಸ್ ಆಫ್ ದಿ ನೇಚರ್ ಆಫ್ ದಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್.
The office objections sometime. Last chance.
ಕೊಡ್ತೇನ್ರಿ ₹500 per day. I will grant you any number of days. Why 7 days? As for 17 days, I can grant you 17 into 5, 8,500.
I have to comply with this.
The learned counsel for the appellant is requesting for 1 more week's time to comply of his objection. The perusal of the office objection would go to show that they are very simple in nature and could have been attended at the earliest. However, considering the submission made today as an ultimate opportunity, 4 days' time is granted to comply of his objection, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance. In case of the office objections are not complied within time in their entirety, registry to list this matter on 1/6. ಬನ್ನಿ 1ನೇ ತಾರೀಕು ಬಂದು during the course of the day ಅಂತೀರಿ ಕೇಳಿ. Yes.
22, Amshake.
1 week minutes.
₹1,000 per day ಕೊಡ್ತೇನೆ 1 week. ₹1,000 per day. ಅಲ್ಲ ರೀ, ನಾ ಲಾಸ್ಟ್ ಚಾನ್ಸ್ ಅಂತ ಮೆನ್ಷನ್ ಮಾಡಲ್ಲ, ಬರೀ ಫೈನಲಿ ಅಂತ ಹೇಳ್ತೇನೆ. 1 week ಕೊಡ್ತೇನೆ. ₹1,000 per day ಕಾಸ್ಟ್. ಎಷ್ಟು ದಿವಸ ಬೇಕು ಹೇಳಿ? ಜಾಸ್ತಿನೂ ಕೊಡ್ತೇನೆ, 10 ದಿವಸನೂ ಕೊಡ್ತೇನೆ. Index to be duly filled up. ಎಷ್ಟು ದಿವಸ ಬೇಕು? 2 minutes. Appeal papers to be paginated. 30 seconds ಸಾಕು. 1 2 3 4 5 6 7 ಅಂತ ಬರೀಲಿಕ್ಕೆ. Disposal date of trial court to be stated in synopsis. 30 seconds. Valuation para to be stated correctly in detail. Maximum 10 minutes. All put together. 14 minutes, 30 seconds. You are asking for 7 days. I grant you 7 days. 7 into 5, 3,500. ಅಲ್ಲ, ಇದೇ ನಾಮಿನಲ್. ಈ ರೀತಿಯ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಗೆ 4 ವರ್ಷದಿಂದ ಬಾಕಿ ಇಟ್ಟು ಈಗಲೂ ಕೂಡ ಎಷ್ಟು ಸಮಯ ಬೇಕು ಅಂತ ಕೇಳ್ಬೇಕಲ್ಲ, 1 ವಾರ ಅಂತ ಕೇಳ್ತೀರಿ ನೋಡಿ. ಅದು ನನಗೆ ಚಿನ್ನದ ಕೊಡಲಿ ರನ್ನದ ಕೊಡಲಿ ಕತೆ ನೆನಪಿಗೆ ಬರ್ತದೆ. ನಮಗೆ 4ನೇ ಕ್ಲಾಸ್ ಸಪ್ಲಿಮೆಂಟರಿಯಲ್ಲಿ ಇತ್ತು. ಹುಡುಕಿ ನೋಡಿ, ಯಾವ್ದಾದ್ರು ಸೆಂಟ್ರಲ್ ಲೈಬ್ರರಿಯಲ್ಲಿ ಅದು ಸಿಗ್ಬಹುದು. ಸುಂದರವಾಗಿದೆ ಕತೆ. ಮರ ಕಡಿಯುವವನು ಕಾಡಿಗೆ ಹೋದಾಗ ಅವನು ಕೊಡಲಿ ನೀರಿನಲ್ಲಿ ಪಕ್ಕದ ಹಳ್ಳದಲ್ಲಿ ಬಿದ್ದೋಗಿ ಬಿಡ್ತದೆ. ಅತ್ಯಂತ ಬಡವ. ಏನ್ ಮಾಡ್ಬೇಕು? ಅಳ್ತಾನೆ, ಅಯ್ಯೋ ನನ್ ಕೊಡ್ಲಿ ಬಿದ್ದೋಯ್ತು. ದೇವರು ಪ್ರತ್ಯಕ್ಷ ಆಗ್ತಾನೆ, ಕೇಳ್ತಾನೆ, ಅಯ್ಯ ಏನಾಯ್ತು ಅಂತ. ಸ್ವಾಮಿ ನನ್ ಕೊಡ್ಲಿ ಬಿದ್ದೋಯ್ತು. ಹೌದಾ, ನಾ ತೆಗೆದುಕೊಡ್ತೀನಿ ಇರು ಅಂತ ಹೇಳಿ ಅವನೊಂದು ಚಿನ್ನದ ಕೊಡ್ಲಿನ ತೆಗೆದುಕೊಡ್ತಾನೆ. ಈ ಮರ ಕಡಿಯೋನ್ ಹೇಳ್ತಾನೆ, ಸ್ವಾಮಿ ಇದು ನಂದಲ್ಲ, ನನಗೆ ಬೇಡ ಅದು. ಓ ಹೌದಾ, ಏನೋ ಬೈ ಮಿಸ್ಟೇಕ್ ಹಾಗಾಯ್ತು ಅಂತ ಹೇಳಿ ಅವನು ಅದನ್ನ ಬಿಟ್ಟು ಇನ್ನೊಂದು ಕೊಡ್ಲಿ ತೆಗೆದು ಕೊಡ್ತಾನೆ. ಬೆಳ್ಳಿಯ ಕೊಡ್ಲಿ ತಗೋಪ್ಪ ನಿನ್ ಕೊಡ್ಲಿ. ಅವನು ಬೇಡ, ಇದು ನನ್ ಕೊಡ್ಲಿ ಅಲ್ಲ, ನನಗಿದು ಬೇಡ ಅಂತ. ಆಮೇಲೆ ಅವನು ಅದನ್ನು ಬಿಡ್ತಾನೆ, ಅವನು ಕಬ್ಬಿಣದ ಕೊಡ್ಲಿ ತೆಗೆದುಕೊಡ್ತಾನೆ, ತಗೋ ನಿನ್ ಕೊಡ್ಲಿ ಅಂತ. ಬಹಳ ಸಂತೋಷ ಆಗ್ತದೆ ಇವನಿಗೆ. ಭಗವಂತನಿಗೆ ನಮಸ್ಕಾರ ಮಾಡಿ, ಅಯ್ಯ ಇವತ್ತು ನೀ ನನಗೆ ಒಂದು ಹೊಟ್ಟೆ ಪಾಡಿಗೆ ಒಂದು ದಾರಿ ಮಾಡಿ ಕೊಟ್ಟಿ, ಇಲ್ಲರೆ ಹೆಂಡತಿ ಮಕ್ಕಳು ಉಪವಾಸ ಮಲಗಬೇಕಿತ್ತು ಅಂತ ಹೇಳಿ ಕಬ್ಬಿಣದ ಕೊಡ್ಲಿ ತಗೊಂಡು ಹೊರಡ್ಲಿಕ್ಕೆ ಹೊರಡ್ತಾನೆ. ಭಗವಂತ ಹೇಳ್ತಾನೆ, ಇರು ಭಕ್ತ ಅಂತ ಹೇಳಿ, ನಿನ್ನ ಪ್ರಾಮಾಣಿಕತೆ ಮೆಚ್ಚಿದೆ, ತಗೋ ಈ ಬೆಳ್ಳಿ ಕೊಡ್ಲಿನೂ ತಗೋ, ಚಿನ್ನದ ಕೊಡ್ಲಿನೂ ತಗೋ ಅಂತ ಹೇಳಿ ಅವನ ಕಬ್ಬಿಣದ ಕೊಡ್ಲಿ ಜೊತೆಗೆ ಅದ್ ಎರಡು ಕೊಡ್ಲಿ ಕೊಡ್ತಾನೆ. ಇವನ್ ಮನೆಗೆ ಬರ್ತಾನೆ. ಅವನ ಹೆಂಡತಿಯಿಂದ ಪಕ್ಕದ ಮನೆಯೊಳಗೆ ಈ ವಿಷಯ ತಿಳಿಯಿತು. ಅವಳ ಗಂಡನು ಮರಕಟಿಗಾನೆ. ನೋಡ್ರಿ ಹಿಂಗಾಯ್ತಂತೆ ಪಕ್ಕದ ದ್ಯಾಮಪ್ಪನಿಗೆ ಅಂತ, ನೀವು ಹೋಗಿ ಏನಾರು ಮಾಡಿ ಬರ್ರಿ. ಸರಿ, ಮಾರನೇ ದಿವಸ ದ್ಯಾಮಪ್ಪ ಹೋಗ್ತಾನೆ. ಅದೇ ಹಳ್ಳ, ಅದೇ ಪಕ್ಕದ ಮರ. 2 ಏಟ್ ಮರದ ಮೇಲೆ ಹಾಕ್ತಾನೆ, 3ನೇ ಏಟನ್ನ ಕೊಡ್ಲಿನೂ ಸೇರಿಸಿ ಅವ್ರು ಹಳ್ಳಕ್ಕೆ ಹಾಕ್ತಾನೆ. ಓ ಅಂತ ಬಾಯಿ ಬಡ್ಕೊಳ್ತಾ ಕೂರ್ತಾನೆ, ದೇವ್ರೇ ನನ್ ಕುಡ್ಲಿ ಹೋಯ್ತು. ಕೆಲ್ಸ ಇಲ್ಲದೆ ದೇವ್ರು ಮತ್ತೆ ಪ್ರತ್ಯಕ್ಷ ಆಗ್ತಾನೆ. ಭಕ್ತ ನೀನು ಅಳ್ತಾ ಇದ್ದಿ, ಏನಾಯ್ತು? ಸ್ವಾಮಿ ನನ್ ಕೊಡ್ಲಿಕ್ಕೆ ಹೋಯ್ತು. ಹೌದಾ, ತಡಿ ನಾ ತೆಗೆದು ಕೊಡ್ತೇನೆ. ಬೆಳ್ಳಿ ಕೊಡ್ಲಿ ಕೊಡ್ತೇನೆ, ತಗೋಪ್ಪ ನನ್ ಕೊಡ್ಲಿ. ನನ್ ಕೊಡ್ಲಿ ಇದಲ್ಲ, ಇದಕ್ಕಿಂತ ಚಲೋ ಐತಿ. ಆಮೇಲೆ ಅವನು ಅದನ್ನ ಬಿಡ್ತಾನೆ, ಚಿನ್ನದ ಕೊಡ್ಲಿ ತೆಗಿತಾನೆ, ತಗೋ ನಿನ್ ಕೊಡ್ಲಿ. ಹಾ ಇದೇ ನನ್ ಕೊಡ್ಲಿ, ಕುಡಿ. ಅವಾಗ ದೇವ್ರು ಹೇಳ್ತಾನೆ, ಅಲ್ಲ ಭಕ್ತ, ನಿನ್ನ ದುರಾಸೆಗೆ ನಾನು ಬಹಳ ಕೋಪಗೊಂಡಿದ್ದೇನೆ. ನಿನ್ ಕೊಡ್ಲಿ ಕಬ್ಬಿಣದ್ದು, ನಿನ್ನೆ ನಿನ್ ಪಕ್ಕದ ಮನೆಯದು ಹೀಗಾಯ್ತು ಅಂತ ನೀನು ಈ ಡ್ರಾಮಾ ಮಾಡ್ಲಿಕ್ಕೆ ಬಂದಿದ್ದಿ. ಎಲ್ಲಾ ಕಡೆ ನಾ CCTV ಕ್ಯಾಮರಾ ಹಾಕಿರ್ತೇನೆ, ನಾನು ಭಗವಂತ, ನಂಗೂ ಗೊತ್ತು ಏನಾಗ್ತದೆ ಅಂತ. ನಿನಗೆ ನಿನ್ ಕೊಡ್ಲಿನೂ ಇಲ್ಲ, ಏನೂ ಇಲ್ಲ, ಹೋಗು ಅಂತ ಕಳಿಸ್ತಾರೆ. ಇಷ್ಟು ಸಣ್ಣ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಗೆ 7 ದಿವಸ ಟೈಮ್ ಸಿಗುತ್ತಲ್ಲ, ಜಾಸ್ತಿನೇ ಸಿಗ್ಲಿ ಅಷ್ಟ. ಎಷ್ಟು ಅರ್ಹತೆ ಇದೆಯೋ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಅಷ್ಟು ಕೇಳಿದ್ರೆ, ಡೂ ಇಟ್ ಡ್ಯೂರಿಂಗ್ ದ ಕೋರ್ಸ್ ಆಫ್ ದ ಡೇ ಅಂದ್ರೆ ಖುಷಿಯಿಂದ ಕೊಡಬಲ್ಲೆ, ಏನೂ ಇಲ್ಲದಿಗೆ. ಕೇಳೋದ್ ಕೇಳ್ತೀರಿ, 1 ವಾರ ಕೇಳಿಬಿಡೋಣಂತೆ ಅಲ್ವೇ? ಹೇಳಿ ನಿಮ್ಮ ಕಲೀಗ್ಸಿಗೂ ಈ ಚಿನ್ನದ ಕೊಡ್ಲಿ ರನ್ನದ ಕೊಡ್ಲಿ ಕತೆ ನಾನು ಯಾವಾಗ್ಲೂ ಜ್ಞಾಪಕ ಮಾಡ್ಕೊಳ್ತಿರ್ತೇನೆ. ಕೆಲವೊಂದು ನಮ್ಮ ಜೀವನದಲ್ಲಿ ಸರಿದಾರಿಗೆ ಕರ್ಕೊಂಡು ಹೋಗ್ಲಿಕ್ಕೆ ಇಂತಹ ಕಥೆಗಳು ಸಹಾಯ ಬೇಕಾಗ್ತದೆ. ನಾವು ಹುಡುಗರಿದ್ದಾಗ ನಮಗೆ ಸಪ್ಲಿಮೆಂಟರಿ ರೀಡರ್ ಕಂಪಲ್ಸರಿ 4ನೇ ಕ್ಲಾಸಲ್ಲಿ. ಅದೆಲ್ಲ ಇಂಥ ನೀತಿ ಬೋಧಕ ಕಥೆಗಳೇ. ಈಗ ಹೇಳಿ, ಎಷ್ಟು ದಿವಸ ಬೇಕು, ಎಷ್ಟು ಕಾಸ್ಟ್ಗೆ? 2-3 days. At the request of the learned counsel for the appellant, as a final last opportunity, 2 days time as prayed is granted, failing which to complete office objection, failing which the court will proceed to pass appropriate order, including dismissal of the plea for non-compliance. If the office objections are not complied within time, registry to list this matter on 31/5. Note, cost ಏನು ಹಾಕಿಲ್ಲ, ಕೊಟ್ಟಿದ್ದೇನೆ.
Seal number 23, Lakshmama SP.
There were 10 office objections, my lord.
So,
Office objection 7 is designation of the trial court difference at first sheet of OS judgment clarify ಅಂತ ಕೇಳಿದ್ರು. ಈ ಕ್ಲಾರಿಫೈ ಬಂದ್ಮೇಲೆ ನಾನು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಹೋಗಿ ಯಾಕೆ ಹಿಂಗ್ ಮಾಡಿದ್ರಿ ನೀವು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 10 ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ರೋಮನ್
ಯಾಕೆ ಹಿಂಗೆ ಮಾಡಿದ್ರಿ ಅಂತ ಯಾರನ್ನ ಕೇಳಿದ್ರಿ? ಅಲ್ಲಿ ಶಿರಸ್ಸಿನ ಕೇಳಿದ್ರ, ಜಡ್ಜನ್ನ ಕೇಳಿದ್ರ?
ಕನ್ಸರ್ನ್ ಕೇಸ್
ಜಡ್ಜನ್ ಕೇಳಲಿಲ್ಲ, ಜಡ್ಜನ್ ಕೇಳಲಿಲ್ಲ.
ಇಲ್ಲ, ಅಷ್ಟಕ್ಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗುತ್ತೆ.
ಎಸ್,
ಕೇಸ್
ಅವ್ರ ಅದೃಷ್ಟ.
ಕನ್ಸರ್ನ್ ಕೇಸ್ ಕೇಳಿದೆ ಸ್ವಾಮಿ. ಏನು ಪೇಜ್ ನಂಬರ್ 10 ಫಾಸ್ಟ್ ಇದೆ, ಇದು ಕೋರ್ಟ್ ಹಾಲಿಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದು. ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಸಾಹೇಬರು ಸ್ಟೇಟ್ ಮಾಡಿದ್ದಾರಲ್ಲ, ಅದು ಜಡ್ಜಿ ಸಂಬಂಧಪಟ್ಟಿದ್ದು ಅಂತ ಹೇಳಿ ಇದನ್ನ ನಾನು ಅದೇ ರೀತಿ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ನೋಟ್ ಮಾಡಿ ಇಟ್ಟಿದ್ದೇನೆ. ಈಗ ಹೊಸದಾಗಿ ಆಫೀಸರ್ಸ್ ರೈಸಿಂಗ್ ದಿ ಅಬ್ಜೆಕ್ಷನ್ ಡಿಗ್ರಿ ಒಳಗೆ ಅದು ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಅವರು ರೈಸ್ ಮಾಡ್ತಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಡಿಗ್ರಿ ಒಳಗೆ ಏನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತಂದ್ರೆ ಪೇಜ್ ನಂಬರ್ 37 ಬನ್ನಿ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ರೋಮನ್ ಎಕ್ಸೆಲ್ ಅಂತ ಹೊಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಇದೇ ಮಿಸ್ಟೇಕ್ ಆಗಿರೋದು, ನನಗೂ ಈಗಲೇ ಗೊತ್ತಾಗಿದೆ. ಇದಕ್ಕೆ ನಾನು ಕೆಳಗಡೆ ಕೊಟ್ಟಿಗೆ ಹೋಗಿ ಓಪನ್ ಮಾಡಿಸಿ ಸೆಕ್ಷನ್ 152 ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿ ದಿಸ್ ಇಸ್ ಎ ಟೈಪೋಗ್ರಫಿಕಲ್ ಎರರ್ ಕಮಿಟೆಡ್ ಬೈ ದಿ ಇದು ಡಿಕ್ರಿಬರೆನ್ಸ್ ಮಾಡಿರೋ ಕೆಲಸ. ಹಾಗಾಗಿ ನಾನು ಇದನ್ನ
ಕೆಳಗಡೆ ಕೊಟ್ಟಿಲ್ಲ, cancel ಮಾಡಿ.
At the request of the learned counsel for the appellant and after hearing her submission. As a final opportunity to which time is granted.
ಆಮೇಲೆ ಸ್ವಾಮಿ ಇನ್ನೊಂದು.
Subsection filing which the court may proceed to pass appropriate order.
ಆಮೇಲೆ ಡಿಪೆಂಡೆಂಟ್ ನಂಬರ್ 4 ನ ಸ್ವಾಮಿ ಕೃಷ್ಣಾರೆಡ್ಡಿ ಅನ್ನೋರ್ನ ನಾನು ಕೆಳಗಡೆ ಕೊಟ್ಟಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ 11 of
2 ವಾರ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಅದು ಏನೇನೆಲ್ಲ ರಿಪೇರಿ ಮಾಡಬಹುದು ಮಾಡಿ, including filing a corrected copy of the decree. Other submission which the registry itself can attend to it or overrule it, you approach the registrar judiciary.
Till number 24, Rajgopal Naidu.
Seek for a 3 days time.
At the request of the learned counsel for the appellant, as a last opportunity, 3 days time as spread is granted, failing which so and so, so and so. In case if not complied, 2/6. Yes.
Till number 25, Geeta Menon.
While some of the objections admittedly are very listed, one of the objections raised is that the decree copy does not show the second defendant. The decree copy only shows the injunction court fee paid, whereas we have paid, we sought for a declaration by way of amendment that is not reflected in the decree, so I have to seek for modification and correction of the decree. The judgment shows the second defendant, but the decree does not show. Other objections, I admit, I know they are, can that requires.
That objection which you are now mentioning about the discrepancy in mentioning the name of the defendant number 2 or not mentioning in the decree copy was raised by the registry at the earliest point of time.
Is my vote.
As long back as in the year 2021. You have not complied the same. Thereafter also thrice the matter came up before the court. You have not complied. So granting of any further time would be only on. It's not for the first time such a office objection is raised. That was raised and you are aware of the same in the year 2021.
There is a mistake on my part.
Exactly. That is the reason.
Give me a final chance of 1 week. I don't have.
Request of the learned counsel for the appellant. As a last chance, a week's time as prayed is granted to complete all office objection their entirety, failing which the court may proceed to pass. So in case if not complete. Just a matter on your door. Yes.
Till number 26, Ramchandra Padian.
Filing of this appeal, that is appellant is dead. I have filed LR application that has been allowed. That we have to amend the memo and we have also filed to, there is amendment memo. For weeks time may be done.
So who would attend to the office objections apart from the amendment?
I will answer you.
ಯಾವ್ದು ಹೇಳ್ಬೇಕು ಅದನ್ನ ಬಿಟ್ಟು ಉಳಿದಿದ್ದನ್ನು ಹೇಳ್ತಾ ಇದ್ವಿ.
All the objections will
12 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ.
that is
ಈ 12 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲದೆ ಇರೋದು ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್ ಅಮೆಂಡ್ಮೆಂಟ್ ಕ್ಯಾರಿ ಔಟ್ ಮಾಡ್ಬೇಕಾಗಿರೋದನ್ನ ಮಾತ್ರ ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಈ 12 ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ 2019 ಇಂದ ಯಾಕೆ ಬಾಕಿ ಇದೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಇದೇ ಡಿಫರೆನ್ಸ್ ನಾನು ಮಾಡೋದು, ಚತುರತೆ ಮತ್ತು ಪ್ರಾಮಾಣಿಕತೆ ನಡುವಿನ ವ್ಯತ್ಯಾಸ ಇದೆ.
for complaint of subjections including this.
ಈಗ ಹಿಂದಿನ 2 ಕೇಸಲ್ಲಿ ನೋಡಿದ್ರು ನೀವು, ಏನು ಇಲ್ಲ, ಎಷ್ಟು ಸುಲಭದಲ್ಲಿ ಸಮಯ ತಗೊಂಡು ಹೋದ್ರು, ಏನು ಕೇವಲ ಪ್ರಾಮಾಣಿಕ, ಬೇರೆದೇನು ಅಲ್ಲ. ಇಲ್ಲಿ ಬರ್ತಾ ಇರೋದು ಚತುರತೆ. ಚತುರತೆ ಪದ ಗೊತ್ತು ತಾನೆ ತಮಗೆ? ಇಲ್ಲ. ಕನ್ನಡ ರತ್ನಕೋಶ ನೋಡಿ ಇದೆ. ಹಾ, ಹೇಳಿ ಎಷ್ಟು ಕಾಸ್ಟ್ ಹಾಕ್ಲಿ, ಕೊಡಬಲ್ಲೆ 1 ವಾರ ಸಮಯ. ಆನ್ ಕಾಸ್ಟ್ ಯು ಡಿಸೈಡ್ ದಿ ಕಾಸ್ಟ್.
accepting impose 2,000 for 1 week.
The counsel for the appellant prays for a week's accommodation. Considering the reason shown by him as a final last chance, a week's time as spread is granted, making it clear that in case if the office objections are not complete in their entirety, the court would proceed to pass appropriate order, including dismissal of the appeal for non-compliance of office objection. If office objections are not complied in their entirety, registry to list the matter on year two. No cost. Okay.
Number 27, Kamal Charan.
None appear similar to 20. Yes.
Then number 28, Siddharth Bimchandi.
Same order.
Number 29, V.V. Mohan.
Same order.
Then number 30, Aditi MB.
Same order.
Then number 31, Rajeshwar PN.
Question is with respect to the production of the OS decree copy. Inadvertently, when it's connected OS decree copy is filed and signed. I request for 2 days time. The other office, the remaining
Request
office.
of the learned counsel for the appellant has filed in 3 days time is granted to comply of this objection, filing which so. List the matter on 2/6 if not complied.
Then number 32, Melanie Sebastian.
Draw the.
You are withdrawing.
It's right.
File a memo.
I'll file a memo. with the- Or it may be
You can
passed.
file here. Will pass over, file a memo. Memo to be signed by the concerned counsel who has executed the work.
Yes.
The matter is passed over. At the request of the learned counsel for the appellant to enable him to file a memo of not pressing the appeal, as decided by him.
Then number 33, Purumbaya DA.
Are you sure within a week you could able to comply one office objection among 8? If you undertake with a peremptory order, I will grant you 1 week.
Can you grant me 2 weeks?
On cost.
2 weeks,
On cost.
1 week without customary.
1 week, no cost.
Yes, please. Yes.
1 week.
Yes.
Yes. The counsel for the appellant prays for a week's time to comply of his objection. Considering the fact that several and sufficient opportunities have already been granted to him to comply of his objection, as a final last opportunity, that time as prayed is granted. However, making it clear that in case if the office objections are not complied within a week from today,
Please.
The appeal stands dismissed on its own without any further orders by this court with effect from 1/6/2023.
Please.
Still number 34, Azam. Still number 34, Mehtaram Azam.
Similar to.
Still number 35, Sridhar P.
Course of the day. I'll pass out the matter. I'll pass out the matter. We complete the office of the course of the day.
Learned counsel for the opponent submits that needful will be done during the course of the day. Making it clear that in case if the office objections are not complied, the court may proceed to pass appropriate order, including dismissal of the appeal for non-prosecution as a last chance. The time as paid is granted. In case if the office objections are not complied, registry to list this matter on 25.
Still number 36, Venkatramana.
Also made an attempt on here to occasions because their column A has to be changed. We need to not press the IA and find subsequently with a proper.
Learned counsel for the appellant who is physically present submit that he would not press A2/2019. In view of the same, they said A2/2019 stands disposed of as not pressed. Registry to proceed further.
Still number 37, Rashid Khan.
It is really bad. In completely come. It is.
The request of the learned counsel for the appellant has finally 3 days time as paid is granted to comply of his objection. As a last chance, final bid as a last chance. In case of office objection not complied, etc., list on 2/6 years.
Still number 38, N.K. Ramesh.
Still up to 20.
Still number 39, Anand.
Similar to 20.
Still number 40, Saraswati C.
Similar to 20.
Still number 41, S.R. Deshpande.
Similar to 20.
Still number 42, Devraj A.
And counsel for the appellant neither present physically nor through video conference. No reasons are forthcoming for non-appearance of learned counsel for the appellant. The result of the order sheet would go to show that in this appeal of the year 2019, in spite of granting several insufficient opportunities of not less than 4 times, the appellant has not complied of his subsection. A look at the office objection which are yet to be complied with will go to show that they are too simple in their nature, like mentioning the present age and clarifying the discrepancy in the address of the appellant, mentioning the correct provision of law with respect to the payment of court fee. For these 3 simple office objections, the appellant has taken enormous time in this appeal of the year 2019. As such, I do not find any reason to grant further time. That too, when the learned counsel for the appellant himself has remained absent. Accordingly, the appeal stands dismissed for non-prosecution as well as for non-compliance of office objections.
Number 43, G.K. Shivaprakash.
Not 20, but date 16. Yes.
Number 44, G. Vasanti.
Good. The counsel for the appellant who is physically present files a memo stating that the parties have settled the matter amicably out of court. As such, the appeal be dismissed as not pressed. In view of the memo supporting submission, the appeal stands dismissed as not pressed.
Bill number 45, M. Ashwathan Reddy.
Counsel for the appellant neither present physically nor through video conference. No reasons are forthcoming for his non-appearance. The result of the order sheet would go to show that in this appeal of the year 2019, despite being granted with sufficient opportunities, the appellant has not complied with his objection. Not less than 4 adjournments were granted, enable the appellant to comply with his objection. In one such instance, on 5/4/2021, this court had directed the learned counsel for the appellant to file an affidavit explaining reasons for non-compliance with specific reference to office objection from the date of raising of office objections till expiry of the further time granted by the order passed on that day. Despite such a direction, also the learned counsel for the appellant has neither filed the affidavit nor complied with the office objection. He has not even shown any reason for non-compliance even today also. Hence, I do not find any reason further granting time. Accordingly, the appeal stands dismissed for non-prosecution as well as for non-compliance of office objection. Yes.
Number 46, Satyananda.
Order, direction to file affidavit dated 31/3/2021. Yes.
Till number 47, Shivkumar DM.
Till 43, yes.
Till number 48, Siddhappa.
Request of the Lieutenant Counsel for the appellant as a final last opportunity, a week's time as period is granted, making it clear that in case of the office objections are not completed within time, the court may proceed to pass appropriate order, including so and so, if not complied. 5/6.
Till number 49, Rajeshwara PN.
So 3 days time, with the delay in filing the file an application. The final objections cannot and complaint will be.
So final last chance. 4 days, failing which 2/6. Please.
Serial number 50, Manjunath P.
Similar to 46, direction dated 7/4/21.
Till number 51, Vijay Krishna Bhatt.
Of decree and valuation. Objection. Clear circumstances. Was filed for challenging the sale deed or possession. While evaluating the relief declaration, as per the.
They are not completed the direction dated 7/4/2021.
Explaining the reason. Subsequently, I have complied the other objections about
That it did not exonerate you from obligation to file or duty to file. So it, since it was a judicial direction,
will file it. Will file it.
have you complied all of his objections?
Except, my lord, the production of decree and question of valuation.
How many days you want at the rate of ₹500 per day?
Regarding that, I filed a memo, my lord, that may kindly be considered. Because any of the impugned the judgment, a decree is not drawn by the trial court. On the issue of valuation was considered along with the main, that is the subject matter of challenge in this appeal. And the trial judge has not quantified the valuation also. I draw your lordship's attention to.
No, which is the relevant office objection in that regard?
Objection number 2, certified copy of the decree to be filed. If deficit court fee paid by the plaintiff. That is one thing. And secondly,
No, probably that office objection is not being reflected here, what you are reading.
attend from the computer. My lord. Initial objections.
That it appears that the registry has taken your memo on record.
Please.
It has confined the office subjection about non-filing of an affidavit for explaining the reason for non-compliance of office subjection raised on office as per court order dated 7/4/2021. Non-compliance of the above office subjection number 1 stated above, not stating of detailed and correct memo of valuation as per chapter 6, rule 2(7) of High Court. So what you are referring to is the previous office subjection. You filed a detailed memo to that effect and they have considered the memo. And these objections you have not complied with, which is independent of your memo And the previous office objection at serial number 6.
I shall do it within 2 days.
500 rupees per day. Because I had to spend so much of time for your job.
Evaluation, we have filed a valuation memo. I shall see whether there is any further.
ಮಾಡಿ ನೀವು ಏನ್ ಮಾಡ್ಬೇಕು ಮಾಡಿ 500 rupees per day. ಕೊಡ್ತೇನೆ 2 days ಟೈಮ್ ಕೊಡ್ತೇನೆ. ಇಷ್ಟೊತ್ತು ಏನು ಅಂತ ನಾನ್ ನಿಮಗೆ ಕ್ಲಾರಿಫೈ ಮಾಡ್ಬೇಕಾಯ್ತು, ಇದು ನೀವೇ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ನೀವು ಮುಗಿದು ಹೋಗಿದ್ದು ನಿಮ್ಮ ಮೆಮೊ, ಅವ್ರದ್ದು ಅಬ್ಜೆಕ್ಷನ್, ಅದನ್ನೇ ನೀವು ಮತ್ತೆ ಹೇಳಿದ್ರೆ, ಹಾಗಾಗಿ ನಾನು ಇಷ್ಟೊತ್ತು ಹುಡುಕಿದೆ ಅದನ್ನ.
Valuation ಬಗ್ಗೆ objection. I thought this is the objection.
ನೀವು ಮತ್ತೆ ಆರ್ಗ್ಯೂ ಮಾಡ್ತಿದ್ದೀರಿ, ಈಗ ಅದು ಕಾಸ್ಟ್ ಬಹುಶಃ 600 ರೂಪಾಯಿಗೆ ಏರ್ಬಹುದು.
ತಾವು ಹೇಳಿದಾಗ ನಾನು ನೋಡ್ಬೋದು.
At the request of the learned counsel for the appellant, as a final last opportunity, 2 days time as paid is granted to comply office objection. By which the court will proceed to pass so and so 26. Yes.
Number 52, Rashid Khan.
Within date, same address possibly, serial number 14, Your Lordship, same appellant. Antonym, 14, serial number 14. Right, and his LRs not showing any inclination to the mark.
ತೋರಿಸ್ತಾ ಇಲ್ಲ.
Right.
Same person, na?
Same person.
Similar to 14. Yes.
Serial number 53, Channabasappa SN.
To 46. The direction dated 8/4. Yes.
Serial number 54, Girish Hegde.
Lord, I represent the appellant, please. I request a week's time. And the principal objection is, my lord, at office objection number 4 and 6 regarding valuation. To submit fairly, my lord, I had not gone through the office objections earlier. And the second set needs to be filed since the valuation exceeds 15 lakhs is the one. The next is, my lord, typed a copy of OS and judgment and decree. But I request, my lord, a 1 week time, please.
What office objection you read out are not the office objection that are due for complaints, except filing the typed copy of OS judgment.
And apart from it, there are other office objections.
Other 3 office objections are there.
Please.
None of them are the office objections which you just now stated.
No, my lord, main office objections I refer to your lordships. Apart from this, there are 6 office objections, please. The office objection number 4 and 6 regarding the valuation and typed copies.
You are referring to RFA number 1616 of 2019.
Please, ma'am.
It appears that at no point of time, the total number of office objection raised by the registry has crossed serial number 4. Then how come office objection serial number 6 arises?
I, my lord, fairly, to submit fairly, my lord, I had not gone through any of the office objections.
Exactly. That is why you are wasting the time. Then 500 rupees per day.
And it's computer generated, otherly noted there are 6 serial number and other
ಹಾಗಾಗಿ ಹಾಗಾಗಿ ನಿಮಗೆ ನಾನು ಇಷ್ಟೆಲ್ಲ ಹಿಂಟ್ ಕೊಟ್ಟರು ಕೂಡ ಅಂತ ಗಂಭೀರವಾಗಿದ್ದಿಲ್ಲ ಅಂತಂದ್ರು ಕೂಡ ನೀವು ಮತ್ತೆ ಹಳೆದನ್ನೇ ಹೇಳ್ತಿದ್ದೀರಿ. Acknowledgement for having served copy to KV8 are to be filed. Designation of trial court to be stated correctly in synopsis. Schedule to be stated correctly in IA. Typed copy of OS judgment to be filed are the only 4 office objections. 500 rupees per day. How many days you want, including during the course of the day?
3 days. 4 days make it.
4 days ಬೇಕಾಗ್ತದೆಯೇ ಇದಕ್ಕೆ? Your client is rich.
Lord, it is regarding.
The appellant has a final last opportunity. 4 days time is granted. However, on a cost of rupees 500, payable by the appellant to the Legal Services Committee of this court within a day from today and filing a complaints memo along with receipt to that effect within the said time. It is made clear that in case if the office objection not complete, etc., 26. 500 rupees cost 4 days time. Yes, Madi.
Cell number 55, Chandrasekhar.
500 rupees total cost.
Please.
Connect to serial 53. Affidavit dated 15/4/21. Yes.
56, Narayan Swami.
During the course of the day ಮಾಡೋದು ಬಹುಶಃ ನಿಮಗೆ ಕಷ್ಟ ಆಗ್ತದೆ. ಹಾಗಾಗಿ 200 rupees per day ಪ್ರಕಾರ ನಿಮಗೆ ಸ್ವಲ್ಪ ಸಮಯಾವಕಾಶ ಕೊಡಬಲ್ಲೆ.
3 days.
3 days ಅಲ್ಲಿ ಆಗುತ್ತೆ. At the request of the learned counsel for the appellant as an ultimate opportunity. 4 days time is granted. Lucky similar to serial number 54. 500 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಕಟ್ಟಿ 4 ದಿವಸ ಕೊಟ್ಟಿದ್ದೇನೆ ಟೈಮ್ ಮಾಡಿ ಕಾಸ್ಟ್ ಇವತ್ತೇ ಕಟ್ಟಿ ಲೀಗಲ್ ಸರ್ವಿಸಸ್ ಅಥಾರಿಟಿ ಮೆಮೊ ಹಾಕಿ ಅದನ್ನ ಕಂಪ್ಲೇಂಟ್ಸ್ ಮೆಮೊ. ಎಸ್
57, Lankesh.
The counsel for the appellant has remained absent. Is neither appearing physically nor through video conference. In spite of granting several and sufficient opportunities of not less than 4 times, the appellant has complied the office objection in this appeal of the year 2019. The perusal of the order sheet would go to show that the office objections. The perusal of the order sheet would go to show that on 16/4/2021, the appellant was directed, the learned counsel for the appellant was directed to file an affidavit explaining the reasons for non-compliance with specific reference to the office objections from the date of raising of office objections till the expiry of further time granted by the order passed on the said day. In spite of the same, the appellant has neither filed the affidavit. In spite of the same, the learned counsel for the appellant did not file the affidavit. The appellant also has not complied with the office objection. Still, as a last chance, 1 more week's time was granted on 24/11/2021. The appellant did not make use of the same. On the other hand, he has remained absent both on 24/11/2021 and even on today also. This clearly go to show that the appellant is not evincing any interest in prosecuting the matter and also to comply office objection. Accordingly, the appeal stands dismissed for non-prosecution and also for non-compliance of office objection.
Number 58, Krishna City.
Paralysis ಆಗಿದೆ, ಕೋರ್ಟ್ ಫೀಸ್ 9 ಇದೆ, ಅಪೆಲೆಂಟ್ಗೆ ಪ್ಯಾರಾಲಿಸಿಸ್ ಆಗಿದೆ, ಬೆಡ್ ರೆಸ್ಟ್ ಇದ್ದಾರೆ, ಅವ್ರು ಬರಕ್ಕಾಗ್ಲಿಲ್ಲ ಆಫೀಸ್ಗೆ, ಅದಕ್ಕೋಸ್ಕರ ಇವತ್ತು ಇಂಟಿಮೇಷನ್ ಮಾಡಿದ್ರೆ ಆಯ್ಸ ಬರ್ತಿದೆ ಅಂತ ಹೇಳಿ ಅದಕ್ಕೋಸ್ಕರ 3 days ಟೈಮ್ ಇದ್ದಿದ್ದಾರೆ.
2,000 rupees cost. 19/4/2021 ಗೆ ನಿಮ್ಗೆ ಕಾಸ್ಟ್ ಹಾಕಿತ್ತು, ನೀವು ಕಾಸ್ಟು ಕಟ್ಟಲಿಲ್ಲ. ಅದ್ರ ಬಗ್ಗೆ ಯಾವ ಸೊಲ್ಲು ಎತ್ತಲಿಲ್ಲ. ಕಟ್ಟಿದ್ದೇನೆ ಅಂತಲೂ ಹೇಳ್ತಾ ಇಲ್ಲ, ಕಟ್ಟಿಲ್ಲ ಅಂತಲೂ ಹೇಳ್ತಾ ಇಲ್ಲ. ಅದನ್ನ ಹಾಗೆ ಬಿಟ್ಟು ನೀವು ಮುಂದಿನದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ಹಾಗಾಗಿ 1,500 ರೂಪಾಯಿ. 3 ದಿವಸ ಸಮಯ ಕೊಡ್ಲಿಕ್ಕೆ 500 ರೂಪಾಯಿ, ಒಟ್ಟು 2,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್. ಅಲ್ಲ, ಅದು ಹೌದು, ಅದು ನಾನು ಹೇಳಿದ್ರ ಮೇಲೆ ನೀವು ಹೇಳ್ತಾ ಇದ್ದೀರಿ. ದಟ್ ಇಸ್ ನಾಟ್ ಎ ರೆಮಿಡಿ. ಪ್ರಾಮಾಣಿಕತೆ ಅನ್ನೋದು ಫಸ್ಟ್ ಇಂದ ಏನ್ ಮಾಡೋದಿರ್ತದೆ ಅದನ್ನ ಫಸ್ಟ್ ಹೇಳ್ಬೇಕಾಗ್ತದೆ. ಸ್ವಾಮಿ ಇಷ್ಟು ಕಾಸ್ಟ್ ಹಾಕಿದ್ರಿ, ನಾನು ಅದನ್ನ ಈಗ ಕಟ್ಟಿದ್ದೇನೆ, 2 ವರ್ಷ ಡಿಲೇ ಆಗಿ ಕಟ್ಟಿದ್ದೇನೆ. ಕಾಸ್ಟ್ ಕಟ್ಟಿದ ನಂತರವೂ ಕೂಡ ನನಗೆ ಕಾಂಪ್ಲೈ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗ್ತಾ ಇಲ್ಲ ಈ ಕಾರಣದಿಂದ. ಎಕ್ಸಲೆಂಟ್, ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೋದು. ಅಂತದೇನಿಲ್ಲ, ಹಳೇದನ್ನೆಲ್ಲ ನಾವೇ ಹುಡುಕಿ ತೆಗೆದು ನೋಡಿ ಹೇಳಿದ್ರೆ ಮಾತ್ರ ಅದು ಬರ್ತದೆ, ಇಲ್ಲ ಹೊರಗಡೆ ಬರಲ್ಲ. ಅದಕ್ಕೆ 1,500. 3 ದಿವಸ ಟೈಮ್ ಕೊಡ್ತೇನೆ, 500. ಎಸ್, counsel for the appellant who is physically present without even whispering about the payment of the cost ordered on 19/4/2021 prays for 3 more days time to comply office subsections, citing some medical inconvenience on the part of the appellant. The court had expected him to make his first submission about the payment of the cost ordered on 19/4/2021. It is only after the court brought the same to his notice he submits that he has just now paid the said cost. Admittedly, it is more than 2 years after the order of the payment of the said cost. He is reporting the complaints. Admittedly, the office objections which are yet to be complied with and runs into a large number of not less than 9 have not yet been complied with. Accordingly, granting 3 days time would be only on cost. Accordingly, as such, imposing a cost of ₹1,000 payable by the appellant to the Legal Services Committee of this court within a day from today and filing a complaints memo along with original receipt to that effect in the registry within the said time. 4 days time is granted as a last chance to comply office objection. It is made clear that registry to permit the compliance of office objection only after ensuring the payment of the cost ordered today. In case if office objections are not complied within the time granted, the court may proceed to pass the appropriate order, including dismissal of the appeal for non-compliance. If the office objections are not complied with, the registry to list this matter on 5/6. Yes.
Number 59, Krishna T.
ಯಾವ ಕಟ್ಟಿದಿರಿ? ಇವಾಗ ಕಟ್ಟಿದ್ರಿ, 1,500 ರೂಪಾಯಿ ಉಳಿಸಿದ್ರಿ ಮುಂದಿಂದು. Yes, other submission, please. What about the complaints of office objection? Next week, 200 rupees per day. How many days you want? Bari 200 rupees per day. You ನೋಡ್ತಿದ್ದೀರಿ, cost has gone up to 2,000 rupees per day. Normal cost is 500 rupees per day. For you, since you yourself said that the cost is paid though with a delay of 2 years, it is now reduced. A special discount is given and fixed at ₹200 per day. ಯಾಕೆಂದ್ರೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತದೇ ಇದೆ, ಗನಾಂದಾರಿ. all the papers to be stitched in. Only one file value stated to be removed. Provision for correct court fee to be mentioned. Any proof of trial court to be filed to verify the schedule. Delay days to be stated in an affidavit. Corrections carried out in cost title of the appeal to be carried out in cost title in IA. ಇಷ್ಟೇ. ಏನ್ ದೊಡ್ಡದಿದೆ ಆಫೀಸ್ ಸಬ್ಸೆಕ್ಷನ್ಸ್? ಇದನ್ನ ಕಾಸ್ಟ್ ಹಾಕಿದ್ರೂ ಕಂಪ್ಲೈ ಮಾಡಲಿಲ್ಲ. ಇಷ್ಟು ಸಿಂಪಲ್ ಫ್ರಿವಲಸ್ ಸಿಲ್ಲಿ ಆಫೀಸ್ ಸಬ್ಸೆಕ್ಷನ್ಸ್. ಆದ್ರೆ ಯಾವುದೇ ಸಂಕೋಚವಿಲ್ಲದೆ ಕಾಸ್ಟ್ ಹಾಕ್ತೇನೆ ಅಂದ್ರು ರೇಟ್ ಕಡಿಮೆ ಮಾಡಿ ಅಂತ ಕೇಳ್ತೀನಿ. ಖಂಡಿತವಾಗಿಯೂ ನಿಮ್ಮ ಕಕ್ಷಿದಾರರಿಗೆ ಆದಾಯ ಮೂಲಗಳು ಸಾಕಷ್ಟಿವೆ. ಹೇಳಿ ಎಷ್ಟು ದಿವಸ ಬೇಕೀಗ? 200 rupees per day ಕೊಡಬಲ್ಲೆ. ನಾನು ಯಾವ್ದ್ರಲ್ಲೇ ಏನೇ ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕಾದ್ರು, ಏನೇ ಟೈಮ್ ಹಾಕ್ಬೇಕಾದ್ರು, ಏನಾಗಿದೆ ಹಿಂದೆ, ಎಷ್ಟು ಆಪರ್ಚುನಿಟಿ ಕೊಟ್ಟಿದ್ದೇವೆ, ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ ಏನಿದೆ, ಎಲ್ಲದನ್ನೂ ನೋಡಿ. ಕೆಲವೊಮ್ಮೆ ಅವ್ರು 2 ದಿವಸ ಕೇಳಿದ್ರೆ 4 ದಿವಸ ಕೊಡ್ತೇನೆ, 2 ದಿವಸ ಕೇಳಿದ್ರೆ 1 ವಾರ ಕೊಡ್ತೇನೆ, ಕೆಲವೊಮ್ಮೆ 1 ವಾರ ಕೇಳಿದ್ರೆ 2 ದಿವಸ ಕೊಡ್ತೇನೆ. ಯಾಕೆಂದ್ರೆ ಯಾವ ಆಫೀಸ್ ಸಬ್ಜೆಕ್ಷನ್ ಎಷ್ಟು ಆಪರ್ಚುನಿಟಿ ಅಷ್ಟೂ ನೋಡ್ತೇನೆ. ನಾನು ಸುಮ್ಮನೆ ರ್ಯಾಂಡಮ್ ಆಗಿ ಮಾಡೋಲ್ಲ. ಎಲ್ಲದಕ್ಕೂ ಒಂದು ರೀಸನಿಂಗ್ ಇದೆ, ಯಾರ್ಡ್ ಸ್ಟಿಕ್ ಇದೆ. ಆ ಪ್ರಕಾರ ನಿಮಗೆ 200 rupees per day ಸಮಯ ಕೊಡ್ಬೇಕು. You are wasting the time of the court. Either the cost may increase or I may pass other order. One day.
2 days.
2 days. Peremptory order ಮಾಡ್ತೇನೆ. The counsel for the appellant submits that though with the delay she has filed a cost of ₹500 today morning. Cost of ₹500 ordered on 17/4/2021 only today morning. However, she further prays for a short accommodation to comply with subjection. In the light of the above circumstance, since the appellant has not completed the office subjection, despite imposing the cost, on the contrary, reports the payment of the costs and prays for some more time, though the appeal could have been dismissed for non-compliance, however, considering the request made as a final last opportunity, 2 days time as credit is granted, but with imposing a cost of ₹400 payable by the appellant to the Legal Services Committee of this court during the course of the day and filing memo, etc., etc., etc. It is made clear that in case if the office subjections are not complied within 2 days from today after payment of the cost, within 2 days from today, including the payment of the cost, the appeal would stand dismissed on its own for non-compliance. However, with the effect from 35 without any further orders by this court.
Serial number 60, Gopal and connected.
One objection.
ಇನ್ನೊಬ್ರು ಬಂದಿದ್ದಾರೆ ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಪುರ್ಸೊತ್ತಿಂದ ಓಡಿ ಹೋಗ್ತಾರೆ. ಮತ್ತೆ ಇಲ್ಲಿ ಸಾಹೇಬ್ರು ಕೂಡಲೇ ಇನ್ನೊಂದು ಕೊಟ್ಬಿಡ್ತಾರೆ ಡಿಟೇಷನ್. ಬ್ಯೂಟಿ ಆ ಚುರುಕ್ತನ ಬೇರೆದ್ರಲ್ಲಿ ತೋರಿಸ್ಬೋದಲ್ವ? ನಾವೆಲ್ಲ ನಮ್ಮ ಮಕ್ಳನ್ನ ಏನ್ ಹೇಳಿ ಬೆಳೆಸ್ತೇವ್ರಿ? ನೈತಿಕತೆ ವ್ಯಾಲ್ಯೂಸ್ ನಾವೇ ಅಂತ ಸರಿ ಪಾಲಿಸ್ದು ಹೋದ್ರೆ ನಮ್ಮಲ್ಲೇ ಸಣ್ಣ ಸಣ್ಣ ಟ್ರಿಕ್ಗಳು ಬುದ್ಧಿಗಳು ಇದ್ರೆ ಅಲ್ವಾ? ನಮ್ಮ ಪುರ್ಸೊತ್ತಲ್ಲಿ ನಮ್ಮನ್ನ ನಾವೇ ನಮ್ಮ ವರ್ತನೆ ನಾವು ಪರಾಮರ್ಶಿಸಿದ್ರೆ ನಗು ಬರ್ತದೆ. ಎಸ್ ಏನ್ ಹೇಳಿದ್ರಿ?
First matter ಅಲ್ಲಿ office subjection is raised on IA. Where correct. The other connected matter is for admission.
None appear in this matter either physically or through video conference. As a last opportunity, 3 days time is granted to comply with this objection, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance of office objection. In case if the office objections are not complied in their entirety, registry to, in case if the office objections are not complied, registry to list the matter on 1/6. Yes.
Serial number 61, Shivram HC.
Respondent number 6 was died, your lordship. With application that can't be put up, your lordship. 12th July 2021 itself. I think.
Who died?
R6, your lordship.
R6 died.
Yes, I filed an application on 12th July 2021, your lordship.
But before filing, before listing that application, is it not required the complaints of the office objection on the main appeal?
But I will check it out.
When the main appeal would become due for first hearing, the IS would be listed.
I think it was the only objection. I will look into that and I will do it.
200 rupees per day. Because that is not at all the objection. Objection is something different.
Will complain.
Yes, I will grant you time, 200 rupees per day. Yes. How many days you want? 2 days, yes.
Please, file, if I receive the file not immediately, I can. File ನಮ್ ಕೊಡ್ಬೇಕಾದ್ರೆ 2-3 ದಿನ ಆಗೋದು.
ಹೌದು, ಅದನ್ನ ನೀವು ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ದೀರಿ, ಅದನ್ನ ನಾನು ಅಲ್ಲಿಯೂ ಹೇಳಿದ್ದೇನೆ.
Office ಹೋಗುವಾಗ ಏನಾಗುತ್ತೆ?
ನಾನೊಬ್ಬನು ಹೊರತಾಗಿ ಬೇರೆ ಯಾರು ಹೇಳೋರಿಲ್ಲ. ನೀವು ಉಳಿದಿದ್ರಲ್ಲಿ ಎಲ್ಲದನ್ನು ಹೋರಾಟ ನಡೆಸುವವರು ನೀವು.
ಯಾವುದೇ ಕೋರ್ಟ್ ಏನಾಗುತ್ತೆ ಅಂತ ಪ್ರೊಸೀಜರ್ ಆಸ್ಪೆಕ್ಟ್ಸ್ ಇಲ್ಲಿ ಸೈನ್ ಆಗಿ ಬಂದು ಇಲ್ಲಿಂದ ಅವರು ಕಳಿಸಿ ಎಲ್ಲ ಟೇಕ್ಸ್ ಲಿಟಿಲ್
ಸಾಯಂಕಾಲದೊಳಗೆ ಫೈಲ್ ಅಲ್ಲಿ ಇರ್ತದ್ರಿ. ನಾನು ಮನೆಗೆ ಹೋಗುವ ಮುಂಚೆ ಎಲ್ಲದನ್ನು ಸೈನ್ ಮಾಡಿ ಹೋದವ್ರೆ ನನ್ನ ಸೆಕ್ರೆಟರಿಗಳು ಹೊರಗಡೆ ಹೋಗ್ಲಿಕ್ಕೆ ಬಿಡಲ್ಲ.
ತಾವು ಎಲ್ಲ ಮಾಡ್ಕೊಡ್ತೀರಿ ಸರ್. ವಾಟ್ ಐ ಆಮ್ ಸೇಯಿಂಗ್ ಇಸ್ ಪ್ರೊಸೀಜರ್ ಆಸ್ಪೆಕ್ಟ್ ಇಲ್ಲಿ ಬಂದ ಮೇಲೆ ಅವ್ರು ನೋಡಿ ಅವರು ರೆಕಾರ್ಡ್ ಕಳಿಸಿ ಅವರು ಸ್ಕ್ರೂಟಿನಿ ಮಾಡಿ ನಮಗೆ ಕೊಡುವಷ್ಟರಲ್ಲಿ ಟೆಕ್ಸ್ಟ್ ಡಿಲೇ ಅಂತ ಅಷ್ಟೇ. ಅದರ್ವೈಸ್ ಪ್ರೊಸೀಜರ್
ಇದು ಸಾಧನೆ ಹೇಳ್ಕೊಡ್ತೀರಾ ನಿಮಗೆ? ಬನ್ನಿ ಈ ಕಡೆ ಬನ್ನಿ, ನಾನು ಶಿಷ್ಯ. ಬರೀ 10 ನಿಮಿಷ ಅದೇನೇ ಆಗಿದೆ ನಿಮ್ಗೆ ನೋಡ್ಕೊಂಡು ನಾವು ಬೆಳೆದಿರೋ.
Who prays for 2 more days accommodation to comply of his objection. Considering the reason shown by him as a final last chance, 2 days time as spread is granted, making it clear that in case if the office objections are not complied in total, the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance. In case if office objections are not complied with, list the matter on 2/6. ಎಲ್ಲಿವರೆಗೆ ನಾವು ಇನ್ನೊಬ್ಬರು ಮಾಡಿದ್ದಕ್ಕೆಲ್ಲ ಅಯ್ಯೋ ಪಾಪ ಅಂತ ಹೇಳಿ ಹೋಗ್ತೇವೆ, ವ್ಯವಸ್ಥೆ ಸುಧಾರಣೆ ಆಗಲ್ಲ. ಅಯ್ಯೋ ಪಾಪ ಹೇಳುವಲ್ಲಿ ಹೇಳ್ಬೇಕು. ಹೇಳಬಾರದ ಪರಿಸ್ಥಿತಿ ಸನ್ನಿವೇಶದಲ್ಲಿಯೂ ಕೂಡ ನಾವು ಅಯ್ಯೋ ಪಾಪ ಅಂತ ಹೇಳಿ, ಅಯ್ಯೋ ಬಹಳ ಹ್ಯುಮ್ಯಾನಿಟಿ ಇದೆ ನನಗೆ, ನಾನೇನೋ ಮಾಡ್ತೇನೆ ಅಥವಾ ನಾನೇನೋ ಉದಾರತೆ ತೋರಿಸ್ತೇನೆ ಅಂತ ಹೇಳಿದ್ರೆ ಅದು ಹ್ಯುಮ್ಯಾನಿಟಿ ಅಥವಾ ಉದಾರತೆ ಅನ್ನೋ ಪದಗಳ ದುರುಪಯೋಗ ಆಗ್ತದೆ. ವ್ಯವಸ್ಥೆ ಸುಧಾರಣೆ ಆಗಲ್ಲ. ವ್ಯವಸ್ಥೆಯಲ್ಲಿ ಯಾರು ಸರಿಯಾಗಿ ಕೆಲಸ ಮಾಡಬೇಕು ಅವರು ಅಂತಹ ಅನುಕಂಪನೆ ನಿರೀಕ್ಷಿಸಿ ಅದಕ್ಕೆ ಒಗ್ಗಿ ಹೋಗ್ತಾರೆ. ದುರಂತ ನಮ್ಮಲ್ಲಿ ಅದು ಆಗ್ತಾ ಇದೆ. ಸಮಯ ಕೊಟ್ಟಿದ್ದೇನೆ ಮಾಡಿ.
Number 62, Prakash I am. Number 63, fifth time, Shivasharanappa.
The counsel for the opponent neither present physically nor through video conference. In this appeal of the year 2019, in spite of granting several insufficient opportunities of not less than 5 times the appellants had not complied with the office objection. On 12/4/2021, this court had granted a week's time to the appellant as a last chance to comply with his objection, however, imposing a cost of ₹5. Despite such an opportunity, the appellant has neither reported the payment of the cost, nor the complied with the office objection, nor even shown any reasons for non-compliance of office objection. Thus, it is a clear case where thus it can be inferred that the appellant is neither interested in complying the office objection nor prosecuting the matter. Accordingly, the appeal stands dismissed for non-compliance of office objection and for non-prosecution. Yes.
64, Narayana VS.
The counsel for the appellant not present. In spite of granting several sufficient opportunities of not less than 5 times, the appellant has not complied with his objection. As though the appeal could have been dismissed for non-compliance, however, in the best interest of justice. As a last chance, 3 days time is granted to comply with his objection, however, imposing a cost of ₹500 payable by the appellant to the Legal Services Committee of this court during the course of the day, and filing a compliance memo along with original receipt to that effect in the registry within the said time. In case if the cost is not paid and office objections are not complied within the time granted, the court would proceed to pass appropriate order, including dismissal of the appeal for non-compliance as well for non-prosecution. If office objections are not complied with, registry to list this matter on 2/6.
Number 65, T. Prakash.
kindly grant a quick help. Ready to very fast.
At the request of the learned counsel for the appellant. The last opportunity, a week's time as credit is granted, however, imposing a cost of ₹500. Payable by the appellant to the legal services committee of this court within a day from today and filing, etc., etc., etc. If not complied, court may proceed to pass appropriate order 5-6. ₹500 cost ಕಟ್ಟಿ ಮಾಡ್ತಾರೆ.
Number 66, Prakash BN.
ಕಾಸ್ಟ್ ಸ್ವಲ್ಪ ಜಾಸ್ತಿ ಆಗ್ತದೆ ವಕೀಲ್ರೆ. 3 days ಅಲ್ಲ, 1 ವಾರ ಕೊಡಬಲ್ಲೆ ₹1,000 ಕಾಸ್ಟ್.
Geologically, I could not obtain from the client. All other office objection I can apply. 3 days time to give the.
ನೀವು ನನ್ನನ್ನು ಓದಲಿಕ್ಕೆ ಪ್ರವೋಕ್ ಮಾಡಬೇಡಿ.
Please.
52 ಜನ ವಕೀಲರು ಇದ್ದಾರೆ. ಮೆಮೊರಾಂಡಮ್ ಆಫ್ ಅಪೀಲ್ ನಲ್ಲಿ ಗ್ರೌಂಡ್ ಇಲ್ಲದೆ ಅಪೀಲ್ ಹಾಕಿದ್ದೀರಿ. ಒಂದು ಲಾ ಫರ್ಮ್ ಮಾಡೋದೇ ಇದು. ಬರೀ ಫ್ಯಾಕ್ಟ್ಸ್ ಹಾಕಿದ್ದೀರಿ, ಪ್ರೇಯರ್ ಕೇಳಿದ್ದೀರಿ. ನಾನು ಹೇಳ್ಬೇಕಿದೆ. ಪಿನ್ ಕೋಡ್ ಇಲ್ಲ, ಪೇಜಿನೇಷನ್ ಇಲ್ಲ, ಇಯರ್ ಆಫ್ ಡಿಸ್ಪೋಸಲ್ ಇಲ್ಲ. The request of the learned counsel for the appellant. As a final last opportunity, serial number 64 they ಮಾಡಿ ₹500 cost custody legal services authority within a day. 1 week time ಕೊಟ್ಟಿದ್ದೇನೆ. 2/6 ಬರ್ತದೆ, ಅಷ್ಟರೊಳಗೆ ಮಾಡಿದ್ರೆ ಉಂಟು. Yes.
Number 67, Ananda.
None appear for the appellant either physically or through video conference. No reasons of forthcoming for non-appearance of learned counsel for the appellant. The perusal of the order sheet would go to show that in this appeal of the year 2019, in spite of granting several insufficient opportunities of not less than 5 times, the appellant has not complied with the office objection. Several opportunities, including final opportunity and the last chance, were all given to the appellant to comply office objection, which he did not make use of. The office objection, which are yet to be complied with, inter alia include requirement to file IA for condonation of delay, filing of typed copy of the decree, correctly mentioning the address of the party, mentioning the date of disposal, etc. For these trivial office objections also, the appellant has taken enormous time, running into several years to comply. Furthermore, the learned counsel for the appellant also has remained absent today without even appearing through video conference and showing the reason for non-compliance. Hence, I do not find any reason to grant any further time. Accordingly, the appeal stands dismissed for non-compliance of office objection and for non-prosecution. Yes.
Number 68 in Jayaprakash Rao.
For each time.
₹200 per day. The learned counsel for the appellant prays for a week's time to comply with his objection. Considering the fact that sufficient opportunities even as final and for not less than 5 times the opportunities were already granted to him, granting any further time, though as ultimate opportunity would be only at cost. Accordingly, imposing a cost of ₹1,000 payable by the appellant to the Legal Services Committee of this court within 3 days from today and filing a complaints memo, etc., along with the receipt, etc. As an ultimate opportunity, a week's time is granted to comply. In case if the office objections are not complied within the set time, registry to list the matter on 5/6. Yes.
Bill number
On this day,
16.
the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance.
Number 69, dear suspect.
Please, Lord, I pray for 2 weeks. Of course, there are a number of objections. The appellant died, LRs were brought, the LR husband also died. I am unable to contact them. On the Advara minimum cost negative.
ಅವರೇ ನೀವು ನಾನು ಲಾ ಮಾಡ್ಬೇಕಾದ್ರೆ ಏನ್ ಸಬ್ಮಿಷನ್ ಹೋಗಿ ಮಾಡ್ತಾ ಇದ್ರು ಆಗಿನ ಕಾಲದ ಸಬ್ಮಿಷನ್ ಟೈಮ್ ಕುರಿತಂತೆ ಮಾಡ್ತಾ ಇದ್ದೀರಿ. ಒಂದ್ 2 ವಾರ ಟೈಮ್ ಕೊಟ್ರೆ ಸಾಹೇಬ್ರೆ ಮಾಡಿಬಿಡ್ತೀವಿ. ಈಗ ಕಾಲ ಬದಲಾಗಿದೆ ನೋಡಿ, ಎಲ್ಲದೂ ಬದಲಾಗಿದೆ. ಈಗ ನೀವು ಲೀಗಲ್ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ಸ್ ನ ರೆಕಾರ್ಡ್ ಮೇಲೆ ತಂದಿಲ್ಲ ಅನ್ನೋದು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲ. ಆ ಪಾಯಿಂಟ್ ಇನ್ನೂ ಬಂದಿಲ್ಲ.
ಅದಕ್ಕೆ ಸಂಬಂಧ
ಅಲ್ಲಿರೋದು ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ಟು ಬಿ ಸ್ಟೇಟೆಡ್ ಕರೆಕ್ಟ್ಲಿ, ಪ್ರೇಯರ್ ಪ್ಯಾರಾ ಟು ಬಿ ಸ್ಟೇಟೆಡ್ ಕರೆಕ್ಟ್ಲಿ, ವ್ಯಾಲ್ಯೂ ಆಫ್ ದ ಸಬ್ಜೆಕ್ಟ್ ಮ್ಯಾಟರ್ ಟು ಬಿ ಸ್ಟೇಟೆಡ್ ಇನ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಪ್ಯಾರಾ. ಇದಕ್ಕೆ ಏನಾದ್ರೂ ನಿಮ್ಮ ಕಕ್ಷಿದಾರನ ನೀವು ಕನ್ಸಲ್ಟ್ ಮಾಡ್ತಕ್ಕಂತ ನೆಸೆಸಿಟಿ ಬರ್ತದೆಯೇ? ಇಲ್ಲ, ನಿಮ್ದ ಜೂನಿಯರ್ ಹೇಳಿದ್ರೆ ಅವರು ಕರೆಕ್ಟ್ ಪ್ರಾವಿಷನ್ ಆಫ್ ಲಾ ನೋಡಿ ಹಾಕಿ ಬಿಡ್ತಾರೆ. ಅದಕ್ಕೆ 2 ವಾರ ಬೇಕೇ?
ಒಂದ್ ವಾರದಾಗ ಮಾಡಿಸ್ತೇನೆ. ಅವು ಮಟೀರಿಯಲ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಬಂದಿಲ್ಲ. ಟು ಬಿ
ಆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ನಿಮಗ್ ಬಿಟ್ಟಿದ್ದು ಅಲ್ವೇ? Request of the learned counsel for the appellant as a final last opportunity, 10 days time as pledge is granted, making it clear that no further adjournment will be granted in this matter of the year 2019. In case if the office objections are not complied in total, list this matter on 7/6. 10 ದಿವಸ ಕೊಟ್ಟಿದ್ದೇನೆ, ಎಲ್ಲದನ್ನು ಮಾಡಿ.
Please.
70, Gangadhar Aital.
Appellant, my lord. I had not go to over 6 months due to my condition. Operation I do 2 times, heart attack I do. Now I want 10.
ಅಷ್ಟು ಗಟ್ಟಿ ಮಾತಾಡ್ಬೇಡ್ರಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಂತಿದ್ದೆ. ನೀವು ಸಿಟಿ ಕೋರ್ಟ್ ನಲ್ಲಿ ಇದ್ದಾಗಿಂದಲೂ ಹೆದರಿಸ್ತಿದ್ದೀರಿ ಎಲ್ಲರನ್ನು. ಗಟ್ಟಿ ಮಾತಾಡಿ. ಹಾರ್ಟ್ ಅಟ್ಯಾಕ್ ಆಗದೆ ಇನ್ನೇನಾಗ್ತದೆ ಹೇಳಿ. ಈಗ ಹೇಗಿದೆ ಆರೋಗ್ಯ?
ಈಗ ಪರವಾಗಿಲ್ಲ.
ಎಷ್ಟು ಸಮಯ ಬೇಕು ಹೇಳಿ?
ನಮ್ಗೊಂದು 10 days ಕೊಡಿ. ನಾನು
ಹೆಚ್ಚು ಮಾತಾಡ್ಬೇಡಿ, ಕೂತ್ಕೊಳ್ಳಿ ಕೊಡುವ.
ಅಲ್ಲ, 1 second. ಯಾಕೆ ಗೊತ್ತಂದ್ರೆ ಜೂನಿಯರ್ಸ್ ಎಲ್ಲ ಜುಡಿಷಿಯರಿಗೆ ಹೋಗ್ಬಿಟ್ರು. ನನಗೆ ಐ ಕುಡ್ ನಾಟ್ ಕಮ್ 6 months ಇಂದ ವರ್ಚುವಲಿ ಅಬ್ಸೆಂಟ್.
ಇಟ್ಸ್ ಅ ಪ್ರೈಡ್ ಫಾರ್ ಯು. ಅದು ನಿಮ್ಮ ಹಿರಿಮೆ. ಜೂನಿಯರ್ಗಳು ಎಲ್ಲರೂ ನ್ಯಾಯಾಧೀಶರನ್ನಾಗಿ ಮಾಡಿದ್ದೀರಿ ಅಂತ ಹೇಳಿದ್ರೆ
ಆದ್ರೆ ಏನ್ ಮಾಡೋದು? ನನಗೆ ಕಷ್ಟ ಆಯ್ತಲ್ಲ, ಹಿರಿಮೆ ಕಟ್ಕೊಂಡು ಏನ್ ಮಾಡ್ಲಿ? ಈಗ ನೀವು ದೊಡ್ಡ ಹಿರಿಮೆ ತೋರಿಸಿ ನನಗೆ ಒಂದು 10 days ಕೊಡಿ. ನಾನು ಯಾರಿಗಾರು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತೀನಿ. ಬಹಳ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಇರುತ್ತೆ ಅದರಲ್ಲಿ.
ಇಲ್ಲ, ಕಡಿಮೆ ಇದೆ ಮಾಡುವುದು ಮಾಡಿ. At the request of the learned counsel for the appellant,
ನೀವು ಕಾಸ್ಟ್ ಹೆಚ್ಚಿಗೆ ಹಾಕ್ಬಿಡಿ. ನಾನು ಕಾಸ್ಟ್
final opportunity. ಆಮೇಲೆ ಗಣೇಶ ಬರ್ತಾನೆ, ನಾನೇನ್ ಮಾಡ್ಲಿ? Final opportunity, 10 days time is granted to comply of his objection as prayed, failing which ಅದನ್ನೆಲ್ಲ ಹಾಕಿ previous order ಹೊಸಮತ್ ಅವ್ರದ್ದು ಏನಿದೆ ಅದನ್ನ ಇದನ್ನು ಮಾಡಿ. ಎಸ್ 7/6 ಬರ್ತದೆ, ಅಷ್ಟೊಳಗೆ ಕಂಪ್ಲೈ ಮಾಡಿ. ಹೋಗ್ಬೇಕು.
Serial number 71. 71, deep open.
Not 43.
Cell number 72, Joseph Anil Kumar.
The request of the learned counsel for the appellant as an ultimate opportunity, though a week's time is granted to comply, however, imposing a cost of rupees 1,000 payable by the appellant to the legal services committee of this court within 2 days from today, and filing a complaints memo along with original receipt within the set time in the registry to that effect. In case if the office objections are not complied with, publish this matter on 5/6, on which day the court may proceed to pass appropriate order, including dismissal of the appeal for non-prosecution, non-compliance. Yes.
Cell number 73, Marilingegoda.
My lordship, I am appearing for a petitioner appellant in this case, my lordship. I am seeking for a 1 week time to comply the office objection, my lordship. There are 13 objections are remaining. Seeking a 1 week time to comply all the office objection, my lordship.
It's not that 13 objections are remaining. 13 objections were the only objections raised by the registry from its inception, which have never bothered
Yes,
to
my
comply even a single one, including pagination and filling up the blanks.
My lordship, I seeking 1 week time to comply all the office objection, my lordship.
200
My
rupees
humble
per day.
request.
I grant you time. 200 rupees per day. How many days you want? Even more number of days also can be granted.
My lordship, I 1 week time be granted, my lordship.
1 week means 7 into 200, 1,400 rupees. You pray for any discount? Monsoon rebate?
Week time.
Number 69 ಹಾಕಿ 10 days time ಮಾಡಿ ಇದನ್ನ ಕಾಸ್ಟ್ ಹಾಕಿ 1,000 rupees ಕಾಸ್ಟ್ LSC within 3 days from today. In case if not complied, 7/6 1,000 rupees ಕಾಸ್ಟ್ ಕಟ್ಟಿ 2 ದಿವಸದೊಳಗೆ 10 ದಿವಸ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೇನೆ. ಕಂಪ್ಲೈ ಮಾಡಿ ಸಣ್ಣ ಸಣ್ಣದಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೈ ಮಾಡಬಹುದು.
74, Sachin PS. Cell number 74.
ಯಾವಾಗ ಯಾವಾಗ ಮಾಡ್ಬೇಕಿತ್ತು ನೀವು ಅದನ್ನ ಅಲ್ವೇ? ಅದು ಸಂತೋಷ. ಉಳಿದಂತೆ ನಾವು ನಾನ್ ಕಾಂಪ್ಲೆನ್ಸ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಬಹುದೇ? ಅಪೀಲು ಕಾಸ್ಟ್ ಹಾಕಿದ್ರೆ ನಿಮ್ಗೆ ಟೈಮ್ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮತ್ತೆ ಕೊಡ್ತೇವೇನು ಅಶೂರೆನ್ಸ್ ಅಲ್ಲ ಅದು. ಅಲ್ಲಿವರೆಗೆ ನೀವು ಮಾಡದೇ ಇರೋದಕ್ಕೆ ಕಾಸ್ಟ್ ಹಾಕಿ ನೆಕ್ಸ್ಟ್ ಡೇಟಿನೊಳಗೆ ಮಾಡಿಯಪ್ಪ ಅಂತ ಕೊಡೋದು. ಅದಾದ್ರ ಮೇಲೂ ಬಹಳಷ್ಟು ಸಮಯ ಬಿಟ್ಟು ಒಂದು 5 ಡೇ ಬಂದು ಸ್ವಾಮಿ ಯಾವಾಗ್ಲೂ ಹಾಕಿದ ಕಾಸ್ಟ್ ಇವತ್ತು ಕೊಟ್ಟಿದ್ದೇನೆ ಅಂತ ಹೇಳಿ ಆಸ್ ಎ ಮ್ಯಾಟರ್ ಆಫ್ ರೈಟ್ ಮತ್ತೆ ಟೈಮ್ ಅಂತ ಕೇಳಲಿಕ್ಕೆ ಬರೋಲ್ಲ. ಅದು ಪ್ರಪಂಚದಲ್ಲಿ ಯಾರಾದ್ರೂ ಮಾಡಿದ್ರೆ ವಕೀಲರು ಮಾತ್ರ, ಬೇರೆ ಯಾರು ಹಾಗೆ ಮಾಡಲ್ಲ.
2 days. 2 days.
ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ತೀರಿ? ಕಾಸ್ಟ್ ಎಷ್ಟು ಹಾಕ್ಲಿ? The counsel for the appellant submits that he has paid the cost imposed on 13/12/2022 today, and once again prays for 3 days accommodation. Though no convincing reason are shown, no convincing reasons are appearing to grant further time. However, in the best interest of justice, as a ultimate opportunity, 3 days time as paid is granted, making it clear that in case if the office objection in their entirety are not complied within the said time, the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance of office objection. If office objections are not complied in their entirety, list this matter on 2/6. Cost hakilla 3 ದಿವಸದೊಳಗೆ ಕಂಪ್ಲೇಂಟ್.
75 Ashok Kumar.
All
Hmm.
week time may be granted.
ಯಾಕ್ರಿ?
ಸ್ವಲ್ಪ ನೋಡ್ಬೇಕಿತ್ತು, ನಾನು ನೋಡಿಲ್ಲ.
ಇಷ್ಟೊಳಗೆ ನೋಡ್ಬೋದಿತ್ತಲ್ಲ.
ನೋಡಿರ್ಲಿಲ್ಲ. ನಾನು sorry. I consider my mistake.
At the request of the learned counsel for the appellant as an ultimate opportunity, 10 days time is granted to comply office objection, failing which ಉಳಿದಿದ್ದೆಲ್ಲ ಹಾಕಿ, if not complied 7/6 ಮಾಡಿ 10 days ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮತ್ತೆ
6 time non-compliance, 76 Syed Akbar. 76 Syed Akbar Pasha.
Let counsel for the appellant neither present physically nor through video conference. The perusal of the order sheet will go to show that in this appeal of the year 2019, in spite of granting several and sufficient opportunities of not less than 6 times, the appellant has not complied the office objection. He has not even appeared and at least through video conference and shown any reasons for non-compliance of office objection. The order sheet further revealed that on more than one occasion, the opportunities, even as finally, were granted to him. Even thereafter, once again, one more adjournment was granted only to enable the appellant to comply with the office objection. In spite of the same, the appellant has neither complied with the office objection or even showed any reason for non-compliance of office objection. The office objections that are required to be complied with also inter alia includes the very trivial and simple office objections, like the mentioning of the date of events in the synopsis, proper stitching of the pages of the memorandum of appeal, mentioning the phone number of the learned counsel for the appellant in Wakala, number of days of alleged delay to be specifically mentioning and non-mentioning of the PIN code. For to comply these office objection, the appellant is not evincing any interest when in fact the appeal is more than 4 years old. As such, I do not find any reason to grant any further time. Accordingly, the appeal stands dismissed for non-prosecution as well as for non-compliance of office objection.
Yes. 77 Nagendra DV Gaur.
At the request of the learned counsel for the appellant as a final last opportunity, 2 days time is granted to complete all office objection, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance. If office objections are not complied within time, registry to list this matter on 1/6.
Yes. 78 Mohammed Usman Sheikh.
₹5 cost payable to LSC by the appellant in 2 days from today and filing memo, etc., etc. As a last opportunity, 1 week time is granted in case if not filed, necessary orders, etc., etc., 26.
Bill number 79, Ravindra BS.
Counsel for the appellant who is physically present submits that in view of the valuation made by the appellant which exceeds ₹15 lakh, the matter may require to be posted before the appropriate division bench. Next line, the registry has also made a similar. The registry has also put a similar note in the order sheet. Next line, in view of the said memos, the said note and the supporting submission, the registry is permitted to list this matter before the appropriate division bench. However, after obtaining the necessary permission required, if any, by the Honorable Chief Justice, list this matter before the appropriate division bench on 2/6/2023. In the meantime, the appellant to comply the office objection if not already complied with. Yes.
Bill number 80, Sagar Baby.
I appear for the appellant, Millards. Millards, it is my mistake, Millards, that within the stipulated time I have not completed the office objection. Millards, however, Millards, on 13/9/2022, Millards, the matter was listed for non-compliance of office objections. Millards, time was granted. Millards, I had instructed my clerk. Millards, he says that Millards, he has done it. Millards, I have personally not verified it. Millards, 2 days time may kindly be given. Millards, I'll do it. Personally, I'll do it.
The request of the learned counsel for the appellant as a final last opportunity, 3 days time is granted to comply office objection. If complaints is not done in total, registry to list this matter on 1/6.
Silver 81, Sachin BS.
ಕಾಸ್ಟ್ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ, ಕಟ್ಟಿದ್ದೀರಿ. ಅದರಲ್ಲೂ ಒಂದು ಆನಂದ ಇರುತ್ತೆ ಅಲ್ವಾ? ಕಾಸ್ಟ್ ಕಟ್ತಾ ಇದ್ರು ಪರವಾಗಿಲ್ಲ, ಅಡ್ಜರ್ಮೆಂಟ್ ಹಾಕ್ತಾ ಇದ್ರೆ ಅದು ಒಂದು ಚಂದವೇ. ಮಾವಿನ ಗೊರಟನ್ನ ಪೂರ್ತಿ ರಸ ಹೋದ್ರ ಮೇಲೂ ಹಿಂಡಿ ಚೀಪಿ ಅದರ ನಾರನ್ನು ಚೀಪಿದಾಗ ಅವಾಗ ಬರ್ತಕ್ಕಂಥ ಹುಳಿ ಹುಳಿ ಸಿಹಿ ಸಿಹಿ ರುಚಿ ಏನಿರ್ತದೆ ನೋಡಿ, ಇದು ಹಾಗೆ ತಮಾಷೆಗಳಿಗೆ. ಚೀಪಿದ್ದೀರಿ ಹಾಗೆ ಎಲ್ರು ಚೀಪ್ತಾರೆ. ಬಾಲ್ಯದ ಆನಂದಗಳು ಸೇಮ್ ಆರ್ಡರ್ ಮಾಡಿ 1/6 maximum 3 days. Yes.
Silver 82, M. Ramchandra Reddy. Silver 82, M. Ramchandra Reddy.
Also for the appellant, neither present physically nor through video conference. In spite of granting several sufficient opportunities of not less than 6 times, the appellant has not complied with the office objection. The result of the order sheet would go to show that in this appeal of the year 2019, sufficient opportunities, even as finally were granted to the even after granting the final opportunity, once again an adjournment was granted to enable the appellant to comply with the office objection. In spite of the same, the appellant has not complied with the office objection, which office objections are very small and simple in nature. Further, the appellant also, having remained absent, has not shown any reason for non-compliance. The research circumstance, I do not find any reason to grant any further time. Accordingly, the appeal stands dismissed for non-prosecution and also for non-compliance of office objection.
Yes. Silver 83, Narayan Swamy PM. Number 84. Manjunath V. Number 85, Manjunath V. Number 86, V. M. Halaswamy.
Decree request to be corrected, my lord. Item schedule item number 7 to 14 are not included. The decree, my lord. It was the application of which put, my lord, it was not put up. I was informed, my lord. Just weeks to 10 days, my lord. I see.
That submission was made on the previous occasion also.
It was moved, my lord. Application has been, it was not put up before the court. That's what I have been informed. Weeks time. So it's a decree, even this board can direct, my lord, regarding the correction of the decree, my lord. It's not in my control here.
When did you file the application?
Date, my lord, I will.
The counsel for the opponent, while reiterating the submission made by him on 14/9/2022, once again, request for 10 days accommodation. Though the needful could have been done by the learned counsel at the earliest point of time, since the appeal is of the year 2019. And though the sufficient time even thereafter was granted to him, however, considering the submission made today as a final last opportunity, 10 days time as prayed is granted, making it clear that in case if the needful in their entirety are not done in and the office objections are not completed in the total within 10 days from today, the appeal stands dismissed on its own for non-compliance of office objection from 11th day from today without any further order by this.
Number 87, Suhas P.
Similar to 43, date 5/6.
Number 88, Prasad B.S.
Similar to 80, 3 days, 1/6.
Number 89, Prasad B.S.
Same order.
Number 90, N.G. Parke.
Appear for the appellant matter, my lord. Time to be granted.
On cost. At the request of the learned counsel for the opponent, as an ultimate opportunity, 10 days time is granted to comply office objection, however, imposing the cost of ₹500 payable by the appellant to the Legal Services Committee of this court within 3 days from today and filing a complaints memo along with a receipt to that effect in the registry within the said time. In case if the office objections are not complied in total, please this matter on 8/6, on which day the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance.
91, Manjunath, please.
Look, 87, yes.
Number 92, Aditi.
Yes.
Number 93, Amsit Hegde.
Some of the face.
Serial number 94, Aditi.
Yes.
Serial number 95, N. Gopal.
Counsel for the appellant neither present physically nor through video conference. No reasons are forthcoming for non-appearance of 11th counsel for the appellant. Reversal of the order sheets will go to show that in this appeal of the year 2019, in spite of granting several and sufficient opportunities, not less than 6 times, the appellant has not complied with the office objection. On 6/4/2021, this court had granted as a last chance a week's time to comply office objection. However, by imposing a cost of ₹500. According to registry, the appellant has not even paid the said cost also, apart from non-compliance of office objection. After imposing such a cost and granting time as a last chance, still this court had granted the appellant 2 more adjournments in the best interest of justice to comply office objection. Despite the same, the appellant has not complied with office objection and has not made use of the opportunities given to him to do needful. Furthermore, having remained absent today, the reasons for non-appearance and non-compliance also has not been shown by the learned counsel for the appellant who could have appeared through video conference. Hence, I do not find any reason to grant any further time in this appeal of the year 2019. Accordingly, the appeal stands dismissed for non-prosecution as well as for non-compliance of office objection.
Number 96, Pratik Kesi.
7 objections followed by
87, yes.
Seventh time non-compliance, number 97, Nagaraja, yes.
Monday, sir. Monday, Monday, Monday. Monday, Monday, Monday. First.
How many days you want? 2 days. 2 days. 3,000 rupees cost. Day before yesterday, this matter had come up before me. The office objections have remained the same. On that day itself, you could have taken a longer time. You submitted that you would comply the office objections during the course of the day. Accordingly, a day's accommodation, though you said that during the course of the day you would do, still a day's accommodation, in addition to during the course of the day, was granted to you, imposing a cost of rupees 500. That means you are aware of the nature of office objections and thinking that, say, or calculating the required time, you yourself opted for time and the court has granted you more time than what you opted. But still you have not complied. Therefore, the court is labored with repeating this matter. For listing this matter, 14 of my staff had to put their labor for no valid reasons or purposes. As such, the cost would be 3,000 rupees to me. ನಿಮ್ಮಲ್ಲಿ ಫೈಲ್ ಸ್ಕ್ರೂಟಿನಿ ಬ್ರಾಂಚ್ ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಏನು ನೀವು ಕ್ರಮ ತಗೊಳ್ಳಬಹುದೋ ತಗೊಳ್ಳಿ. ಅದು ನನಗೆ ಸಂಬಂಧಪಟ್ಟಿದ್ದಲ್ಲ. ನನಗೆ ಹೇಳಿ 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 ಸಾಕಾಗಿದೆ. ನಿಮಗೆ ಎಲ್ಲಾ ನಿಷ್ಕ್ರಿಯ ವ್ಯಕ್ತಿಗಳು, ನಿಷ್ಕ್ರಿಯ ಸಿಬ್ಬಂದಿಗಳು ಹಾಗೆ ಇರಬೇಕು. ಅವ್ರ ಜೊತೆ ತಮ್ಮ ಸ್ನೇಹಿತಗಳು ಇದ್ದ ಪಕ್ಷದಲ್ಲಿ ಅದು ಹಾಗೆ ಇರಬೇಕು. ಅಲ್ಲಿ ಬದಲಾವಣೆ ಆಗಬಾರ್ದು. ಇಲ್ಲಿ ಬಂದು ಅಲ್ಲಿ ಸುಂಕದವ್ರ ಮುಂದೆ ಸುಖದಕ್ಕ ಹೇಳ್ಕೊಳ್ತೀರಿ. ಮೊಫಿಜಲ್ ಏರಿಯಾದಲ್ಲಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜುಡಿಷಿಯರಿಯಲ್ಲಿ ಹೋಗಿ ನೋಡಿ, ಅಲ್ಲಿ ಸಿಬ್ಬಂದಿಗಳು ಹೇಗೆ ಕೆಲಸ ಮಾಡ್ತಾರೆ ನೋಡಿ. ನೋಡಿ ಅಲ್ಲಿ ಮಾಡೋ ಕೆಲಸ. ಇದೇ ACMM ಕೋರ್ಟಿಗೆ ಹೋಗಿ 2600 ಫೈಲ್ ಒಬ್ಬ ಜುಡಿಷಿಯಲ್ ಆಫೀಸರ್, ಒಬ್ಬ ಬೆಂಚ್ ಕ್ಲರ್ಕ್ ಡೀಲ್ ಮಾಡ್ತಾರೆ. ನಮ್ಮಲ್ಲಿ ಕೆಲಸ ಮಾಡೋರು ಒಬ್ರು, ಸುಮ್ಮನೆ ಕೂರೋರು ಇನ್ನೊಬ್ರು. 1.5 ಗಂಟೆಗೆ ಸ್ಟೆನೋಗ್ರಾಫರ್ಗಳು ಚೇಂಜ್. ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜುಡಿಷಿಯರಿಯಲ್ಲಿ ಒಬ್ಬ ಸ್ಟೆನೋಗ್ರಾಫರ್ 2 ಕೋರ್ಟ್ ಅಟೆಂಡ್ ಮಾಡಬೇಕು. ಇಬ್ರು ಸಾಹೇಬ್ರದ್ದು ಇಡೀ ಮಂತ್ಲಿ ಕೋಟಾ ಕೊಡಬೇಕು, 28 ಯೂನಿಟ್ ಜೊತೆ ಇಂಟೀರಿಯಂ ಆರ್ಡರ್ಸ್ಗಳು, ಇಂಟೀರಿಯಂ ಆರ್ಡರ್ಸ್ಗಳು. ಇಲ್ಲಿ ಮಾತಾಡ್ತಿದ್ರೆ ವರ್ಕ್ ಜಾಸ್ತಿ, ಹ್ಯಾಂಡ್ಸ್ ಶಾರ್ಟೇಜ್. ಬರ್ತಾರೆ ಜನ ಬರ್ತಾರೆ, ರಿಕ್ರೂಟ್ಮೆಂಟ್ ಆಗ್ತಾನೆ ಇರ್ತದೆ. ಅವ್ರು ಕೂರ್ಲಿಕ್ಕೆ ನಿಲ್ಲಕ್ಕೆ ಬೆಂಚ್ ಇರಲ್ಲ, ಏನು ಇರಲ್ಲ. ಹಂಗಾಗಿ ಅಡ್ಡಾಡ್ಕೊಂಡು KJD ಬಿಲ್ಡಿಂಗ್ ಇಂದ ಅವೆನ್ಯೂ ರೋಡ್ ವರೆಗೂ ಹೋಗಿ ಡ್ಯೂಟಿ ಮಾಡಿ ಬರ್ತಾರೆ ಬಯೋಮೆಟ್ರಿಕ್ ಹಾಕ್ಲಿಕ್ಕೋಸ್ಕರ. ನಿಮ್ಮ ಪ್ರಾಬ್ಲಮ್ ರಗಳೆ ಹಾಗೆ ಇರ್ತದೆ. ಫೈಲ್ ಬಂದಿಲ್ಲ, ಬರಲ್ಲ. ಇಂಥದ್ರ ಬಗ್ಗೆ ನೀವು ಸಂಬಂಧಪಟ್ಟವ್ರ ಗಮನಕ್ಕೆ ತನ್ನಿ. ಏನ್ ಮಾಡ್ತೀರಿ ಅಂತ ನೀವು ಕೇಳಿ. ಬಿಕಾಸ್ ದಟ್ ಈಸ್ ಯುವರ್ ರೈಟ್, ಅವರ್ ಡ್ಯೂಟಿ. ಯು ಆರ್ ಪೇಡ್ ಫಾರ್ ದಟ್. ಮಾಡ, ನಿಮ್ಮ ಕಾಸ್ಟ್ ಕಡಿಮೆ ಆಗಲ್ಲ. The learned counsel for the appellant, at whose instance on 22/5/2023 a day's accommodation to compel office objection was granted, though by imposing a cap of rupees 500, is once again praying for 2 more days time to compel office objection. Needless to say that while seeking for time on 22/5/2023 itself, he was aware of the nature of the office objections which were yet to comply with. Despite the same, he volunteered to opt for a day's accommodation, which were granted. Since showing no any valid reasons, he is requesting for 1 more adjournment by 2 days to compel office objection. I am of the view that unnecessarily he has put labor to the registry in making lot of entries in the concerned registers and computers and re-listing the matter for no valid reasons or purpose. As such, granting of 2 days time would be only by imposing additional cost and as an ultimate opportunity, that too with a peremptory order. Accordingly, imposing a cost of ₹2,000 payable by the appellant to the legal services committee of this court within a day from today and filing a complaints memo along with original receipt in the registry within the said time. As a final last opportunity, 4 days time is granted to comply office objection, failing which from the 5th day onwards, the appeal stands dismissed on its own for non-compliance of office objection without any further orders by this.
Number 98,
Number 76 ಯಾವುದು ಮಾಡಿದ್ದೇನೆ ನೋಡಿ ಎಂದು ಹೇಳಿದ್ದೇನೆ. Referred option to in spite of granting finally one more adjournment was granted. Even after granting finally he did not comply. ಅದನ್ನೇ ಹಾಕಿ same order. Dismiss non-complex, non-prosecution.
number 99, Bacharaj DP.
That was listed day before yesterday regarding payment of court fee, which I have already paid on the same day. Now the office has raised seeking the proof of having paid the 13,000 deficit court fee before the trial court. I have requested my counterpart to verify by applying.
Counsel for the appellant submits that. Release DCF of ₹65,900 has been paid by him on 22/5/2023 itself. However, to meet the subsequent query raised by the registry, he requests 10 days time. As finally, 2 weeks time is granted to do needful in the matter.
Number 100, Jagdish Achari.
You may have to make an application, a memo won't do.
No, madam, as per court direction, like that. Court direction.
ಯಾವುದು ಡೇಟು ನೀವು ಹೇಳ್ಬೇಕ್ರಿ ಡೇಟು. ನಾನು ಇಷ್ಟ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಪ್ರೂಫ್ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಯಾವ ಡೈರೆಕ್ಷನ್ ಅಂತ. ನೀವು ಡೇಟ್ ಹೇಳಿ ನೋಡ್ತೇನೆ ಇಮಿಡಿಯೇಟ್. ಪಾಸ್ ಅವರು ಮಾಡಿರ್ತೇನೆ ಮಧ್ಯಾಹ್ನ ಹೇಳಿ. ಯು ಕೆನಾಟ್ ಮೇಕ್ ದಿ ಕೋರ್ಟ್ ಆಸ್ ಯುವರ್ ಕ್ಲರ್ಕ್. Matter is passed over at the request of the learned counsel for the appellant. Yes.
Number 101, that is TS.
Weeks time.
At the request of the learned counsel for the appellant as a last chance, a week's time as grade is granted, failing which the court may proceed to pass appropriate order. In case if needful is not done, registry to list this matter on 6/6.
Number 102, SF Anis Ahmad.
The counsel for the appellant who is physically present in the DB refer ಮಾಡಿ ಮಾಡಿದ್ದೇನೆ ನೋಡಿ madam. Same. Yes, refer to DB. List the matter before DB on 2/6. Yes.
Serial number 103, Mahesh L.
With respect to this office objection, in para 14 and 15 of the judgment of the trial court, my lord, they were all deleted and no relief was claimed by the plaintiff. This is the defendant's appeal before this honorable court. And I did not seek any relief against these defendants. Kindly, my lord, come to page number 31 of my appeal memo.
Why did you not bring this aspect before the
I
registry?
ಅಲ್ಲಿ ಹೇಳಿದ್ವಿ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಅವ್ರ ಮೇಲೆ ರಿಲೀಫ್ ಕ್ಲೈಮ್ ಮಾಡಿಲ್ಲ ಅಂತ ಒಂದು ಶಾರ್ಟ್ ನೋಟ್ ಹಾಕಿದ್ದೀನಿ. But later I thought that a detailed note would have sufficed the. ಇದರಲ್ಲಿ
Could have made this exercise could have been attempted before registrar of judicial alway.
Please, I'm sorry. Not ಅಲ್ಲಿ page 31 ನಲ್ಲಿ.
There are also in RFA 581. They have to be made as a formal participant, even though the claims are.
Office note ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ. No relief is claimed against them.
ನಿಮ್ಮ submission ಗೆ against ಆಗಿ ಒಂದು division bench order ಇದೆ, judicial order. ಇದು ನಿಮಗೆ ಒಂದು ವ್ಯರ್ಥ ಪ್ರಯತ್ನ ಮಾಡಲು ಆದೇಶಿಸುತ್ತದೆ.
ಅಲ್ಲ, ಇಲ್ಲಿ ಕೈಲಿ ಇಲ್ಲಿ ಇವರು plaintiff they did not press their relief and a memo is also filed.
ಏನ್ ಹೇಳಿದ್ರು ತಮಗೆ ಅರ್ಥ ಆಯ್ತೆ? ಕೋರ್ಟ್ ಏನ್ ಹೇಳಿದೆ ಅಂತ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಿಕ್ಕೆ ಮುಂಚೆ ನೀವು ಹಾಗೆ ವ್ಯರ್ಥ ಅಲ್ಲ ಅಂತೀರಿ.
All the parties were
ನ್ಯಾಯಾಲಯ ಅಥವಾ ನ್ಯಾಯಾಧೀಶರು ಏನ್ ಹೇಳಿದ್ರು ಕೂಡ ನಮಗೆ ಎಗೇನೆಸ್ಟ್ ಹೇಳ್ತಿದ್ದಾರೆ ಅಂತ ಭಾವಿಸಬೇಡಿ. ಹಲವಾರು ಸಂದರ್ಭಗಳಲ್ಲಿ ನ್ಯಾಯಾಲಯ ನಿಮ್ಮ ಪರವಾಗಿನೇ ಹೇಳ್ತಿರ್ತದೆ. ಈಗ ಆಗ್ತಿರೋದು ಅದೇ. ನಿಮಗೊಂದು ವ್ಯರ್ಥ ಪ್ರಯತ್ನ ಮಾಡಲು ನ್ಯಾಯಾಲಯದ ಆದೇಶವಿದೆ. ಇಂಥ ವ್ಯರ್ಥ ಪ್ರಯತ್ನವನ್ನು ಡಿವಿಷನ್ ಬೆಂಚ್ ಆದೇಶದ ಪ್ರಕಾರ ನೀವು ಮಾಡುವುದು ಅನಿವಾರ್ಯವಾಗುತ್ತದೆ. ನಾನು ಸೂಕ್ತ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. ಇದರಲ್ಲಿ ಇರೋದವ್ರು ಫಾರ್ಮಲ್ ಪಾರ್ಟಿ ಆದ್ರೂ ಡಿಲೀಟ್ ಆದ್ರೂ ಅವ್ರನ್ನ ನೀವು ಒಮ್ಮೆ ಇಲ್ಲಿ ಪಾರ್ಟಿ ಅಂತ ಮಾಡಿ ಆಮೇಲೆ ಡಿಲಿಷನ್ಗೆ ಕೇಳಬೇಕು ಅಂತ ಜುಡಿಷಿಯಲ್ ಆರ್ಡರ್ ಇದೆ. ದಿಸ್ ಬೈಂಡ್ಸ್ ನಾಟ್ ಓನ್ಲಿ ಮೀ, ಈವನ್ ದಿ ಹ್ಯಾಂಡ್ಸ್ ಆಫ್ ದಿ ರಿಜಿಸ್ಟ್ರಿ ಆಲ್ಸೋ. ಇಟ್ ಸರ್ವ್ಸ್ ನೋ ಪರ್ಪಸ್ ಬಟ್
formality has to be followed.
ಫಾರ್ಮಾಲಿಟಿ ಟು ಬಿ ಫಾಲೋಡ್ ಅಂತ ಹೇಳಿ ಅವರು ಹೇಳಿದ್ದಾರೆ. ಮಾಡಿ
R1 is the plaintiff before the trial.
ಯಾವಾಗ ತೀರಿದ್ದಾರೆ?
2021.
ಆ ಬಗ್ಗೆ ನೀವೇನ್ ಮಾಡಿದ್ದೀರಿ? ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ? ಅಲ್ಲರಿ, ಖಾಲಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ನಿಧನ ಹೊಂದಿದ್ದಾರೆ ಅನ್ನುವುದರ ಮಾಹಿತಿಯನ್ನು ನೀವು ಯಾರಿಗೆ ಯಾವ ಮೂಲಕ ನೀಡಿದ್ದೀರಿ? ಏನಾದ್ರು ಮೆಮೊ ಹಾಕಿದ್ದೀರಾ? ಅವ್ರಿಗೆ ಏನಾದ್ರು ಮೆಮೊ ಇವತ್ತು ಕೊಡ್ತಿದ್ದಾರೆ? ಕೊಟ್ಟಿದ್ದೀರಾ ಈಗ ಅವರಿಗೆ ಮೆಮೊನ? ಕೋರ್ಟಿಗೆ ಯಾವ ರೀತಿ ಗಮನಕ್ಕೆ ತಂದಿದ್ದೀರಿ? ಕೌಂಟರ್ನಲ್ಲಿ ಹಾಕ್ತೀರಿ. ಹಾಕಿ ಬನ್ನಿ, ನಾನು ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೇನೆ ಮಧ್ಯಾಹ್ನ ಹೇಳಿ. That is passed over at the request of the learned counsel.
ಮೆಮೊ ಹಾಕಿ
Password. ಬರೀತಿದ್ದಾರೆ. ನಾಗೇಶ ಹೋಯ್ ಬೇಗ ಊಟ ಮಾಡ್ಕೊಂಡು ಬರ್ಕೊಂಡು
Court officer. Serial number 121 ಪಾಸ್ ಓವರ್ ಆಗಿದ್ಯಾ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರಾ?
121 ಇದೆ ಸರ್.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಸರ್ ಇದೆ ಸರ್ 121 ಇದೆ.
ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
Yes. Household matters, serial number 17. Yes, Shiv Prasad for respondent.
But again in the afternoon, none appear in this matter either physically or through video conference. Result of the order sheet will go to show that in spite of getting several sufficient opportunities, the appellant has not complied with the subsection. It is shown by the registry that the appellant counsel has not even filed the affidavit explaining the reasons for non-compliance, though corrected by the order dated 19/4/2021. Under the such circumstance, though the appeal could have been dismissed for non-prosecution as well for non-compliance of office objection. However, the best interest of justice as a final last opportunity, 3 days accommodation is granted to comply office objection and to complete the direction dated 19/4/2021, failing which the court may proceed to pass appropriate order, including dismissal of the appeal for non-compliance of office objection. In case if the office objections are not complied in their entirety within the time given above, the registry to just the matter on 31/5. Yes.
Serial number 32. Melania Sebastian.
Again in the afternoon, learned counsel for the appellant who is physically present files a memo seeking permission to withdraw the appeal as not pressed. In view of the memo supporting submission, the appeal stands dismissed as not pressed.
Serial number 100. Jagdish Chari. Seventeen, 18, 21.
court this morning asked you to give the date
Yes.
when you specifically submitted that this court has directed you to file a memo. Show me the order or the direction directing you to file a memo passed by this court.
17/8/2021.
17/8/2021. There is no direction for you to file any memo in that regard.
Application or memo, your last. My submission minute, application or minute, memo. The court minute recorded my submission.
The court recording your submission does not mean that court permitting you to act accordingly. I need not tell this to a learned advocate.
I will file the application.
ಮತ್ತೆ ಬೆಳಗಿಂದ ಇಷ್ಟೊತ್ತರ ಟೈಮ್ ಯಾಕೆ ವೇಸ್ಟ್ ಮಾಡಿದ್ರಿ ಆ ಪಾಯಿಂಟ್ ಮೇಲೆ? ಅದು ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ.
I will file the application.
What again in the afternoon? The learned counsel for the appellant who is physically present submits that you would not press on the memo dated 17/10/2022. However, you would file a necessary application for the same relief. In the light of the above submission, the memo dated 17/10/2022 stands disposed of. The application, if any, is desired to be, if the application, if any, desired by the appellant to be filed, to done within 10 days from today. Yes.
Serial number 103, Mahesh L, AG Nagaraj for the respondent.
I'll comply with the office objections.
You have complied.
ಅಲ್ಲಲ್ಲ ಮಾಡ್ತೀನಿ. I will fresh appeal memo ಹಾಕ್ಬೇಕು. Indicating the name of all the parties who were the parties before the trial court. I will do it by
God again, learned counsel from both sides present. The counsel for the appellant submits that he would do needful in the matter in arraigning of the left out defendants within a day from today. 3 days accommodation as finally is granted to do needful, failing which the court will proceed to pass appropriate order. Next line. ಯಾರು ನೀವು ಡಿಸಿಷನ್ ಇದ್ದು ಕಾಪಿ ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ ಅದನ್ನ the learned counsel for affidavit or public respondent number 1 submits that the respondent number 1 is reported to be dead on 30/10/2021 and that a memo of intimation that record has been furnished to the learned counsel for the appellant. And a copy is also filed in the registry today. Registry to verify. Learned counsel for the appellant acknowledges the receipt of the intimation of death of respondent number 1 and prays for 2 weeks accommodation to do needful in the matter.
Serial number 104, Narendra D.V. Gowda.
None appear for the appellant. As finally, 3 days time is granted to do needful as per the direction dated 4/11/2015, filing which the court may proceed to pass appropriate order. List the matter on 5/6, please. ಇದ್ದೇ ಅಲ್ವೇ ಆಮೇಲೆ ಬಂದು ಅಷ್ಟೊತ್ತು ಮಾತಾಡಿದ್ರಿ ಅಲ್ವೇ ಇದ್ದವ್ರು ಮಾಡಲ್ವೇ ಮೇಡಮ್ ಅಲ್ರಿ ಇದು ನೀವು ಕಳಿಸದೆ ಎಲ್ಲಿ ಮಾಡಲ್ವ ರಿಜಿಸ್ಟ್ರಿ ಇಲ್ಲಿ ನೀವು ಫೋನಲ್ಲಿ ಹೇಳಿದ್ರೆ ಎಲ್ಲ ತಂದು ಕೋರ್ಟ್ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡಿದ್ವಿ. 3 days time ಇದೆ during the course of the day. As a last chance, 3 days time is granted to the appellant to comply of this objection. Have to be paid during the course of the day. ಕಾಸ್ಟ್ ಕಟ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಶೀಟ್ ಕಾಪಿ ಬೇಡ. ಅದು LSC ಹೋಗಿ ಕಾಸ್ಟ್ ಕಟ್ಟೋದು ಹಂಗೆ ಕಟ್ಟಿದ್ರು ಕಟ್ಟಿಸ್ಕೊಳ್ತಾರೆ. ಈ ಪಾರ್ಟಿ ದಡ್ಡರಾಗಿ ಪದೇ ಪದೇ ನನ್ನ ಪೇಷನ್ಸ್ ಚೆಕ್ ಮಾಡಬೇಡಿ. ಸ್ವಲ್ಪ ತಲೆ ಉಪಯೋಗಿಸಿ ಕೆಲಸ ಮಾಡಿ. Yes. Sale number 105, Harish Bandari T. Yes.
For recovery of lordship. For the court bill, I have paid the rupees 73,325 was the court fee. Now, your lordship kindly refer to page 10 of my bill.
Now, according to you, the quantum of court fee paid by you is sufficient.
I restricted your lordship to virtual claim was 11,65,000.
No, you are not answering my question. You are elaborating your reasoning. My question to you is whether according to you, the quantum of court fee paid is sufficient. Fine. Did you make this submission in the registry? ಮಾಡಬೇಕಿತ್ತಲ್ವೇ at the earliest point of time ನೀವು ಮಾಡಬೇಕು. ಮಾಡಿದಾಗ ಅವರೇ ಅದನ್ನ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅನ್ನು ಅಲ್ಲಿಯೇ ರಿಮೂವ್ ಲಿಫ್ಟ್ ಮಾಡಿದ್ರೆ ಮುಗಿದೋಯ್ತು. ಇಲ್ಲಿವರೆಗೆ ಬರಲ್ಲ. ಅವ್ರು ಮಾಡದೆ ಹೋದ್ರೆ ಇಲ್ಲಿ ನಾವು ಕೇಳಿ ನಿಮ್ಮ ಸಬ್ಮಿಷನ್ ಅಲ್ಲಿ ಮೆರಿಟ್ ಇದೆ ಅಂತ ಆದ್ರೆ ನಾವು ಓವರ್ ರೂಲ್ ಮಾಡೋದು ಆಮೇಲೆ ಬರ್ತದೆ. ಅಲ್ಲಿ ಹೋಗಿ ಒಮ್ಮೆ ಮಾಡಿ. Counsel for the appellant who is physically present submits that according to him the quantum of court fee paid is sufficient for the relief sought for by him. In that regard, he has got a submission to be made before learned registrar judiciary. He is permitted to make his submission regarding the said office objection about valuation. In case if the registry is not convinced with the submission to be made by the learned counsel for the appellant, then the registry to record its reasoning and place the matter before the court. The exercise is to be completed within a week from today. 2 weeks from today. Yes.
Seal number 106, Saravana S, RB Sadashivappa for R1.
ಎಲ್ಲರೂ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ನಲ್ಲಿ ಬರಬೇಕಂತ ಆರ್ಡರ್ಸ್ ನಲ್ಲಿ ಯಾಕೆ ಬರುತ್ತೆ ಇದು? ಕೆಲವೊಮ್ಮೆ ಇವ್ರನ್ನ ಬೋರ್ಡ್ ಬ್ರಾಂಚ್ ಪೆಂಡಿಂಗ್ ನ ಕರೆಸಿ ಕೇಳಿ. ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್, ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಆಫ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಬದಲು ಆರ್ಡರ್ಸ್ ನಲ್ಲೂ ಯಾಕೆ ತೋರಿಸ್ತಿದ್ದಾರೆ
ಅಷ್ಟೇ ಕೇಳ್ದೆ ಅವ್ರೇನ್ ಹೇಳ್ತಿದ್ದಾರೆ ಅಂದ್ರೆ ಅಪ್ ಟು 8th ಟೈಮ್ ಅಂತೂ ವರ್ಗೂ ಇಲ್ಲಿ ಬರುತ್ತೆ. 8th or 9th ಟೈಮ್ ವರ್ಗೂ ನಾನ್ ಕಂಪ್ಲೇಂಟ್ಸ್ ಬರುತ್ತೆ. ಇಟ್ ಈಸ್ ಮೋರ್ ಅಂತ ಹೇಳಿದಾಗ ಅವರು ಅದನ್ನ ಆರ್ಡರ್ ಸ್ಟೇಷನ್ ಆಗ್ತಾ ಇದ್ದಾರೆ.
ಯಾವ ಬೇಸಿಸ್ ನಲ್ಲಿ ನೈಟ್ ಅವರು ಮಾಡಿ ಆಮೇಲೆ ಇದು ಆಮೇಲೆ ಕೇಳಿ ಸಂಜೆ ಯಾವ ಬೇಸಿಸ್ ನಲ್ಲಿ ಅದನ್ನ ಮಾಡ್ತಾರೆ. ಆಮೇಲೆ ಹಾಗೇನಾದ್ರು ಹಾಕೋದಾದ್ರೂ ಇಲ್ಲಿ ನಾನ್ ಕಾಂಪ್ಲೆನ್ಸ್ ಆಫ್ ಸಬ್ಜೆಕ್ಟ್ ಫಾರ್ ದ 9th ಟೈಮ್ ಅಂತ ಕೆಳಗಡೆ ಬ್ರಾಕೆಟ್ ನಲ್ಲಿ ಹಾಕ್ತೀವಿ. ಅದನ್ನು ಹಾಕ್ಲಿಲ್ಲ ಅವರು. None appear for the appellant in this matter, either physically or through video conference. The perusal of the cause list and the order sheet doesn't clearly reflect whether there is objections, whether the objections raised by the registry were the office objection raised at the scrutiny or erupted at a later point of time regarding the alleged non-tallying of the description of the defendant number 3 and appellant number 6. If it were to be the office objection raised at the stage of scrutiny in the initial stage itself, the registry to mention as to why the matter is not being listed under the title of non-compliance of office objection. On the contrary, is listing it under the orders list. Next line, irrespective of the above, as a final last opportunity, the appellant is granted 2 days time to the objections raised by the registry, failing which the court may proceed to pass appropriate order, including appropriate order. Is the matter on 31/5. Yes.
Number 107. MC Veerabhadraya.
Yes, please.
Objection by Synchronization district settler. Suit for partition lot on the family member. Appellant has filed partition suit against the respondent. The elder of the first respondent has also filed.
Appellants had filed the partition suit against respondents.
All first respondent also filed another partition suit against the appellant. Because of that,
This appeal has arisen out of the suit filed by which party? The present appellant or the present respondent one?
then the first respondent also filed.
You are not answering my question. According to you, 2 suits were filed by either of the parties. My question is, present appeal has arisen from which particular suit of them? Filed by the present appellant or filed by the present respondent number 1?
Respondent has filed. Respondent has already
Brahmurthy has filed. The elder brother of the appellant, Brahmurthy has filed the partition.
Answer my question in one word. According to you, both the appellant and the respondents have filed suit for partition in the trial court.
Same family kingdom.
The present appeal is filed against which suit? Filed by the present appellant or by the present respondent or respondents?
Three respondent is the voice number 3.
I will pass over the matter, clarify yourself as to how to answer my question in one word and make submission.
Voice number 91 of.
No, you are wasting my time. I have other matters to attend. You could have simply answered as respondent number 1, which you are not attempting to.
This suit, my lord.
Matter is passed over.
Respondent has filed partition suit.
Request of the appellant. Yes.
Number 108. Transfer City, K.
Why? No, pecuniary jurisdiction observation raised to be observed by the office. Do you accept or deny?
That's to be.
Your affidavit has got no concern with respect to the pecuniary jurisdiction of the appeal. Your affidavit is in compliance with the direction given to you on 7/4/2021, wherein you are directed to file a sworn affidavit explaining the reasons for non-compliance of office objections. Therefore, your present submission about the pecuniary jurisdiction has got no bearing, no relevancy, no connection with the affidavit. At the request of the learned counsel for the appellant has a final last opportunity. 3 days time as spread is granted, making it clear that In case if needful is not done within the scheduled time, the court may proceed to pass appropriate order, including dismissal of the appeal. Is the matter on 1/6.
Number 109, A. Madhusudan Rao, M. Srinivas Murthy, correspondent.
The counsel for the appellant present. ಬೆಳಗ್ಗೆ DB refer the submission ಹಾಕಿದ್ದೀರಿ ನೋಡಿ submit so and so. Registry also has made the same mention.
The office objection related to
Is the matter before DB on 5/6. Before which time the appellant to complete the office objection in court.
the office objection is relating to not non-impeding defendant number 2. Defendant number 2 has remained ex parte. I mentioned that in the past.
No, that the DB would make observation.
Number 110, V. Srinivasaya. I've also made an application seeking for condonation of the delay for complying with office of
When you have done this,
today morning.
prayer is for condonation of delay in complying office objection.
Along with an affidavit explaining why there was a delay in compliance.
Was making an application was
Our affidavit
required of you.
was, the order was to file an affidavit. I thought it fit to make an application along with an
So
affidavit.
instead of running 100 meters, you attempted to run 150 meters. Fine. Learned counsel for the appellant who is physically present submits that he has paid the deficit court fee this morning and also has filed an application seeking condonation of delay in complying the office objection, which according to him was as per the direction dated 8/4/2021. Registry to verify and proceed further. Yes.
Permit me, I will make the necessary correction in the valuation para. That is of the.
In registry.
Seal number 111, permitted by the court, I think. they will-
Well, according to you have complied office objections.
Paid the court fees. They have.
You have complied office objection, however, filed an application seeking condonation of delay in complying office objection. Then the question of you having requiring any access to the case file does not arise. Yes.
Seal number 111, Shamant Naik.
The counsel for the appellant is neither present physically nor through video conference. No reasons are forthcoming for his non-appearance. The perusal of the order sheet would go to show that the matter is still due for complaints of office objection raised by the registry. The appeals of the year 2019 and not less than 6 opportunities were granted to the appellant to comply of his objection, despite which he has not complied the same. The perusal of the order sheet would further go to show that on 1/4/2021, this court has recorded the submission of the learned counsel for the appellant that he has done the needful in the matter. The registry was directed to verify the same. However, the registry has put up its note stating that the sole office objection, which was due for complaints, is still due and the appellant has not complied the same. As such, it emerges from the order sheet and the submission that the office objections raised at the earliest instance by the registry still not complied by the subjections, office objection still not complied by the appellant. He has not even shown any reason for its non-compliance. However, it appears that by the submission dated 1/4/2021, the court was misled to believe that the office objections were complied with when in fact it was not. As such, I do not find any reason to grant any further time. Accordingly, the appeal stands dismissed for non-prosecution as well as for non-compliance of office objection. Yes.
Appear for appellant, my lordship. Appear for an appellant, my lordship.
Yes. Yes, please.
My lordship, the value of the appeal is like 15 lakhs, my lord. So it should be posted before the honorable division bench, my lord.
Same with the number 5/6. Yes, refer to DB. Next.
Obliged, my lord.
Ashok. In the meantime, to comply office objections if any. Yes, please.
Presiding officer of the court, and after conclusion para of the judgment, is not signed. Earlier edition of page 32, your lordship. Degree is already drawn in the and against the same judgment, one more appeal is filed and it is already admitted. His objection was not pointed out. RC 229 of 20.
What is your submission today?
One more connected. Already, my lord, one more connected appeal is also filed against the same judge. That appeal is admitted. It also filed by the other.
I give you two options.
Yes, ma'am.
3,000 rupees cost and complying office objection within a week from today. Option number 2, dismissal of the appeal for non-compliance of office objection. The reason is simple that office objections were raised at the first instance. You complied. However, before you could comply office objection, a direction was given to you by the other bench of this court, the roster, directing you to file an affidavit explaining the reasons for non-compliance of office objection from the date of raising of the office objection till the extended period. Till today, you have not complied the said direction given by the court. Number 1. Number 2, about the office objection subsequently raised by the court. 2 years back, the same was brought to my notice by you. Then also the court felt that rather than placing and endorsing the said office objection in a judicial order, which may require or which may warrant calling for explanation from the concerned judicial officer, it was better for you to approach the court and get the duly signed copy, certified copy unto file.
I immediately soon after the direction was given, I approached the registrar that the presiding officer is already been transferred.
Sir, that is for that presiding officer, that court to do.
The registry refused to entertain the petition. Even I got the copy of the petition given before the registrar, and he has refused to acknowledge.
Here the registrar.
Bangalore registrar.
Trial court.
City civil court.
Trial court.
Yes, my lord.
You have got a separate remedy there, sir. You have a separate remedy there. He is only simply a registrar, but you are the law court officer, you are an advocate. You know better law, more law, wide aspects of law than him, or at least expected to know. I myself have given you 2 adjournments in the matter.
Yes, my lord.
You did not make use of them. That has constrained me to give you these 2 options. You are not at fault, but you cannot let them to override. ಒಂದು ವಿಷಯ ಹೇಳಬೇಕಂದ್ರೆ ಬೇಜಾರು ಮಾಡ್ಕೊಳ್ಬೇಡಿ. Though I am not expected to or permitted to say so, but still, in the best interest of fraternity, in many of the matters, probably in my own self in several of the instances, rather than believing upon our knowledge, our effort, our studies, or making some effort in studying or knowing what the law is, we believe what others say. Whether what a bench clerk says, what a pending clerk says, or what any other officials would say, we believe and act accordingly. That leads to a lot of chaos. With their limited knowledge or no knowledge, majority of the cases, they mislead the learned counsels. These counsels believe, instead of taking pain in convincing them or telling them what the correct provision of law is, they put all their effort, energy, time, etc., in the court of law, attempting to convince the court and the judge. This is one such instance. When you have paid the necessary copy application fee and made a copy application, which was accepted by them after scrutiny, it is their duty to furnish you a correct, legible, clear, authenticated copy. If they provide you correct, clear, legible copy, if it is not authenticated, it is not your fault. You have got every right to demand free of cost a substitution of an authenticated copy in the place of the defective copy supplied to you. Plus, you have a right to claim any compensation also from them, provided if you feel like. Rather, having all the support and backing of law in your support, rather than convincing them as to what your rights and how strong they are against them, you are attempting me to subdue to an aspect that simply because another appeal is filed and admitted, I should entertain this unauthenticated copy and proceed further. Is this the fair submission? No, twice you made the submission, another matter has already been accepted and admitted.
Brought to the notice both the things.
That was not at all warranted. Not at all warranted. ನನಗೆ ಅದೇ ವ್ಯಥೆ ಆಗ್ತದೆ. ಹೆಚ್ಚಿನ ಜನ ತಾವಂತಲ್ಲ ಸುಮಾರು ಯಂಗ್ಸ್ಟರ್ಸ್ ಎಲ್ಲ ಬರ್ತಾರೆ, ಇನ್ನೊಬ್ರು ಬರ್ತಾರೆ, ಅಲ್ಲಿ ಹೋದ್ರು ಸ್ವಾಮಿ ಪೆಂಡಿಂಗ್ ಬ್ರಾಂಚ್ ಅಲ್ಲಿ ಹಿಂಗ್ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ, ಆ ಕ್ಲರ್ಕ್ ಹಿಂಗ್ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ, ನಾವೇನ್ ಮಾಡೋಣ ಸ್ವಾಮಿ? ನನ್ಗೆ ಕೇಳಿ 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 ಬೇಜಾರ. ಒಬ್ಬ ಕ್ಲರ್ಕ್ ಏನೋ ಹೇಳಿದ ಅಂತ ಹೇಳಿದ್ರೆ ಅಡ್ವೊಕೇಟು ಅದನ್ನು ಒಪ್ಪಬೇಕೆ? ಈಸ್ ಅನ್ ಅಡ್ವೊಕೇಟ್. ಕ್ಲರ್ಕಿಗೆ ಅಯ್ಯ ನೀನ್ ಹೇಳ್ತಿರೋ ತಪ್ಪು, ತೆಗಿ ಪುಸ್ತಕ ಓದು. ಅಲ್ಲಿ ಅವನಿಗೆ 2 ನಿಮಿಷ ಅಲ್ಲಿ ಹೇಳಲಿಕ್ಕೆ ತಯಾರಿರಲ್ಲ, 20 ನಿಮಿಷ ಇಲ್ಲಿ ನಿಂತು ನ್ಯಾಯಾಧೀಶರೆದ್ರು ಕ್ಲರ್ಕ್ ಹೇಳಿದ್ದನ್ನ ಕೋರ್ಟ್ ಒಪ್ಪಬೇಕು ಅನ್ನೋದನ್ನ ಕನ್ವಿನ್ಸ್ ಮಾಡ್ಲಿಕ್ಕೆ ನೋಡ್ತಾರೆ. Though counsel himself is clear and aware that what the clerk has told or advised or suggested was not in accordance with law. ವಕೀಲರೇ, ನಿಮ್ಮ ಸಾಮರ್ಥ್ಯದ ಮೇಲೆ ನಂಬಿಕೆ ಇಡಿ. ನೀವು ವಕೀಲರು, ಆತ ಅಲ್ಲ. ಯು ಆರ್ ಇನ್ ದಿ esteemed position, honor, designation, reputation, not him. It is quite natural or expected of him to commit some error, but it is for you to enlighten him, impart knowledge, show him that he is not correct so that he can understand what the correct position of law is, and henceforth he would not cause any inconvenience to any of your learned friends. You are in such a esteemed position, such a respectable position. This is one such case. 2021 ನಲ್ಲೇ ನಿಮಗೆ ನಾನು ಹೇಳಿದೆ, ನಾನು ಇದನ್ನೆಲ್ಲ ರೈಟಿಂಗ್ ನಲ್ಲಿ ಇಟ್ಟರೆ ನಾನು ಎಕ್ಸ್ಪ್ಲನೇಷನ್ ಎಲ್ಲ ಕೇಳಬೇಕಾಗ್ತದೆ. ಐ ಹ್ಯಾವ್ ನೋ ಹೆಸಿಟೇಷನ್, ನಾನ್ ಬೇಕಾದ್ರೆ ಮಾಡಬಲ್ಲೆ ಅಲ್ವೇ? ನೆನಪಿದೆ. ಅಷ್ಟೆಲ್ಲ ಆಗೋದು ಬೇಡ, ಅವ್ರಿಗೆ ಎಂಬರಾಸ್ಮೆಂಟ್ ಆಗೋದು ಬೇಡ ಅಂತ ಆಗಿರೋದ್ರಿಂದ ನಿಮಗೆ ಟೈಮ್ ಕೊಡಿ ಸರ್, ನಾನೇ ಇನ್ನೊಮ್ಮೆ ಟ್ರೈ ಮಾಡ್ತೇನೆ, ಅಥೆಂಟಿಕೇಟೆಡ್ ಕಾಪೀಸ್ ಒಬ್ಟೈನ್ ಮಾಡ್ಕೊಂಡು ಹಾಕ್ತೇನೆ ಅಂದ್ರೆ ಟೈಮ್ ಕೊಟ್ಟೆ. ಆಮೇಲೆ ಒಂದು ಅಡ್ಜರ್ನ್ಮೆಂಟು ಕೊಟ್ಟೆ. ನನ್ನ ಕಷ್ಟ ನೋಡಿ, ನಾನು ಎಷ್ಟೆಲ್ಲ ಹಳೆದನ್ನು ರಿಕಲೆಕ್ಟ್ ಮಾಡ್ಕೊಳ್ಬೇಕು.
ಇನ್ನೊಂದು ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡ್ಬೋದು ಅಷ್ಟೇ ನಾವು.
ನಾನು ಹೇಳಷ್ಟು ಹೇಳಿದೆ, ಕೌನ್ಸಿಲ್ ಟು ಕೌನ್ಸಿಲ್ ಆಗಿ. ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಆಸ್ ಎ ಜಡ್ಜ್ ಐ ಕೆನಾಟ್ ಟೆಲ್.
2 weeks time.
ಹತ್ತು ದಿವಸ ಕೊಡಬಲ್ಲೆ, ಹಬ್ಬಬ್ಬ ಅಂದ್ರೆ ಅದು ಪೆರಿಮಿಟರಿ ಆರ್ಡರ್. There are counsel for the appellant who is physically present, submit that who is making effort to secure an authenticated copy of the impugned judgment by the competent court. However, due to the transfer of the presiding officer who is the author of the impugned judgment, there is some delay in obtaining the copy. This he prays for a week's accommodation. Next, perusal of the arbitration to go to show that for the very same purpose, as long back as in the year 2021, 2 adjournments were granted to the appellant to do needful. Still no progress. Still, the sole office objection due for complaints is not complied by the appellant. As such, though the appeal could have been dismissed for non-compliance of office objection, however, in the circumstance of the case, I am of the view that one more opportunity as ultimate opportunity be granted to the appellant. Accordingly, 10 days time is granted to the appellant to comply the sole office objection, which is due for complaints, failing which the appeal would stand on its own dismissal for non-compliance of office objection from the 11th day from today without any further order by this court or any further hearing in the matter.
One humble submission.
Please.
Since there is already another appeal is admitted, ಎಲ್ಲ LCRs ಎಲ್ಲ ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟಿದ್ರೆ ನನಗೆ find it difficult. ಆ ಬಿಲ್ ಅಲ್ಲಿ LCR ಕಾಲ್ಫಾರ್ಮ್ ಮಾಡ್ಬಿಟ್ಟಿದೆ ಇಲ್ಲಿ ಬಂದ್ಬಿಡ್ತಾರೆ ಹೈಕೋರ್ಟ್.
ಅದು ನಿಜವೇ,
2020
ಅದಕ್ಕೂ ಪರಿಹಾರ ಹೇಳಬಲ್ಲೆ, ಸುಲಭವಾಗಿದೆ. ಇನ್ನು ನೀವು 10 ತಿಂಗಳು 19 ದಿವಸ ಕಾಯಿರಿ, ಅವಾಗ ನಾನು ಇಲ್ಲಿರಲ್ಲ, ಅಲ್ಲಿ ಬಂದಿರ್ತೇನೆ. ಅವಾಗ ನಿಮ್ಮ ಕಲಿಗಾಗಿ ನಾನು ಎಲ್ಲದಕ್ಕೂ ಕೂಡ ತಕ್ಷಣದ ಪರಿಹಾರವನ್ನು, ಅತ್ಯಂತ ಸರಳ ಸುಲಭ ಉಪಾಯವನ್ನು ಯಾವುದೇ ದಕ್ಷಿಣ ಇಲ್ಲದೆ ಹೇಳಬೇಕು.
ಪ್ರಾಕ್ಟಿಕಲ್ ಅದು LCR ಬಂದ್ಬಿಟ್ಟಿದೆ. ಇವನ್ ಲಾಸ್ಟ್ ಟೈಮ್ ಐ ರಿಮೆಂಬರ್ ನಾವು ಅಲ್ಲಿ ಎನ್ಕ್ವೈರಿ ಮಾಡುವಾಗ ಬಿಕಾಸ್ ಆಫ್ ದಟ್ ಅದರಿಂದ ಇದೆ.
ನಾನು ಹೇಳಷ್ಟು ಹೇಳಿದೆ, ಅದಕ್ಕೆಲ್ಲ ನಾನು ಅಡ್ವೈಸ್ ಕೊಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ. ಅದು ಯಾವುದು ಸಮಸ್ಯೆಯೇ ಅಲ್ಲ. ನೀವೀಗ ಇಲ್ಲಿಂದ ನೇರ ಹೋಗಿ ಸಿಟಿ ಸಿವಿಲ್ ಕೋರ್ಟಿನಲ್ಲಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಎದುರು ಕೂತ್ರೆ 5 ಕಾಲರ ಒಳಗೆ ಎಂಟೈರ್ LCR ಅಲ್ಲಿರ್ತದೆ, ಸಿಟಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ತದೆ ಅಷ್ಟೇ. ವಕೀಲ ಆಗಿದ್ದಾಗ ನಾನು ಇಂಥದ್ದೆಲ್ಲದನ್ನು ಮಾಡಿದ್ದೆ.
ಅದು ಈಗ ಇಲ್ಲಿಗೆ ಬಂದ್ಬಿಟ್ರೆ ಅಗೇನ್ ದೇ ವಾಂಟ್ ಆರ್ಡರ್ ಟು ಸೆಂಡ್ ದ ರೆಕಾರ್ಡ್.
ಹೇಳಿಲ್ವೇ 5 ಒಳಗೆ ಹೋಗ್ತದೆ. ಅಷ್ಟರೊಳಗೆ ಅದೇನು ಆರ್ಡರ್ ಬೇಕು ಅದೆಲ್ಲ ಆರ್ಡರ್ಗಳನ್ನು ಕೂಡ ಸಂಬಂಧಪಟ್ಟವರಿಂದ ನಮ್ಮ ರಿಜಿಸ್ಟ್ರಿ ತಗೊಳ್ಬೇಕು. ಲೋಪ ನಿಮ್ಮದಿಲ್ಲ, ಲೋಪ ಇರೋದು ಕೋರ್ಟ್ ಕಡೆಯಿಂದ. ಹಾಗಾಗಿ ಅವ್ರು ಮೂಗಿಗೆ ದಾರ ಕಟ್ಕೊಂಡು ಮಾಡೇ ಮಾಡ್ತಾರೆ. ಅದು ನನ್ನ ಕೋರ್ಟಿನಲ್ಲಿ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಆದಾಗ ಹೋಗಿ.
Number 114, Sarvana, yes.
My lords, appearing for the appellants, my lords.
One sentence I see, in case the trial court records are required by the TCR ಬಂದಿದೆ ಏನ್ರಿ ಇದರಲ್ಲಿ? ಬಂದಿಲ್ಲ. TCR ಬಂದಿಲ್ಲ ವಕೀಲರು, ಎಲ್ಲಿ ಹೋದ್ರು? ಹೋಗಿ ಹಾಕ್ಬಿಡಿ, ನೋ ಪ್ರಾಬ್ಲಮ್. Yes, next.
Number 114.
My lords, appearing for the appellants, my lords, in this matter.
Yes.
Let's kindly seek short accommodation to file a paper of application, my lords. 3 times notice has been issued.
Probably, I have to pass a strong order in the matter. I am constrained and compelled by virtue of the observations in the previous order sheets. I am proceeding in that direction. Second, that the counsel for the appellant who is appearing through video conference prays for time and submits that he is required to file an application for substitute of service of notice upon unserved respondent number 1 to 8. Next line. Perusal of the order sheet would go to show that such a permission to carry out the substituted service of notice upon unserved respondent number 1 to 8 was accorded to the appellant as long back as on 28/3/2023, and he was directed to carry out the newspaper publication on or before 24/2023, showing the date of hearing as today's date. However, this fact of already obtaining such a permission by this court to carry out the substituted service of notice through paper publication was not disclosed by the learned counsel for the appellant in his submission today. Next line. In spite of there already being a permission to carry out the service of notice through substituted service, the appellant has not made use of the same, nor even shown any reason for not carrying out the substituted service of notice through paper publication, though was permitted on 28/3/2023. In the light of the above circumstances, particularly when the learned counsel for the appellant has not disclosed the order dated 28/3/2023, on the contrary, has made submission as though for the first time he is intending to make such an application before the court, and has not made use of the order passed in his favor on 28/3/2023, I do not find any reasons to grant some more time and one more opportunity. Accordingly, the appeal as against respondent number 1 to 8 stands dismissed for not taking appropriate steps to ensure service of notice upon them. By virtue of the dismissal of the appeal as against respondent number 1 to 8, the maintainability of the appeal as against the remaining appellant also is required to be held. Registry to proceed further.
My lord, from short accommodation, my lord, we'll file it.
Yes, next.
Seal number 115, Abhinav Ramanand A.
I
BCC.
appear for the appellant in this matter, my lord.
I am for the respondents in all these three appeals.
Along with connected matters,
First, my lord should kindly consider RFA 155 of 2021. In which
No, you are
my
for the
application-
respondent.
Yes,
1 minute. It appears that there is something to be done by the appellant in that matter regarding the
Yes,
service
yes,
of notices.
that is the reason why I have to trouble my lords for 2 minutes. This appeal was filed in the year 2020 by a person who did not file even written statement, let alone entering into the witness box. We are the landlords. We have already suffered at the hands of such a developer for the last 17 years. All the three joint owners who are the plaintiffs before the court are dead today. After filing of this appeal, two respondents died. Only LRs are there. Their LRs are also being harassed by this appellant in RFA 10,072. They don't comply with any of his objections. 155. Those who are placed ex parte before the trial court, they are not taking steps. They are sailing together. And this appellant had protracted the proceedings for the last 14 years during the pendency of the appeal. Ultimately, he did nothing except cross-examining me. And they were directed to furnish file the paper book. That also they do not do. On 5 occasions, I have requested this on court before different benches to decide about my IA, which is pending for vacating the interim order obtained by misleading the court or suppressing the material facts. I had filed caveat. They come and serve a copy of the appeal memo to me. They don't tell to the court. Registry fails to put up the caveat. Taking advantage of my absence, stay is obtained by a disinterested person. Property owners are dying now. They have died. Their LRs are also being harassed by this appellant. Not even written statement filed by this appellant. He did not even enter into the witness box. He did not come out with the truth before this on court to say that there is a caveat and I have served a copy. Kindly show the name of Sitaram Rao ಅಂತ ಹೇಳ್ಬೋದಿತ್ತು. ಅದು ಮಾಡಲಿಲ್ಲ ಇವರು.
Yes, appellant.
My lord, today, my learned friend is pressing for hearing on the application. But my lord, service is not complete. If a week's time is granted, my lord, I will go ahead and take necessary steps for service of notice on the unserved respondents.
They are not necessary parties at all for deciding the IA. It is our property. The fraudsters who created document in favor of the appellant are those parties. They were never contesting before the trial court. This sort of tactics was adopted even in the trial court, and matter was dragged on for more than a decade.
For the submission of learned counsel for the appellant in RFA 155/2021. And learned counsel for respondent number 6 to 12. 13 bracket A to G, 14 bracket A to C, 15. In the side appeal to video conference. For the submission of learned counsel for caveat or object respondent number 11. In RFA 1072/2020 and RFA 1713/2021. Learned counsel for the respondent oblique caveat vehemently submitted that the present appellants who remained expectant did not even file their written statement in the original suit, who obtained the order of the interim stay by this court in RFA 155/2021. And without even ensuring the service of the notices upon the unserved respondents, or intentionally dragging on the matter, thereby depriving the rights of the large number of owners of the property, putting them to severe inconvenience and prejudice. Further submitted that the present appellant and those unserved respondents are colluding with each other and intentionally or seeing that there is enormous delay, intentionally ensuring the delay in service of notice upon unserved respondent. He also submits that his IA 1/2022 is long pending, 1/2022 filed for vacating the interim order is pending since a long time. For contra, learned counsel for the appellant, who is appearing through video conference, submitted that if a week's time is granted, he would ensure the service of notice upon the unserved respondents. Next line. A perusal of the order sheets will go to show that in this appeal of the year 2021, on 8/6/2022, this court had passed the interim order on the following lines. Common. On IA 1/2021, the respondents are hereby restrained, etc., etc. Accordingly, IA number 1/2021 is allowed. The set date onwards till today, so a large number of hearing dates have come through in the matter. However, on all those dates, without recording much progress in the service of notice upon the respondents, the interim order came to be extended regularly till the next date of hearing. However, in the said process, no reasons are given for extending the interim order. Needless to say, next line, that while granting the interim order itself, this court had reserved the liberty in favor of the respondents to seek for vacation and modification of the interim order. As such, the submission of the learned counsel for the respondent oblique caveat that there is all the urgency in disposing of the IA 1/2022 filed by him requires. The request cannot be ignored. Further, it is also needless to say, when an interim order is granted for a limited period, it is generally expected of a reasoning for its extension further by the court. However, in none of the extended interim orders, in none of the orders wherein the interim order was extended, in this matter, the reason for extension has not been given, even after noticing that there was an IA pending for vacating the interim order. In such a circumstance, when the interim order was granted for a limited period, and the appellant could not able to ensure the service of notice upon the unserved respondents till date, despite sufficient opportunities have been granted to him. I am of the view that though a week's accommodation as prayed for by the responsible for the appellant be granted, however, the same would be without any order about the extension of the interim order.
My lord, may kindly see, my lord.
A week's
Lord,
time
I have taken
granted.
steps 3
There
times,
is no
Lord.
order for the extension of the interim order.
Lord, I
Yes.
have taken steps thrice, my lord. Addressee is left. Lord, I am ready to argue on the IA, my lord. I am only requesting a date to be fixed. Lord, I have promptly taken steps. There has been no delay or latches on my part, my lord.
Yes.
Therefore, my lord, there will be great, my lord, prejudice if interim order is not extended.
Next case.
Request it to be extended and, my lord, a date to be fixed.
Okay, reason ಕೊಟ್ಟಿದ್ದೇನೆ. Yes, next.
Vishwanath, Ramurthy CD correspondent.
Others list ಆಗಿದೆ.
Orders list.
Confuse ಆಗುತ್ತೆ.
Date has been
waiting.
Why it has come in the orders list today?
But it has been given today, awaiting the fire code record, that's all, we don't know.
Counsel for the appellant alone is physically present. Await TCR. Is the matter. The third week of June 2023. Considering the reasons shown by the, considering the submission made by the current counsel for the appellant that in case if the interim order is not extended, the same would cause prejudice to him, the interim order granted on 5/4/2023 is extended till the third week of 2020. Yes.
Bill number 117, Srimati B.V. Vidyulata, hearing on IA.
The submission of 11 counsel for the appellant. Both are main appeal and 11.9. Peruse the memorandum of appeal and the interim judgment. Issue notice to the respondents both on the main appeal and on A1/2019. Appellant to pay the necessary process and furnish copies in the registry if not already done within 4 days from today. In the meantime, call for TCR.
Yes. Bill number 118, we are Balraj.
Yes, please.
All of these are moved on. Bill for 2021. The next subject. Please. As per the order of this, 13/10/2022, I have compared all the office subjects. Academic could not be able to find the interview. The work order could not able, not very an academic, for explaining the delay. Will complete the office subjects. And as of now, there is no office subjects. Other office subjects are compared.
The request of the 11th counsel for the appellant. Today's time as period is granted to file objection, file affidavit in compliance with the order dated 12/4/2021. Is the matter 131/5. Yes.
Number 119, Abhinav Ramanand A.
My lord, in this, my lord, I want to retire from the matter. The client, my lord, has taken the file back. I will file a memo, my lord, by tomorrow.
Request of the 11th counsel for the appellant. Which time as period is granted. Yes.
Great.
Number 20, MJ Alva. We have 42 days with these two.
B. Sidramani advocate. Please.
VB Sidramaya. VB Sidramaya.
ಶ್ರೀ VB ಸಿದ್ದರಾಮಯ್ಯ ಅಡ್ವೊಕೇಟ್ ಅಂದಿ ಮತ್ತೆ ನೀವು ಅಡ್ವೊಕೇಟ್ ಅಂದ್ರೆ ಹಾಗೆ ಕೂಗಿಸಿದ್ರೆ ಹೇಗೆ ಮರ್ಯಾದೆ ಕೊಡೋದನ್ನ ಫಸ್ಟ್ ಕಲೀರಿ ವಕೀಲರಿಗೆ.
ಶ್ರೀ VB Sidramaya advocate.
Don't treat a litigant at par with learned counsels. ವಕೀಲರ ಹೆಸರು ಕೂಗಿಸ್ತಾ ಅದಕ್ಕೊಂದು ಘನತೆ ಇರ್ತದೆ, ಮರ್ಯಾದೆ ಇರ್ತದೆ. For the submission of the counsel for the appellant. Use the memorandum of appeal, IA and the impugned order. Issue emergent notice to the correspondence, both on the main appeal and on IA, 1/19. Appellant to pay the necessary process and furnish copies if not already done within a day in the register. Is the matter on 8/6.
Number 121, yes, Kalyan Basuraj, case Kaleshappa for R1.
Orders.
How the proposed respondent is connected to or interested to in the matter.
Is subsequent to the interim order not passed by the Assam court. Joint development agreement is executed by the defendant in favor of third party.
According to you, the present defendants have entered into a joint development
Yes.
agreement with the proposed defendant.
The subsistence of the interim order, in violation of the interim order, passed by the Assam.
You want that establishment to be implemented as a respondent in this appeal or a defendant in this.
Defendant in this suit.
Defendant in this.
I have also sought for amendment of the pleading.
Yesterday, they solved it. Well, actually, just 1 minute I will take.
No, before going to the merit, I am just on the application. Can you see impleading of a party as a defendant in a dismissed suit or were required to wait till the restoration of the suit and then file the application if it was required or warranted?
The appeal is being the continuation of the suit. Not.
So that is not for every purposes. Not for every purposes. ನಮ್ಮಲ್ಲಿ ಕೆಲವೊಂದು ಲೀಗಲ್ ಜಾರ್ಗನ್ ಹಿಡ್ಕೊಂಡು ಎಲ್ಲದಕ್ಕೂ ಅದಕ್ಕೆ ನಾವು ನೇತು ಬೀಳ್ತೀವಿ.
I'll examine that aspect. Okay, they have served the copies. I'll examine that aspect.
Suit came to be dismissed by the court.
ವಕೀಲರೇ ನಿಮ್ಮನ್ನ ಕೇಳುವ ಅವಕಾಶ ಕೊಡುವ There are counsels from both sides present. There are counsel for the appellant prays for a short accommodation. That means that you look into the aspect as to whether the proposed defendant can be arraigned as a defendant in this appeal. Can be arraigned as a defendant united comma the lady. When in fact the suit has stood dismissed by virtue of the impugned judgment and the present appeal is pending.
Is admitted.
The matter in the week after next. Yes.
Case number 122. Arjun Rego, Ganesh H. Kempanna for R1 and R2 along with connected matter.
RFA 45, that is. At 3/11/2022, the appeal was submitted. And interim stay of the interim judgment and decree, which has been continued from time to time. The
respondent has now filed an application for vacating the interim order. I have filed my objections to that. Objections are filed to my IA for the grant of the interim. Vacating stay, I have filed my objection.
When was the interim order was granted?
Dated 3/11/2022. Find the paper book, it may be listed for you. There is a short point involved. It is about admission to a club.
Paper order sheet ಗಳನ್ನ ಸಾರ್ಟ್ ಮಾಡಿ ಕೊಡದೆ ಹೋದ್ರೆ ನಾನು ಏನ್ ಮಾಡೋದು ಇದು ನನ್ನ ಮುಂದೆ ಸಿಗ್ನೇಚರ್ ಗೆ ಕಳಿಸುವ ಮುಂಚೆ ಈ ಪೇಪರ್ ಸಾರ್ಟ್ ಆಗಿದೆ ಅನ್ನೋದನ್ನ ಅಸರ್ಟೈನ್ ಮಾಡಿ ನನ್ನ ಮುಂದೆ ಸಿಗ್ನೇಚರ್ ಗೆ ಕೊಡಿ ಅಲ್ಲಿವರೆಗೆ ನೀವು ಟೈಪ್ ಮಾಡಬೇಕು ಇಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಇದೆ ಕೆಲವು ಆರ್ಡರ್ ಶೀಟ್ ಅದರಲ್ಲಿ ಕೆಲವು ಇದರಲ್ಲಿ ಎಲ್ಲ ಜಂಬಲ್ ಆಗಿದೆ ಇಂಟರ್ಮಿಕ್ಸ್ ಆಗಿದೆ ಕಂಟಿನ್ಯೂಟಿ ಇದೆ ಅದು ಸಾರ್ಟ್ ಮಾಡಿ ಕೊಡಲಿವರೆಗೆ ನನ್ನ ಮುಂದೆ ಸಿಗ್ನೇಚರ್ ಗೆ ಕಳಿಸ್ಬೇಕು ಯಾವ್ದು ಆರ್ಡರ್ ಹೇಳ್ತಿದ್ದಾರೆ ಅವ್ರು ಕೊಡ್ಲಿ
Lord, has your lordship taken RFA 45? In that, the order is dated 3/11/2022.
ಒಂದು ಕಡೆ RFA 45 ಅಂತ ಬರೆದಿದ್ದಾರೆ ಇನ್ನೊಂದು ಕಡೆ RFA 3/22 ಅಂತ ಬರೆದಿದ್ದಾರೆ ಇಲ್ಲಿ ಪೇಪರ್ಗಳನ್ನ ಸರಿ ಅರೇಂಜ್ ಮಾಡಿಲ್ಲ ನಮ್ಮ ಪೆಂಡಿಂಗ್ ನವರು ಅದಕ್ಕೆ ಅವ್ರಿಗೆ ಹೇಳ್ತಿದ್ದೇನೆ ಬಹುಶಃ ಅದು ಇಂಟರ್ವ್ಯೂ ಮಾಡ್ರು ಅವ್ರ ಕೈನಲ್ಲಿರೋ ಬಂಚ್ ಅಲ್ಲಿ ಇದೆ
Lord, I was defendant number 1 there.
1 second. To senior counsel, it appears that say unable to understand some order which is creating some confusion with me.
In RFA 45.
RFA 45/2022 on 3/11/2022 an interim order was granted, right?
Yes, after admitting the appeal.
Yes, after admitting the appeal, pending consideration of IA 1/2022, there shall be ad interim stay as prayed for till next date of hearing.
Yes.
Excellent. The next line says, if process fee is not paid within 3 days, the interim order granted would automatically stand vacated. Admittedly, the process was not paid within 3 days. Or was it paid?
My instructions are it was paid.
It was paid, huh? Nodi. If it is paid, no confusion.
Fact that I have a certified copy, without paying the process fee, they would not issue the certified copy. I would believe that the process fee was paid.
So the process was paid within 10.
At this point of time, I would.
Process memo is there, you have paid.
But there is an application which has been continued from time to time.
So application for vacating does not survive. You have to file objection to your IA.
Yeah, that objection has not been filed. In fact, pending.
You would file. Please.
I had filed a KVA on 3/11/2022. The court is name of the KVA certificate.
You gave it in which matter? RFA
45 only.
45 only. Yes.
The KVA are advocated in this state and it has not been charged for criminal. We are not able to appear on 3/11/2022. Because our name is not properly shown in the card issue. Therefore, we could not get the card issue.
The causal is to system.
The problem is known as a direct death component.
ಮತ್ತೆ ಆಫೀಸ್ನವ್ರದ್ದು ಏನ್ರಿ ತಪ್ಪಿದೆ? ನೀವು ತೀರಾ ಅಪರೂಪವಾದ ಹೆಸರುಗಳನ್ನ ಇಟ್ಕೊಂಡ್ರೆ ಅವ್ರೇನ್ ಮಾಡ್ತಾರೆ? ಯಾವ್ದು ನೆನಪಿಗೆ ಬರ್ತದೆ ಅದನ್ನ ಹಾಕ್ತಾರಪ್ಪ. ಸರ್ವದೇವರು ಒಂದೇ.
Let me make this clear. The issue involved is very short in a very narrow compass. It is not the plaintiff, the relief that he sought was that I, as the defendant club, should issue a form to him. The injunction, the mandatory injunction which he sought, not I have extracted the prayer at page 21.
No, appellant, whether appellant was a defendant.
Yes, Lord. The appellant, there are two appellants in RFA 45. They were defendant 1 and 2 in this suit. But the relief sought in this suit, I have extracted at page 21 of my appeal memo.
1 second.
In the suit, there were 13 defendants. And the present appeal, that is 45, is by defendant 1 and 2. And the other defendants have filed the other, the remaining 11.
ಹೆಸರು ತಪ್ಪು ತೋರಿಸಿದ್ದಾರೆ. ಹೇಳಿ.
When we general word, we all name search with the surname. I don't think in the second name there was any error. We all do the name search with the first name and the second name. So one of them will pop up.
It is between you. You have ಹುಡುಕ್ತಿರ ಅವರೇ ಹುಡುಕ್ತಾರೆ.
Anyway, my lord, the prayer I have extracted at page 21 in my appeal memo. Prayer in the suit. The lordship kindly turn to page 21 in my appeal memo.
1 minute. Today, the matter is slated also for the purpose of ensuring the service of notice as against unserved respondents number 3 to 10. In the main matter, it is for ensuring the service of notice.
My learned friend Mr. Vigo appears in that.
Among respondent number 3 to 10 in the first appeal, RFA 3/2022, are there any respondent who is appearing in, who are also the respondent in connected appeal RFA 45 of 2020? Whether notice is ordered in RFA 3/2022? No, respondents number 1 and 2 were caveators. Whether notice was ordered as against the other respondents? Degree 3/22 order sheet. 1 second. If it is ordered, fine, otherwise we will do need. I am unable to get the said order as to when the notice was ordered for the respondent. Would you be able to tell me the date so that I can easily point it out? No. What is our common parties? Everything is okay, but the thing is, if the notice is not ordered in one matter and ordered in another matter, I cannot proceed further. I have to bring both and synchronize both the matters, ensure that notice is ordered against all the parties and all of them are served. If notice is not ordered in your appeal, I can order for issuance of notice, and whosoever have been served in the connected matter, I can direct them to accept notice in your appeal. That will save a lot of time.
For instance, my lord,
Yes.
in that RFA 3, respondent number 3 and 4 are the ones that are appellant in my appeal. And my briefing counsel can take notice.
Yes, that is it. I will come to that. It's what I want. Because in RFA 45, it appears that large number of respondents have been served or attempted to be served. Respondent number 3, Bangalore Club. Respondent number 4, Bangalore Club, represented by its president and the secretary. Whether the counsel for the appellant in RFA 45/2022 would take notice for them,
Will accept.
for both the president and the secretary.
Yes. Third and fourth.
Yes, third and fourth respondent. Let senior counsel for the appellant in RFA 45/2022, learned counsel for the appellant in RFA 3/2022, and learned counsel for K-Vators of the respondent number 1 and 2 in both the appeals are physically present. Next line. Learned counsel for the appellant in RFA 45/2022, who is also physically present, accepts notice for respondent number 3 and 4 in RFA 3/2022. Survey copy, if not already served.
Already handed.
And acknowledges the receipt of the copy of the memorandum of appeal. And also prays for a week's time to file wakalat for respondent number 3 and 4. She is permitted to do so. Respondent number 5, Mohammed Zaki Khalili, is respondent number 5 in the other matter also. Is it that for the said respondent, Mr. Mohammed Zaki Khalili, you are appearing in the connected appeal? Then how can you take notice for him? No, you are appearing for the respondent number 5 in your appeal. Three are the representatives of kind of part 2 and 3. The remaining from 16 members. After the suit was decreed, an appeal was filed by 5 of the appeal in RFA. The respondents, formal respondents in the case are the greatest in the suit in for the trial court, and the other defendants in the case as in the suit before the trial court. So they have been treated as 4 and 5. The other defendants are formal defendants because they were not present in fact when the suit was the appeal was filed. So the appeal was filed on behalf of 5 of those original defendants. The issue basically is that we have no real case against them because That is true, Mr. Counsel. That is at the second stage. My endurance is in the beginning, before proceeding in the matter, as you are aware, the very first stage and the very first step in a litigation, civil litigation is service of notice upon the opponents. Service of notice upon the opponent. Once the service of notice is completed upon the opponent, inviting their pleading, if any, of course, in this appeal, the question of inviting their pleading doesn't arise. The preliminary formality should be completed, and then we can proceed further on the merit or other aspects of the case. As such, since notice is shown to have been either served and accepted or attempted to be served to the respondents in RFA 45/2022, but no such attempts appears to have been made in your appeal, I am now trying to ensure that the respondents in your appeal are also required to be served. Those respondents who are now present through their counsels, like the appellant in the counter appeal, if they accept the notice by themselves, you need not have to pay process for them. And that will save time. With respect to other respondents who have not accepted, you have to take steps. In the said process, my question is, in your appeal, you are appearing for the appellant. Which appellant was defendant number 3, 4, 7, 8, and 9 in the original suit? In your appeal, you have arraigned fifth defendant in the original suit as the fifth respondent. Incidentally, for the very same defendant come respondent, you are appearing in their appeal. That means in the other appeal, for the present respondent number 5 in your suit, you are appearing. And for the very same person who is respondent, you want to continue both for the appellant and for your own respondent number 5. Exactly. The second point. Yes. Then there will be difficulties forming. Then complete the service of notice formalities before we could proceed. That is left to you, your option, because you are the master of your appeal. How do you decide whether to give up or transpose or what to be done? That is left to you. There should not be any conflict of interest. So today we have to adjourn the matter to ensure the completion of service of notice. The meantime, you think whether you are required to file objection for vacating the stay. Till then, you want to retain your IA for vacating the stay, or you don't press the said IA with the liberty to file objection to his IA. The learned counsel for the appellant in RFA 3/2022 prays for a short accommodation to ensure the service of notice upon the unserved respondents. Next line. It is also noticed that the learned counsel for the appellant in RFA 3/2022 is a counsel for the respondent number 5 in connected RFA 45/2022. Incidentally, the said respondent number 5 in RFA 45/2025 is also the respondent number 5 in RFA 3/2022. Next slide. Learned counsel for K-Waiter of the respondent number 1 and 2 submits that If IA 1/22 is still pending consideration, he would file his objection to IA 1/2022 in RFA 45/2022 and simultaneously may submit of not pressing IA 1/23 filed by him seeking vacating the stay. This is the matter in the week after next as prayed.
Till then, Lord.
ಇದೆಯಾ interim order?
ಹೌದು, ಇದು interim order.
ಯಾವುದರಲ್ಲಿ ಇದೆ? ಎರಡರಲ್ಲಿಯೂ ಇದೆಯಾ?
Okay, in my appeal.
Your appeal.
In 45 is there.
There is a stay will also. There is also direction to dispose it. Paper is filed by 8. The order was made on.
Will file. By the time it is called out next time.
ನನಗೆ ಅಲಾಟ್ ಆಗಿರೋದು 2017ನೇ ಇಸ್ವಿಯಿಂದ ಮ್ಯಾಟರ್ಗಳು. 2017ನೇ ಇಸ್ವಿಯ ಮ್ಯಾಟರ್ಗಳಲ್ಲಿಯೂ ಕೂಡ ಇನ್ನೂ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಲಿಲ್ಲ. ನಿನ್ನೆ ರಿಜಿಸ್ಟ್ರಾರ್ P&S ನ ಕರೆಸಿದ್ದೆ. 2011 ಒಂದು ಮ್ಯಾಟರ್ ನಲ್ಲಿ ಇನ್ನು ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ ಅಂದ್ರು. 12 ವರ್ಷ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಲಿಲ್ಲ. ನಾನ್ ಬಂದ್ರ ಮೇಲೆ ಎಲ್ಲ ಹುಡುಕಿ ತೆಗಿರಿ ಅಂತ ಹೇಳಿ ಪಾತಾಳ ಗಡ್ಡಿ ಹಾಕಿ ಹುಡುಕಿದಾಗ ಅದೊಂದು ಫೈಲ್ ಸಿಕ್ಕಿತ್ತು. ಆ ಫೈಲೇ ಮಿಸ್ ಆಗಿತ್ತು. ಅಂತ ಪರಿಸ್ಥಿತಿಯಲ್ಲಿ ಇದು ಕೇವಲ ಕೆಲವೇ ತಿಂಗಳಾಗಿದೆ ಪೇಪರ್ ಬುಕ್ ಫೈಲ್ ಮಾಡಲಿಲ್ಲ. ಸರ್ವಿಸ್ ಒಂದು ಆಗ್ಲಿ ಅವ್ರಿಗೆ ಡೇಟ್ ಕೊಡಬಲ್ಲೆ, ಡೇಟ್ ಕೊಡ್ಲಿಕ್ಕೆ ಏನು ಅಭ್ಯಂತರ ಇಲ್ಲ. ಅಷ್ಟರೊಳಗೆ ಸರ್ವಿಸ್ ಅವ್ರು ಎನ್ಶೂರ್ ಮಾಡಿ ಬಿಟ್ರೆ ವಿ ಕ್ಯಾನ್ ಪ್ರೊಸೀಡ್ ಫರ್ದರ್ ಇನ್ ದ ಮ್ಯಾಟರ್. No, in that state, before considering your application, notice is required to be served upon the respondent. ತಾವೆಲ್ಲರೂ ದೊಡ್ಡ ದೊಡ್ಡ ವಕೀಲರು ಇದ್ದೀರಿ, ಎಲ್ರಿಗೂ ಗೊತ್ತಿರ್ತದೆ. ಯಾಕೆ ನನ್ನನ್ನು ಸುಮ್ಮನೆ ಒಂದು ಬಾಣ ಬಿಟ್ಟು ನೋಡೋಣ ಅಂತ ಕಲ್ಲು ಹೋಗ್ಯೋಣ ಮಾವಿನ ಹಣ್ಣು ಉದುರಿದ್ರಾಯ್ತು ನಂಗೆ ಯಾಕೆ ಟ್ರೈ ಮಾಡ್ತೀರಿ? ಇಷ್ಟ ಮ್ಯಾಟರ್ ಇನ್ ದ ವೀಕ್ ಆಫ್ಟರ್ ನೆಕ್ಸ್ಟ್ ತಗೊಂಡ್ರಿ ಅಲ್ವಾ? ಎಸ್. ಯಾವಾಗ ಬೇಕು ಹಾಕೊಳ್ಳೋಣವೇ? 12th June. Is the matter in the week after next better? Is the matter on 12/6, 2023 as stated.
RFA 45 interim order to be.
Interim order granted. ಲೇಟೆಸ್ಟ್ ಯಾವಾಗ ಬಂದಿತ್ತು ನಿಮ್ಮ RFA 45? 24/3. Interim order extend ಆಗಿಲ್ಲ. Therefore, I cannot extend the interim order what was not there in existence as on the previous date of hearing.
In 45 it was when my learner friend submitted. Because in the trial court, not before the execution petition, in the execution petition, they are sought for arrest of the office bearers.
No, I will not do it. Not do this.
But I myself was present.
ಅದನ್ನು ಬರ್ಸ್ಬೇಕು, ಬರ್ಸಿದ್ದಾರೆ ಅಂತ ನೋಡ್ಬೇಕು. ಈಗ ನಾನು ಎಷ್ಟು ತಾಳ್ಮೆಯಿಂದ ನಿಧಾನವಾಗಿ ವ್ಯವಧಾನದಿಂದ ಮಾಡ್ತೇನೋ ಹಾಗೆ ಮಾಡಿಸ್ಬೇಕು ನೀವು ನ್ಯಾಯಾಧೀಶ.
I am sorry, I should have verified. But my lord, it was continued from time to time. My learned friend Mr. Vigo was also present.
ಅವತ್ತಂತೂ ಆಗ್ಲಿಲ್ಲ.
It is not.
ಆಗದೆ ಇರೋದನ್ನ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ.
It is our mistake.
The learned counsel is submitting that he is not, he would not continue any coercive action or step against you. ಅಂತ you can best say repose confidence in his submission.
Lord, since Lord, my learned friend also agreed that there was an interim order.
ಅವ್ರನ್ನ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿ.
On 3/11, what was?
Sir, it is for you to request him. If he says no objection, I will extend. ಅದು ನಿಮ್ಮಿಬ್ಬರು ಗುಡ್
what he means is
ನೀವು
that-
ಕೇಳಿ ಅವ್ರಿಗೆ ಪರವಾಗಿಲ್ಲ ಮೈ ಲಾರ್ಡ್ ಮಾಡಿಬಿಡಿ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅಲ್ವಾ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ನಾನ್ ಮಾಡ್ತೇನೆ. ಅದು ನಿಮ್ಮಿಬ್ಬರ ನಡುವೆ ಇದೆ.
He is aware that it was granted and it was continued from time to time. But I'm sure he would.
ಆಗಿ ನಾನು ಅದನ್ನ ಇಲ್ಲ ಅಂತಲೂ ಹೇಳ್ತಿಲ್ಲ, ಹೌದು ಅಂತ ಒಪ್ಕೊಳ್ತಿಲ್ಲ. ನನಗ್ ಬೇಕಾಗಿರೋದು ಈಗ ನಾಗಭೂಷಣ್ ಅವರು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಿ ಅಬ್ಜೆಕ್ಷನ್ ಇಲ್ಲ ಅಂದ್ರೆ ಮಾಡ್ತೇನೆ, ಅವ್ರು ಇದ್ದವ್ರು ಏನ್ ಮಾಡ್ಲಿಲ್ಲ ಅಲ್ವಾ, ಏನು ಅವಘಡ ಏನು ಸಂಭವಿಸಿಲ್ಲ, ಸಂಭವಿಸೋದು ಇಲ್ಲ ಅಂದ್ರೆ ನಾನು ಸುಮ್ಮನೆ ಇರ್ತೇನೆ. Learned Senior Counsel for appellant in RFA 45/2022. Praise for extension of interim order passed in RFA 45/2022. Nextly, a perusal of the order sheet will go to show that on the previous date of hearing, that is on 4/3/2023, the said interim order was not extended. Next line. However, the learned counsel for KVATR subject respondent number 1 and 2 in RFA 45/2022 undertakes that he would not take any coercive step in the execution proceeding against the appellants in RFA 45/2022 till the next date of hearing.
I'm good.
Excuse me. 23 one carry. Still number 123. Sri Bhat Rajaram Devro. ಅದೇ ಸೈಡ್ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೀರಾ? ಅದು ಅಬ್ಜೆಕ್ಷನ್ ಇದ್ರೆ ನೋಡ್ಬೇಕಲ್ಲ ನಾವು. ಅಪಲೇಟ್ ವಕೀಲರನ್ನು ಕೂರಿಸ್ರಿ. ಮತ್ತೆ ಇಲ್ಲಿ ಬನ್ನಿ. The counsel for the appellant is physically present.
Court has been already served with the notice. We issued the first response.
Issue notice to the proposed respondents number 3A to 3C on IA 1/23. The appellant to pay the necessary process and furnish copies in the registry, if not already done, within 4 days from today.
Product number 1 will be reissued. 2 times it was returned as unserved.
Respondent ಗೆ ಕಳಿಸಿದ್ದು ಅಂತ ಹೇಗೆ ಗೊತ್ತಾಗುತ್ತೆ ನಿಮಗೆ? ಇದರಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಇರೋದು ಕೇವಲ ಕನ್ಸೈನ್ಮೆಂಟ್ ನಂಬರ್ ಮಾತ್ರ. ಪಾರ್ಟಿಗಳ ಹೆಸರಿರಲ್ಲ, ಏನಿರಲ್ಲ. ಈ ಫಸ್ಟ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಡಿಸ್ಪ್ಯಾಚ್ ಆಗಿರೋದು ಇದೇ ಕನ್ಸೈನ್ಮೆಂಟ್ ನಂಬರ್ ಅಂದ್ರೆ ಮಾತ್ರ ನಾವು ನೋಡಿದ್ವಿ.
R1
ಮಲ್ಲೇಶ್ವರಂ ಕೂಡಲೇದಾಗಿದೆ ಅಂತಲ್ಲ ಇದರಲ್ಲಿ ಮಲ್ಲೇಶ್ವರಂನಲ್ಲಿ ಅದು ಈ ಕೇಸಿನಲ್ಲಿ ಪಾರ್ಟಿ ಮಲ್ಲೇಶ್ವರಂಗೆ ಹೋಗಿರ್ಬೋದು, ಇನ್ಯಾವುದೋ ಕೇಸಿನಲ್ಲಿ
Lord.
ಪಾರ್ಟಿಗೂ ಮಲ್ಲೇಶ್ವರಂಗೆ ಹೋಗಿರ್ಬೋದು. ನಿಮಗೆ ಬೇಕಾಗಿರೋದು ನಮ್ಮ ಟಪಲ್ ಸೆಕ್ಷನ್ ನಲ್ಲಿ ಈ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಮುಂದೆ ನೋಟಿಸ್ ಸೆಂಟ್ ಅಂಡರ್ ಕನ್ಸೈನ್ಮೆಂಟ್ ನಂಬರ್ ಅಂತ ಈ ನಂಬರ್ ಹಾಕಿದ್ರೆ ಮಾತ್ರ ಅದು ಐಟಮ್ ಡೆಲಿವರ್. ಇಲ್ಲದೆ ಹೋದ್ರೆ ನಾವು ಇದನ್ನೇ ತಗೊಳ್ಬೇಕಾಗ್ತದೆ. ಹಾಗಾಗಿ ರಿಜಿಸ್ಟರ್ ಇದನ್ನೇ ಬರೆದಿದ್ದಾರೆ ಅಂತೇಳಿ ನಾವು ಅದನ್ನೇ ನಂಬೇಕಾಗ್ತದೆ. ಕನ್ಸೈನ್ಮೆಂಟ್ ನಂಬರ್ ಇವ್ರೇನಾದ್ರು ಚೆಕ್ ಮಾಡಿದ್ರೆ ಅಥವಾ ನಿಮಗೇನಾದ್ರು ಗೊತ್ತಿದ್ರೆ ಅವಾಗ ನಾವು ಕನ್ಸೈನ್ಮೆಂಟ್ ನಂಬರ್ ಟ್ಯಾಲಿ ಆಗ್ತದೆ, ಇಲ್ಲಿ ಡೆಲಿವರಿ ಇರ್ತದೆ, ನೀವೇ ಇನ್ಸಫಿಷಿಯಂಟ್ ಅಡ್ರೆಸ್ ಅಂತ ರಿಟರ್ನ್ ಮಾಡಿದ್ದೀರಿ ಅಂತ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ R1 and 2 answer ಒಳಗೆ ನೀವು ಸ್ಟೆಪ್ಸ್ ತಗೊಳ್ಳಿ.
Already did and already the other appellant students are all on record. 2 days. Wait for the minute. And 3 is now created in the month of February and 4th has been already served. The game is R3 ಗೆ ಹೋಗ್ಬೇಕು.
R2
already did and the other appellants and respondents are the LRs. She is a mother. 2 is a mother. Yashoda is the mother of all the other parties.
To take fresh steps to ensure the service of notice upon the answered respondent number 1. We set 4 days in the registry. Needful then registry to proceed further. Yes. For other matters, show it as not reached and adjourn the matter. Further argument ಹೊಂದಿದೆ. ಕಡಿಮೆ ಇದೆ, ಮುಗಿಸಿ ಬಿಡಿ. ಒಂದು ರೌಂಡ್ 124 ಬೇಗ ಬೇಗ ಮುಗಿತದೆ.
Admission matter, case number 124, KM Somshekara.
Yes. Yes. Make use of the microphone.
Lord, I have to serve the copy of the respondent number 2, Lord, I'll be doing it.
The respondent number 2, who is appearing for respondent number 2? Copy without leave of the court. Why did you serve copy to him? He has not yet filed wakalat.
Yes, my lord, he has not filed the wakalat.
Then unless he files wakalat, he got no locus standi to represent any party.
Lords, but there is order of this court to serve the copy to the respondent.
Order of the court is served copy to respondent number 2, not to his counsel.
Yes, my lord, I'll do that.
Wakalat haki copy ತಗೊಳ್ಳಿ. Yes, learned counsel from both sides present. Learned counsel Sri Ashwin is already praised for a week's time to file wakalat for respondent number 2.
Date may be fixed.
The counsel for the appellant also praised for a week's time to ensure the service of copies upon the respondents. List the matter in the week of the next. Yes.
25, Sri K. Svenkaramana, Jagannath HT.
I appear for the appellant, my lord.
Yes.
My lord, this is the suit appeal filed against the judgment and decree in OS number 2340 of 2013, my lord.
Respondent ಇದ್ದೀರೇನ್ರಿ? ಯಾವಾಗ ಬೇಕ್ರಿ?
Immediate may be.
There are counsel from both sides present. Since the court time is over, the matter could not be proceeded today. This matter in the week after next. Yes.
Case number 126, Sri Shanmukappa, Sri Ravi Ji Sabahit.
Counsel for the appellant present. Since the court time is over, list the matter in the next week.
Case number 127, Venkatesh K.
ನೋಟಿಸ್ ಆಗ್ಲಿಲ್ವಾ ಇದ್ರಲ್ಲಿ ಇನ್ನು? What the appeal is for?
And degree cost,
In a suit for?
partition and separate portion.
ಯಾಕೆ ಸೋತ್ರಿ?
Is that the case for now? The
ಅಲ್ಲ, reason for
court law as
dismissal of your suit.
court law has taken the contention that they have not made the revenue entries on the basis of the revenue entries, the suit not been decreed. Contention has been taken. This is the case is four members of the Doddamunaya and first son of Doddirappa is not having the issues. Here, 1925, the partition has been taken place. As for the partition, some of the properties have been left over. They are in joint position. Other portions of the suit schedule properties have been allotted to the Doddamunaya. Partition among the brothers.
Or to admit notice. To pay the process and furnish copies in the registry if not already done within a week from today. TCR. Yes.
Bill number 128.
May activate for. They apply. But relations, my lord, there was a delay in securing relationship by the trial court.
Suit was for
For mandatory injunction, my lord.
mandatory injunction of what?
Change of name, my lord. Here,
Change of name in what?
change of name from Muhammad Ibrahim to M.I. Ibrahim. That suit was came to be dismissed by the trial court. Actually, issue number 1 is held in the affirmative. It says that there is a change of name as such. But issue number 2 and 3 in the negative. Issue number 2 without the reasoning given for issue number 2 is in total opposition to what is the findings given by the trial court. Well, even regarding limitation, that this issue is answered in the negative, but the finding is given in the affirmative.
For the submission of legal counsel for the appellant. Issue notice to the respondents. Appellant to pay the necessary process and furnish copies in the registry if not already done within a week from today. Call for PCR. First sentence ತಗೊಳ್ಳಿ. For the submission ಆದ್ರ ಮೇಲೆ the affidavit filed by the appellant explaining the reasons for delayed compliance of office objection is taken on record. Yes, next.
Number 129, Sri B.C. Venkatesh Shanmukappa for R1 to R3.
Able to sort of objection to my application.
Counsel from both sides present. If the court time is over, matter could not be proceeded today. List the matter in the week of next. Objection ಹಾಕಿದ್ದೀರಿ? ಹಾಕಿಲ್ಲ ಇನ್ನು. In the meantime, the respondent of the case to file their objection to IA 1/23. If you need. Objection if you need to IA 1/23. Yes.
Further argument, seal number 130, Srimati B.B. Nidhishri.
Yes. When we will have it? Day after tomorrow?
Next week, my dear.
Next week? Learned counsels from both sides present. Since the court time is over, the matter could not be taken up today. That matter could not be proceeded with today. List the matter on 29th, 30th, 30th.
Very well.
30/5/2023. ಇಬ್ರು ರಿಸರ್ಚ್ ಮಾಡಬೇಕು. ನಿಮ್ಮ ಕಲಿಗೆ ಹೇಳಿದ್ದೇನೆ ನೋಡಿ, ಯಾವ್ದಾವ್ದು ಪಾಯಿಂಟ್ ಇದೆ ಅಂತ ಬರ್ಕೊಂಡಿದ್ದಾರೆ ಅವರು.
Seal number one, final hearing matter, seal number 132. Srikanth S. Sri Ramesh Goda KFR, Arco.
Learned counsel for the appellant alone present. Since the court time is over, the matter could not be proceeded today. Wish the matter in the next week. Yes.
Seal number 133, for the appellant here 6%. Arthur has expired.
Counsel for the appellant and respondent number 1 are physically present. Yaar expire?
R1 is expired. He is filing a memo.
Sorry.
16/5/2023.
Counsel for respondent number 1 files a memo reporting the death of respondent number 1 on 15/5/2023. And counsel for the appellant acknowledges the receipt of the copy of the memo and prays for 2 weeks time to do needful in the matter. Time has been granted. Yes.
Number 134. CK. Interim Shetty.
Respondent.
Ramesh Ananthan for respondent.
Respondent.
Counsel for the respondent alone present. List the matter in the week of the next. Yes.
Seal number 135. Srinivas Murthy, day.
Appellant will be.
Counsel for the appellant alone present. Since the court time is over, matters should not be proceeded today. Week after next. Second week. List the matter in the second week of June 2023. ನೋಡ್ರಿ ಅದೊಂದು ಪಾಸ್ ಓವರ್ ಆಗೈತಿಲ್ರಿ, ಅವಾಗ ಅವ್ರು ಪ್ರಶ್ನೆ ಒಂದ್ ವರ್ಡ್ ಉತ್ತರ ಕೊಡ್ಲಿಲ್ಲ. 107 ಅಲ್ವೇನ್ರಿ? ನಿಮ್ಗೆ ಕ್ಲೂನು ಕೊಟ್ಟೆ, ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1 ಅಂತ. ನೀವು ಅದನ್ನ ಬಿಟ್ಟು ಉಳಿದಿದ್ದೆಲ್ಲ ಹೇಳಿದ್ರಿ.
Seal number 107.
ಯಾಕದ್ ಮರ್ತೋಯ್ತು? The plaintiff share does not exceed ₹10,000 ಅಂತಾರೆ. ಈಗ ಕೌಂಟರ್ ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ ಅಂತ ನೀವು ಅಂತೀರಿ. ಈಗ ನಿಮ್ಮ ಅಪೀಲ್ ನಲ್ಲಿ
48 lakhs rupees I have valued the settled property. Respondent in file ಮಾಡಿದ್ರು OS partition. He has valued the 14 lakhs rupees. Same scheduled property.
Now, you are appellant here.
Yes.
You were the defendant in the trial.
Yes,
You were the defendant in the trial.
OS number 91.
In OS number 91. OS number 91 was valued for a particular amount.
14 lakhs. I have submitted.
It was valued for a particular amount, particular sum. The plaintiff's share in that suit has fallen less than ₹10 lakh. How can RFA would lie here? You should go before district court.
In the trial court has clubbed the both cases, the 233 and 91, my lord. I have same scheduled property. I have earned the 48 lakhs rupees. He has respondent has valued the same scheduled property 14 lakhs rupees. Both cases, the trial court has clubbed by the both cases and passed the common order.
ನಿಮ್ಮ ಸೂಟ್ ಏನಾಯ್ತು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Partly allowed, my lord.
ಅದ್ರ ಮೇಲೆ ಯಾರಾದ್ರೂ ಅಪೀಲ್ ಬಂದಿದ್ದಾರಾ?
ಇಲ್ಲ.
ನೀವು ಅಪೀಲ್ ಬರಲಿಲ್ಲ, ಅವರು
ನಾನು appeal ಬಂದಿದ್ದೀನಿ.
ಅವರು ಅದರಲ್ಲೇ ಸೂಟ್ ಕ್ಲಬ್ ಮಾಡಿ ಕಾಮನ್ ಆರ್ಡರ್ ಆಸ್ ಪಾಸ್ ಮಾಡಿ ಪಾಸ್ ಬೈ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್. ಅದರಲ್ಲಿ ನಾನು 2 RFA ಆಸ್ ಫೈಲ್ ಮಾಡಿ.
OS number 233 of 2003
Yes, this is
was
my
filed by you.
My suit.
What happened to that suit?
Clubbed the 2 cases and partly allowed by the trial court.
No, your suit was partly allowed. Any appeal is filed against that judgment?
No, my lord. He has not filed. Nobody has filed appeal against my suit.
So neither you have filed any appeal, nor he has filed any appeal.
No, my
Right? Then you go before district court.
lord. 2 cases already in division bench. In my lord, kindly in
2 cases ಅಂದ್ರೆ ಯಾವ್ದ್ರ ಮೇಲೆ ಬಂದಿರೋದು? 2 cases ಯಾವ judgment ಮೇಲೆ? OS 91 ನಾ 233 ನಾ?
91 ನಲ್ಲೂ ಬಂದಿದ್ದೀನಿ, 233 ನಲ್ಲೂ ಬಂದಿದ್ದೀನಿ.
ಇಷ್ಟೊತ್ತು ನಾನು 233 ಮೇಲೆ ಏನಾದ್ರೂ ಅಪೀಲ್ ಆಗಿದೆಯಾ ಅಂತ 1000 ಸರ್ತಿ ಬಡ್ಕೊಂಡ್ರು ನೀವು ಯಾರು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ, ನಾನ್ ಬಂದಿಲ್ಲ ಅಂತಿದ್ದೀರಿ ನೀವು.
ಫೈಲ್ಡ್ ಮೆಮೋ ಅಲಾಂಗ್ ವಿತ್ ವ್ಯಾಲ್ಯೂಯೇಷನ್.
ನೀವು ವಕೀಲರ ಒಂದೋ ಕನ್ನಡದಲ್ಲಿ ಮಾತಾಡಿ ಅಥವಾ ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಮಾತಾಡಿ. ನಿಮ್ಗೆ ಇಂಗ್ಲಿಷ್ ಸ್ಪಷ್ಟ ಅರ್ಥ ಆಗಲ್ಲ ಅಂದ್ರೆ ಕನ್ನಡದಲ್ಲೇ ಹೇಳಿ, ನನಗೇನು ಸಂಕೋಚ ಇಲ್ಲ ಕೇಳಲಿಕ್ಕೆ. ಆದ್ರೆ ಹೇಳೋದನ್ನ ಸರಿಯಾಗಿ ಹೇಳಿ. ಕೋರ್ಟ್ನ ಹಗುರವಾಗಿ ತಗೊಳ್ಬೇಡಿ. ನಾನೇನಾದ್ರೂ ಬರ್ಸಿದೆ ಅಂದ್ರೆ ನೀವು ನಿಮ್ಮ ಸರತ್ ಕಳ್ಕೊಳ್ತೀರಿ. ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದು ಬರೀ ಹಿರಿಮೆ ಮಾತ್ರ ಅಲ್ಲ, ಅದಕ್ಕೆ ಅರ್ಹತೆ ಬೇಕು. ಬೆಳಗಿಂದ ಗಿಣಿಗೆ ಹೇಳಿದಾಗ ಹೇಳ್ತಾ ಇದ್ದೇನೆ, ನಿಮಗೆ ಪ್ರಶ್ನೆನೇ ಸರಿ ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳಲ್ಲ ನೀವು. ನಮ್ಮ ಸಮಯ ಪುಕಟೆ ಬಂದಿರುತ್ತೆ. ಈ ಕ್ಷಣದಲ್ಲಿಯೂ ಕೇಳಿದೆ, OS 233 ನಲ್ಲಿ ಏನಾಯ್ತು? ಪಾರ್ಟ್ಲಿ ಅಲೋಡ್. ಆ ಪಾರ್ಟ್ಲಿ ಅಲೋಡ್ ಮೇಲೆ ಯಾವ್ದಾದ್ರು ಅಪೀಲು ಯಾರಾದ್ರೂ ಹಾಕಿದ್ದಾರಾ? ಯಾರು ಹಾಕ್ಲಿಲ್ಲ. ಆಮೇಲೆ ಮತ್ತೆ ನಾನು ಇನ್ನೊಂದು ಅಬ್ಸರ್ವೇಷನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಕೊಟ್ಟಾಗ 2 appeals are pending, ಅದ್ರಲ್ಲಿ ಇದ್ರ ಮೇಲೂ ಹಾಕಿದ್ದಾರೆ, ಅದ್ರ ಮೇಲೂ ಹಾಕಿದ್ದಾರೆ. ಏನ್ ಹೇಳಿ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು?
ನಾನು ಅವ್ರು ಬಂದಿದ್ದಾರೆ ಅಂತ ಹೇಳಿಲ್ಲ, ನಾನು ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಮಾಡಿ. I have filed the memo also, my lord. Order sheet also produced before the court, my lord. I have filed 15 to 23. Filed memo along with
Memo for what? Memo stating what?
valuation slip, my lord, 2 valuation slip and computerized order sheet.
ಬರೋಲ್ಲ,
Page number 6, that is
ಬರೋಲ್ಲ. ನೀವು ಕೆಳಗಡೆ ಕೋರ್ಟಿನಲ್ಲಿ ಸೇಮ್ ಪ್ರಾಪರ್ಟಿ ಬಗ್ಗೆ ಅವ್ರು ಸೂಟ್ ಹಾಕದಲ್ದೆ ನೀವು ಸೂಟ್ ಹಾಕಿದಾಗ ನೀವು ಅವ್ರು ಮಾಡಿರೋ ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಅನ್ನ ಯಾಕೆ ಚಾಲೆಂಜ್ ಮಾಡಲಿಲ್ಲ? ಅಲ್ವೇ? ಅದನ್ನಲ್ಲಿ ಮಾಡ್ಬೇಕಿತ್ತು. ಯಾವ್ದನ್ನ ಎಲ್ಲಿ ಮಾಡ್ಬೇಕು, ಹೇಗೆ ಮಾಡ್ಬೇಕು, ಏನು ಇಲ್ಲದೆಯೇ ಇಲ್ಲಿಯೂ ಕ್ಲಿಯರ್ ಆಗಿ ಏನು ಅಂತ ಹೇಳದೆಯೇ ಏನೋ ಹೇಳ್ತೀರಿ. ನಿಮ್ಮ ಮೆಮೋ ಆಧಾರದ ಮೇಲೆ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ರಿಟೈನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋಲ್ಲ. ನಿಮ್ಮ ಅಪೀಲ್ ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಇದೆ ಅಂದ್ರೆ ಡಿವಿಷನ್ ಬೆಂಚ್ ಇದೆ, ನೀವು ಆರ್ಡರ್ ತಗೊಂಡು ಆ ಮ್ಯಾಟರ್ ನ ತರಿಸ್ಕೊಂಡು ಕ್ಲಬ್ ಮಾಡ್ಬೇಕು. ಅದಕ್ಕೆ ಪ್ರಾವಿಷನ್ ಇದೆ, ಅದನ್ನ ಮಾಡ್ತಾರೆ ಕೂಡ.
valuation slip also produced. Valuation slip was to the 233. Another was
Heard the submission of learned counsel for the appellant regarding the office objection on maintainability of the suit in view of the valuation. Even according to the learned counsel for the appellant, the valuation made by the plaintiff in OS number 91/2003, wherein he claims to be a defendant before the trial court, was not challenged by him. As such, accepting the valuation made by the plaintiff in OS number 91/2023, the present appellant as defendant in the trial court proceeded with the suit and ensured its conclusion by the pronouncement of judgment on its merit. In that view of the matter, merely by himself contending that the valuation exceeds rupees 10 lakh, he cannot alter the valuation made and accepted by the plaintiff and by the trial court, comma, at his own choice. If at all the present appellant has preferred another appeal against the impugned judgment passed in OS number 233/2003, the same would be according to the valuation made by the plaintiff therein in the said suit. If the appellant in the alleged connected RFA, number yaudri RFA idu?
RFA number 156 and
ನಾನು ಕೇಳ್ತಾ ಇರೋದು RFA filed against the judgment in OS 233/2003. 1256 of 2019. ಎಂತವನ್ರಿ? 19 has challenged the common judgment. However, the same is confined into the judgment in OS 233/2003. If at all, next line, the appellant therein, who according to the present appellant is then the present appellant themselves, comma, intend to try the present appeal along with the said RFA 1256/2019, then they may have to obtain a necessary order in the RFA 1256/2019 to that effect. Thus, when admittedly the share of the plaintiff in OS 91/2003 did not exceed rupees 10 lakh, the present RFA 1255/2019 is not maintainable before this court, and the appellant have to approach the appropriate court with the said observation, reserving liberty to the appellant to present the papers before the appropriate court within 3 weeks from today. The appeal stands returned to the appellant. However, the registry to retain a copy of the same for the purposes of the record. ಲಾಸ್ಟಿನಲ್ಲಿ ನಾನು ಏನು ಹೇಳಿದ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಅದು ಕರೆಕ್ಟ್, ಅದು ಇಂಪಾರ್ಟೆಂಟ್. ಅದು ನೀವು ವಕೀಲರು ನೀವು ತಿಳ್ಕೊಂಡಿರ್ಬೇಕು, ನೀವು ಹೇಳಬೇಕು ಕೋರ್ಟಿಗೆ. ಏನೋ ಅರ್ಧಂಬರ್ಧ ಏನೋ ನೋಡ್ತೀರಿ, ಏನೋ ಮಾಡ್ತೀರಿ, ವಕಾಲತ್ ಬಂದ್ಬಿಟ್ಟಿದೆ ಬಿಡಬಾರ್ದು ಹೋ ಅಂತೀರಿ. ಸಿಸ್ಟಮೆಟಿಕ್ ಆಗಿ ಕರೆಕ್ಟ್ ಆಗಿ ಏನಿದೆ ಪ್ರೊಸೀಜರ್ ಬರ್ತದೆ. ಆ ಮ್ಯಾಟರ್ ಇಲ್ಲೇ ಬರ್ತದೆ, ಡಿವಿಷನ್ ಬೆಂಚ್ಗೆ ಬರುತ್ತೆ, ಕನೆಕ್ಟೆಡ್ ಅಂತಲೇ ಆಗುತ್ತೆ, ಒಟ್ಟಿಗೆ ಡಿಸ್ಪೋಸ್ ಆಗುತ್ತೆ. ಆದ್ರೆ ಅದಕ್ಕೊಂದು ಟೆಕ್ನಿಕಲ್ ವೇ ಇದೆ. ಇಲ್ಲೇ ಹೋದ್ರೆ ನಾಳೆ ಅದರ್ ಸೈಡ್ ಬಂದವರು ಎಲ್ಲಾಗಲಿವರೆಗೂ ಸುಮ್ಮನೆ ಇದ್ದು ನಾಳೆ ಅವರಿಗೆ ಎಗೇನೆಸ್ಟ್ ಆಗ್ತದೆ ಅಂತ ಆದಾಗ ಅಥವಾ ಆದ್ರ ಮೇಲೆ ಈ ಟೆಕ್ನಿಕಲ್ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡ್ತಾರೆ. ಅಟ್ ದಿ ಇನ್ಸೆಪ್ಷನ್ ಇಟ್ ಸೆಲ್ಫ್ ದಿ ವೆರಿ ಎಂಟರ್ಟೈನ್ಮೆಂಟ್ ಆಫ್ ದ ಅಪೀಲ್ ಇಟ್ ಸೆಲ್ಫ್ ವಾಸ್ ಇಲ್ಲೀಗಲ್. ಅವಾಗ ನೀವು ಮತ್ತೆ ನಿಮ್ಮ ವಕೀಲರಿಗೆ ಹೇಳ್ಬೇಕಲ್ಲ, ಇನ್ಸ್ಟ್ರಕ್ಟಿಂಗ್ ಕೌನ್ಸಿಲ್ಗೆ ಇನ್ನೊಂದು 50,000 ರೂಪಾಯಿ ಫೀಸ್ ಕಳ್ಸಿ ಹೇಳೋದು ಅಂತ. ಆ ಪೂರ್ ಲಿಟಿಗೇಂಟ್ಗಳು ಏನು ಜಮೀನಿರಲ್ಲ ಎಲ್ಲೋ ಕೂಲಿ ಮಾಡ್ತಿರ್ತಾರೆ, ಹೆಂಡತಿ ತಾಳಿ ಒತ್ತೈಟ್ ಫೀಸ್ ಕಳಿಸ್ಬೇಕು. ಇದೇನ್ರಿ ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡೋದು?
I have filed the invoice, my lord, please.